Total 9. In mentioning from video.
My lord, serial number 20, my lords, respondent has died. So petitioner has gone to Chennai to ascertain the death of the respondent and also to produce some of the documents, if any.
There is an office note also beneath that saying, make the mention of the matter reaches. So we'll look into the document once.
I'll do that, please.
Memo from the left side. It's next week. Next week. Kati helಬೇಕು. ಯಾರಿಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಲಿಕ್ಕೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು? Respondent ಗೆ. Objection to what? Application was for what? Permission to deposit. Confirmation of conviction. You have to do.
Sentence of
Sentence for what?
138. I filed an application for extension of interim order. I was supposed to.
ಎರಡು ಅದೇನಾ?
ಇಲ್ಲ.
ಎರಡು 138 ತಗೊಳ್ಳಿ.
I filed application seeking extension of time. I was supposed to deposit amount within 2 weeks. They expelled. Interim order expelled.
So complaint have to give some amount to the.
Repeat it, please. ಆದರೂ ಸ್ವಲ್ಪ ಜಾಗ ಬಿಡಿ.
Kindly, my lord, the interim order expires tomorrow.
ಗೊತ್ತಿಲ್ಲ. Yes, that will matter come on Monday. Yes.
Correspondent, my lordship, since a long time the bill amount is pending. The complaint have to pay the amount to the respondent. The respondent is facing so many difficulty financially. So that is the matter is urgency.
No, what do you expect by this court to do for your difficulty?
Because bill is pending, Your Honor. Since long time bill is pending. Complaint have to give respondent have.
Whom you appear for?
Respondent.
Respondent.
Yeah.
What the matter is about? What is the alleged offense? Yes. Go through that and find it out and make submission.
Section 138 ಅಲ್ಲಿ my lord, the petitioner, my lord, he has filed it, my lord, challenging the order of the appellate court, remanding the matter to the trial court, my lord.
You are the complainant.
I'm the complainant.
What is the urgency?
My lord, the trial court is, my lord, now starting the trial, my lord. It is not.
When did you file the petition?
Pardon?
When did you file the petition?
1 month back. It was coming for objection complaints.
Friday.
Lord, I have called for permission to withdraw the money deposit.
Permission to?
Appellant for respondent. Appellant has deposited money before the lower court. I have sought for permission.
Have you served copy of application to the other side? Yes, next.
Now, one matter for hearing, 138 proceedings, 2008 loan token and
Is it final hearing?
file hearing,
Matter is of which year?
2019, once date,
2019.
please. Monday, once matter of court of local, but not settled by the complaint.
2019 would come a little bit later.
Please.
I am taking up from 2009. It will take some time. You can move the matter week after next. Yes.
15/3/2022. Suspended subject to circumstances. He could not able to pay the amount. He is ready with the amount. I have filed application seeking for extension.
Yes.
Sentence was suspended or subject to condition, my lord. So he has to deposit 50% of fine amount. He could not pay the said amount. I have filed application for extension of time for deposit.
It's mentionings, if any. Yes. More thing. Whom you appear for? At the request of the learned counsel for the petitioner, a week's time is spread is granted as final. Next week.
Lordship, serial number 57.
Yes,
Hearing for the petitioner.
yes.
I pray for 2 weeks, Your Lordship.
Fifty-seven.
Yes, Your Lordship.
Counsel for the petitioner physically present and prays for 2 weeks accommodation. So, the 1/22 is pending for an interim order since the petitioner himself is not evincing urgency in the matter. List this matter after 3 weeks. Any earlier posting would be only after bringing to the notice of the court about today's observation made in the matter. Yes, call the
Serial number 11, pray for 2 weeks time to comply.
make the mention the matter which is yes.
First time, serial number 1, Girish and
For the petitioner has filed no seeking dismissal of this revision petition as not trust. Any of the memo supporting submission. Petition stands dismissed as not trust. Yes.
serial number 2, Girish V. Baldare.
Pray for the petitioner, my lord. The objection is IA for condemnation and delay is not precedent. And for the petitioner.
You are not pressing.
I am not present. Bill is in time, my lord. Petition is in time.
Counsel for the petitioner who is physically present submits that he would not press IA. What's that IA number?
IA number 1, my lord. For seeking condemnation of delay.
I do not know. You should tell me the IA number.
IA number 1, my lord.
One ಏನ್ರಿ 3 IA 3 of 20. ಏನೋ ಒಂದು ಹೇಳಿಬಿಡೋದು ಅಲ್ವೇ
Condemnation of delay.
Bar 22. In view of the sets up in view of the above submission, IA 3/2022 stands. Post off has not pressed. Yes.
Next week, any date, my lord.
No. Get it listed in the registry. Yes.
Serial number 3, Balakrishna, MR.
3451 week. Yes.
Serial number 6, second time, Rakesh Kishore.
My lord, serial number 5, it's on maintainability. I'm appearing for petitioner in this matter. I seek to withdraw with liberty, my lord. Criminal appeal file ಆಗಬೇಕಾಗಿತ್ತು due to bona fide error. This objection is on maintainability. I appear on behalf of Mr. Nitin Ramesh. See to withdraw with liberty to file criminal appeal minutes.
In this matter, the office has raised an objection at the stage of scrutiny. The maintainability of the revision petition against the impugned order. Now, the learned counsel for the petitioner has filed a memo seeking withdrawal of this petition with the liberty to file criminal appeal. In view of the memo supporting submission, the criminal revision petition stands disposed of as withdrawn, with, however, with the liberty to file criminal appeal to the petitioner if he is advised so, within a period of 2 weeks from today. Yes.
Registry may be directed to documents minutes.
No mentioning in that.
I
Yes.
have mentioned minutes in the memo.
The original documents produced, if any, be returned to the petition. However, after retaining copies thereof. Yes.
Non-compliance, second time, serial number 6, Rakesh P. Bhatt.
Pray for 1 week time.
6, 7, 8. Finally, 1.
Serial number 9.
Lord, the office has raised objection regarding the alternative prayer. But in fact, before the appellate court, one of the grounds is the proper opportunity for leading the defense evidence has not been given. So since that may be considered, that was the point ground before the honorable appellate court also. Therefore, the same ground has been made before this honorable court along with the many other grounds. And therefore, the alternative prayer has been made.
For the submission of Mirror Counsel for the petitioner, the office subsection over. Yes.
Matter is urgent, Mara. Monday.
They will list it, get it and listed anytime
Sir.
you want. Yes.
Serial number 10, Parameshwarappa MV. Second time.
And 11 finally 1 week. Yes.
Serial number 12, third time.
Serial number 11. Serial number 11. 2 weeks time may be granted, my lord.
Finally 1 week. Yes.
Non-compliance, third time, 12, Gayasuddin Khan.
Then appear either physically or through video conference. As a last chance, 3 days time is granted to complete office subjection in court. If the office subjections are not complied with within the set time, registry to list this matter on 66.
Serial number 13, Hemant Kumar SR.
Kindly 3 days, granted, my lord.
Same.
3 days, my lord.
Yes.
Much of
3 days really. Counsel for the petition present and request ಮಾಡಿ ನನ್ನ appear as
Appear for the
4 days ಮಾಡಿ 66. Yes.
appear for the petitioner. One week time to complete the subsection. Only certified copy of the produced matter. Complete 1 week matter.
Same order, last chance, 4 days, 16-6.
Fourth time, serial number 15, Chetan Kumar K.
Muralo last chance. Right. When appear for the petitioner, either physically or through video conference. Reasons are forthcoming from the counsel for the petition. A perusal of the order sheet will go to show that petition of the year 2020, in spite of granting several and sufficient opportunities of not less than 4 times, the petitioner has not complied the office objections. On one occasion, even by imposing the cost of ₹500 also, time was granted. However, the petitioner neither paid the cost nor complied the office objection. Hence, it can be inferred that the petitioner is not interested to prosecute the matter as well as to comply office objections. As such, the petition stands dismissed for non-compliance of office objection as well as for non-prosecution. Yes.
Serial number 16, Srihari AV.
We have applied all the objections. Only objection is objection number 4, production of certified copy of the honorable trial court's order, my lords. We have applied for that. 4 days time may be granted, my lords. We will produce the certified copy of the trial court's order, my lords. Only objection is
At the request of the learned counsel for the petitioner, though 4 days time as paid may be granted. However, the cost accordingly imposing the cost of ₹500 payable by the petitioner to the Legal Services Committee of this court within 2 days from today and filing a complaint memo along with receipt as a final last opportunity. 4 days time is granted to comply the remaining office objections. In case the office objections are not complied with, it is just free to just this matter on 16-6. Yes.
Serial number
such
7,
applied.
regular Arvind.
Grant 1 week time. Kindly grant 1 week time. Next week.
Final last chance ಮಾಡಿ 1000 rupee cost payable to the legal services committee. 2 days filing ಅದೆಲ್ಲದನ್ನು ಹಾಕಿ 4 days ಬದಲು 1 week ಅಂತ ಮಾಡಿ list the matter on 17-6. Yes.
18, Dinesh Rao N.
For petitioner, my lords, kindly finally 3 days time may be granted. I will complete the office objection. 3 days time may be granted. I'll complete the office objections finally, my lords.
Why did you move the matter?
Just is there, my lords, for maintenance and residential orders.
You should have completed the office objection.
Last
and
third
moved the
time
matter.
ಬಂದಾಗ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ 500 rupees ಪೇ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಕ್ಲಾಸ್ ಬರ್ದಿಲ್ಲ ಅಂತ ಅದೊಂದು
ಏನೇ ಆಗ್ಲಿ, there is some office objection. Without ensuring that there are no office objection or ensuring that all office objections are complied with, you have moved the matter and taken out the opportunity for another matter to appear in your place. And there are more than 3 office objections.
Finally.
Not just one.
Finally, my lords, I'll complete the office.
At the request of the learned counsel for the petitioner, though 4 days time has prayed be granted to comply office objection. However, considering the fact that without complying the office objections, the petitioner has moved a amount, got the matter listed, and thus has deprived another eligible matter from appearing before the court in its place, comma. I am of the view that by imposing a granting of time would be only on cost. Accordingly, imposing a cost of ₹500 payable to LSC 2 days, filing a memo report as a final last opportunity. 4 days time as spread is granted. Is the matter 16-6. Yes.
Fifth time, non-compliance. Serial number 19, MS Chandrasekhar Babu.
Number 15 is similar order ಮಾಡಿ not present for cost to 1000 rupees ಮಾಡಿ opportunity not less than 5 times. Yes.
First matter, bill number 20, V. Lakshmikant Rao, MP Vishwanath for respondent.
Let's appear for the petitioner Millets in this case. Let's the respondent has died according to counsel for respondent. He made a submission. Let's the petitioner has gone to his native place to ascertain and to get some of the documents. Lordships may kindly give me 2 weeks time so that I'll produce the documents, death certificate with me.
All are alive in your petition.
Yes, so far as the connected revision is concerned, I am the petitioner, accused, and the respondent, of course, is also present.
For the appellant in criminal appeal 27 of 2015 is appearing through video conference and reiterating the previously made submission that the respondent is reported to be dead and he requires them to ascertain the alleged fact of death and the other details of unnecessary details. Once again, praise for time. The perusal of the order sheet would go to show that in this matter of the year 2008, in this matter where the criminal cases of the year 2008, several and sufficient opportunities have already been granted to the appellant to ensure the alleged death of the respondent and to do needful in the matter. In spite of the same, the petitioner has not done, has not taken necessary steps. In that regard, a detailed order was passed on 6/6/2022, on which day, in fact, the learned counsel for the appellant had remained absent. Therefore, granting of the time, which will not be more than a week from today, would be only imposing a cost. Accordingly, imposing a cost of ₹2,000 payable by the petition appellant to the Legal Services Committee of this court, etc., within 2 days and filing a memo to that effect as a final last opportunity. 1 week time is granted to needful in the matter.
My lord, 2 weeks fellows, because he has to go to Chennai and obtain the documents. Chennai and Coimbatore, 2 weeks.
1 week final last with a cost of ₹1,000. Learned counsel for the petitioner in the connected matter is fiscally present. Yes.
Bill number 21, A. John Bosco, Samuel S. Danning, K.L. Srinivasa for respondent.
Two thousand previous matter. Cost 2,000.
1,000. ಸರಿ ಕಳಿಸ್ಕೊಳ್ಬೇಕು ಏನೇನು ಮಾಡಬಹುದು. and appear in the matter either physically or through video conference. The previous occasion, the Grand Counsel for the revision petitioner had filed a memo of retirement. However, on a reasoned order, the said memo came to be rejected. As such, though he was required to continue to appear for the petitioner, however, he has not appeared in order to avoid in further delay in this matter, in the criminal cases of the year. Two 2009. One of the that an amicus period be appointed for. Punimshiri, Dudu Kusri, KH Manjunath Swami.
KH Manjunath Swami. Samuel.
NOC Pudi, NOC Vokal. Because class degree. At the final last opportunity, a day's accommodation is granted for both sides to appear and proceed for both sides to proceed further in this matter, failing which the court may proceed further. This matter was appropriate order, including appointing an amicus curiae for the absentee party, oblique parties, as it finds necessary. Cannot be ignored of the fact that the present petition has arisen from a criminal case of the year 2009. Is the matter on 13/6. Yes.
Still number 22, MB Chandrachud, Archana KM, amicus curiae, Sampath Mahapat, correspondent.
His objection is the copy is not served on the other side. Sent by RBID, it was returned. I served my counsel right now. I have received. Copies received.
Copy of what?
Copy of the IA number 1 of 2022.
You have put real. Pay to the amicus curiae 1,500.
Please. Great.
The previous counsel for the petitioner, who is also applicant in IA 1/22. The amicus curiae and the counsel for the respondents are physically present. Copy subjection on IA 1/22 stands to since the copies of IA has been served to other side. Next line, heard both side on IA 1/22. Considering the reason shown in the affidavit accompanying IA 1/22, which is filed under section 482 of CRPC. Though I am of the view that IA this is to be allowed, however, considering the fact of the effort and labor put forth by the learned amicus curiae in the matter, her services also must be honored. Accordingly, imposing an honorarium of rupees 1,500 payable by the applicant to the learned amicus curiae. IA 1/22 is allowed and order dated 23 is allowed, and the learned amicus curiae is permitted to retire from appearing for the petitioner in this matter. Consequently, the learned original counsel for the petitioner is permitted to continue to appear for the petitioner in this matter. Next line, the learned amicus curiae acknowledges the receipt of honor. Is the matter in the week of yes.
Case number 23, A. Vijay Kumar Bhatt.
Taking the surety, my lord. Interim order was granted on 28/2/2019. Furnishing time granted for me to furnishing the surety for 4 weeks from 28.
There are office objection on the
Compliant.
you have to comply office objection.
Yes, please.
Yes. The learned counsel for the petitioner physically
3 days time.
and prays for a short accommodation to comply office objection. In view of the fact that despite there being office objection on IA 1/22, he has moved a memo and got the matter listed, thus depriving another eligible matter from appearing in his place. The time has prayed is granted, however, imposing a cost of ₹500 payable by the petitioner, public applicant, to the legal services committee of this court within 2 days from today and filing. Memo given, the receipt, etc., etc. 4 days time as spread is granted to comply office objection on the matter on 15/6. Yes.
15, 16, 16.
16. Adina. Yes.
Case number 24. Case number 24, Nehru P.
ಯಾರಿಗೆ?
Correspondent. Yes, for objection for delay application.
ಬೇರೆ ಬೇರೆ ಇದಲ್ಲ. File wakalat here. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿರ್ತೇನೆ ತಗೊಂಡು ಬ್ಯಾಟ್ರೀಸ್ ಪಾಸ್ವರ್ಡ್.
Number 25, Murali Babu.
Responding to this case, give us some time in this case. The reason is this, not we are paid. Balance is only 70,000 is balance. The last hearing date also I paid that 1 lakh DD.
1 minute.
Shipment ಕೊಡಬೇಕು 2 days time. Respondent.
The counsel from both sides present in place for 2 weeks time. The time has paid is granted.
First week ಅಲ್ಲ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ ಕಾವಲ ಸೆಟಲ್ಮೆಂಟ್ ಅಮೌಂಟ್ ಇದೆ ಮೇಜರ್ ಅಮೌಂಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ 70,000 ಕೊಡ್ಬೇಕು
2 ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ.
Case number 26, Shankar M. Nayak. Commissioner of Police, Bangalore.
Respondent number 2. Respondent, sole respondent. Babu Rao.
Babu Rao.
Mudubi.
Mudubi. Babu Rao, Mudubi.
None appear in this matter. Physically or video conference. According to police report, the notice has been served to the wife of the respondent. Hence, it is taken that hence the service upon. Since the notice is served upon the family member of respondent, the service is held sufficient. Respondent called out has remained absent. Send reminder to send it is here. Yes.
Number 27, Ravi Kumar MB.
This has raised objections. I am filing memo, my lord. Motion from revision to appeal.
You want a mere conversion. You don't want to withdraw this and file fresh.
Delay will make cause. Delay may come.
Please.
Delay. There will be delay if I file fresh. Judgment was passed on 8th April 2022, my lord.
In filing this revision petition, there is no delay. Is there any delay in filing this revision petition?
There is no delay, my lord.
There is no delay. The registry has raised an objection about the maintainability of this revision petition. The counsel for the petitioner, who is physically present today, files a memo seeking conversion of this revision petition into a criminal appeal. Or his submissions. The conversion of sought for is permitted. The registry is directed to accord the directed to convert this revision, accord the permission to convert this revision petition into criminal appeal. However, subject to further scrutiny to be made, if any, by the registry on the. Yes.
Hearing on interlocutor application. Serial number 28. Case Hardy Money, K.M. Archana amicus curiae.
For the petitioner M. Shishidhar filed a memo of appearance in this case. Earlier, the petitioner was on bail, and subsequently his counsel was expired, and his counsel was not appeared before this court on that which NBW was issued and executed. Is in custody.
Who is Mr. Shashidhara?
I am Shashidhar.
How your application is maintainable when an amicus curiae is there for the petitioner? Unless you seek the retirement of the amicus curiae,
yes,
you have no locus standi to move any application or any memo of appearance.
Application.
Who has given you instruction to appear in this matter?
Wife of the petitioner.
Where you have stated in the memo of appearance that are based upon the instruction given by the wife of the alleged deceased petitioner, you are appearing.
Regarding the
According to the petitioner is dead, right?
petitioner counsel, earlier counsel was
Earlier
dead due to
counsel
COVID-19. Counsel, earlier counsel.
Counsel dead.
Counsel
Petitioner
dead.
is alive.
Petitioner is alive. Therefore,
You have to then seek the permission of this court to request the amicus curiae to retire in this matter.
tomorrow it may be dated. I will file in the meantime.
For that purpose, amicus curiae cannot come again.
Today itself.
I will pass out the matter, come up with the necessary application right now. In the morning session itself, we come.
2:30.
No.
I have another matter. Other matters it is in the meantime it is very difficult. 2:30. Otherwise,
2:30, yes. Learned amicus curiae for the petitioner present, learned counsel for the applicant, and learned HCGP for respondent are also physically present. Learned counsel for the applicant, stating that he would file a necessary application seeking permission to appear for the petitioner after seeking permission to appear for the petitioner and also the retirement of the learned amicus curiae. Praise for passover of the matter. Call at 2:30 p.m. as prayed.
Number 29, Shivram SCG for respondent.
Of the petitioner's counsel. Is posted concerning IA 2 of 2022. 26/5/2022. Matter was posted before this honorable court.
One moment. Yes, please.
My Lord, as per the submission that was made before this honorable court on 26/5/2022.
Yes.
My Lord, the legible copies have been procured. And my Lord, that have been placed along with a memo on 6th of June 2022. Now, in view of the matter,
Probably you may attract the wrath of this court.
I'll make my submission, my humble submission now is.
Not just 3 or 4 pages, several pages. The xerox is incomplete. Several lines have been cut.
For that, my Lord, I have applied for the order, separate certified copy of the charge sheet that I'll get it. What I would request is, my Lord, in the view of the fact that I'll be able to produce those documents, my Lord, I'll not press this IA for the time being. I may be permitted, my Lord, to place those documents on record afresh, so that, my Lord, the office objection could be complied as regarding the illegible copies are concerned.
The counsel for the petitioner is physically present and prays for some more time to comply office objection. Office objection. He further submits that for the time being, he would not press IA 2/2022. In view of the above, the IA 2/2022 stands disposed of as not pressed. A week's time as prayed is granted. Yes.
Not it. Admission matter, seal number 30, CH Kumar, Archana came, amicus curiae for respondent. Number 30, CH Kumar.
None appear for the petitioner as a physically or through video conference. No reasons are forthcoming for non-appearance of learned counsel for the petition. The amicus curiae for the respondent alone is physically present. In view of the detailed observation made on 1/6/2022, and also considering the fact that the criminal case from which this revision petition has arisen is of the year 2007, but the learned counsel for the petitioner has remained absent and not evincing interest in proceeding further with the matter. An amicus curiae for the petitioner is also now being appointed. Accordingly, learned counsel ಯಾರಿದ್ದಾರೆ ಹಾಲ್ಶೆಟ್ಟಿ ಜಾವೀದು ಅವರು ಇವರು ತುಂಬಿಗೆ ಯಾರಾದರೂ ಇದ್ದಾರೆ. Accordingly, learned counsel Sri S. Javed is appointed as amicus curiae for the petitioner. Format the Haki takes notice to register to furnish him with copies, deposition, etc., etc., etc. within a week from today. List this matter on. ಅವ್ರದ್ದು ಯಾವ ಕೊಟ್ಟಿದ್ದೇವೆ ಮ್ಯಾಟ್ರು 16 ಕೊಟ್ಟಿದ್ದೇವ ನಿನ್ನೆ ಮೊನ್ನೆ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೇವೆ ನೋಡಿ 16th ಇದೆ ರೀ ನಿಮ್ದು ನನ್ನ ಮ್ಯಾಟ್ರು ಜಾವೇದ್ಗೂ 16th ಕೊಟ್ಟಿರ್ಬೇಕು ನೋಡಿ. Yes, 16.
Much obliged.
Number 31, Kempegoda MK, Archana came for respondent. Amicus curiae.
Previous order ಮಾಡಿ ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ previous order dated ಅದನ್ನು ಚೇಂಜ್ ಮಾಡಿ 26/5/2022 ಮಾಡಿ arising out of the CC of the year 2013 ಅಂತ ಮಾಡಿ ಅಂದ್ರೆ storage Javed for petitioner ಮುಂದಿಂದೆಲ್ಲದು ಸೇಮ್ 16/6. Yes.
Serial number 33. Serial number 32 adjourned. Serial number 33.
Serial number 32%.
Serial number 33.
I am appealing. I represent the petitioner. Complied with the order of this court. Deposited the money to the legal service committee.
Petitioner ವಕೀಲರು ಕೂಸ್ರಿ ವಿನಯ್ ಕುಮಾರ್.
Yes, Kulkarni, we are Vinay Kumar.
I represent.
Rajana correspondent.
ವಿನಯ್ ಕುಮಾರ್. ನಮ್ಮ ವಿನಯ್ ಕುಮಾರ್.
Yeah, Vinay Kumar.
I am. Yes.
What is your submission?
But I've complied with the cost minutes. I've complied with the cost and I've remitted.
When?
The cost minutes. But I've complied.
When did you remit?
Remitted on 6th minutes. 6th I've remitted the cost minutes and on the same day I filed my Vakalata statements.
You have filed your no objection Vakalat in all the matters?
In all the 4 matters I filed.
All the 4 matters.
All the 4 matters I filed.
Learned Consul Sri V.R. Vinay Kumar and Learned Consul for the respondent are physically present. The Consul for the petitioner Sri V.R. Vinay Kumar and Learned Consul for the respondent are physically present. The Consul for the petitioner submits that he has paid the cost, though with some delay. That is, it delayed payment of the cost is accepted. Is the matter in the week after next. Yes.
34, Prasad BS.
After next. That's great. Yes.
34, Prasad BS. Girish SHD correspondent.
Yes, I represent the respondent in this case. Lord, I apologize for having unrepresented last occasion, my lord. The reason is that, my lord, I did not receive the message that the matter was having been listed.
Audio is very poor.
My colleague friend, Mr. Prasad, I'm sorry, my lord.
Audio is very poor.
Am I audible, my lord?
Yes.
Lord, I request for a 2 weeks accommodation for this reason. First of all, I apologize for having remained unrepresented last occasion, my lord. I did not receive the text that the matter was listed. I was not aware of it. In fact, my friend Mr. Prasad told me yesterday that the matter was listed today. But I did not have this trial court records placement. I request, my lord, 2 weeks accommodation. I'll get it from my counterfraud from the trial court, my lord. Except the appeal memo, I do not have any papers of the trial court case.
Learned Counsel for the petitioner is physically present. Learned Counsel for the respondent appearing through video conference. Place for 2 weeks accommodation. Linking to his notice, the observation made on 31/5/2022, as a last opportunity. Once again, as a final last opportunity. 2 weeks time as credit is granted. List the matter immediately there. Yes.
35, PP Hegde, Associates, Venkat Somareddy, Arun KS for respondent.
I appear for the respondent in this case, your lordships. Last date of hearing, the respondent petitioner counsel has submitted that they have not deposited the 50% amount as directed by this honorable court. Earlier, your lordship, order was passed wherein suspension of sentence was allowed subject to deposit of the amount. They have not paid the amount. Subsequently, they have applied for extension of time, your lordship. Even that was allowed, and 3 weeks time was granted to deposit the amount. Subsequently, they have submitted that they have deposited the amount, but they want to produce a receipt. For that, they have taken 2 or 3 hearings days, your lordship. And then they have submitted that they have not deposited the amount. And the IA for suspension stands vacated on the last date of hearing.
Then what more you require? To proceed in executing the order.
In the lordship. Meanwhile, the case may be disposed of the lordship.
So you are not interested in securing an NBW against him.
Indeed, we are. We have
But the
intimated.
magistrate did not give you. He said, High Court ಅಲ್ಲಿ ಇದೆ ಹೋಗ್ರಿ ಅಲ್ಲಿಂದ ಏನೋ ಬರ್ಸ್ಕಲ್ರಿ.
ಇಲ್ಲ ಸರ್, matter ಏನಾಗಿದೆ?
ಆತರ ಆಗ್ಲಿಲ್ಲ. So you were given liberty to enforce the judgment of conviction, right?
Indeed,
Despite that, you did not enforce it.
we have intimated to the council appearing in trial for the lordship. It is not in Bangalore, so we have intimated them.
Counsel for the petitioner neither present physically nor through video conference. Counsel for the respondent alone present. Hence the matter could not be proceeded. Yes.
36 Venkat Reddy R. K. Ariga for respondent.
For the respondent.
Sir, for the announcement.
Who is for respondent?
For the respondent, my lord. I appear for the respondent. Respondent wife, my.
The petitioner is the serving the Indian Army, and when he was, I just want to highlight to when he was in line of control, the notice was served, Your Lordship, and it was served, and he couldn't contest the matter. Petition which was filed on retaliation to the divorce petition filed by the petitioner on 23/2/3/17.
Because of the microphone, please.
2/3/7, the petitioner had filed it when he came to know about the illicit affair of the respondent. He filed a divorce petition before the family court on 2/3/2017. In retaliation to this, she is filed the criminal Miss 92/17 on 28/10/2017. And this, when after filing this, the notice was served, and the notice, the petitioner was in the line of control. At that time, the notice was served, and he didn't receive the notice. The notice was served in the office, and he was placed ex parte before the learned magistrate. And he couldn't contest the matter. Hence, the respondent had filed the appeal before the session court, and there the petitioner had contested the matter, but he didn't. The learned session judge erred not looking into the ex parte order, and also without considering the appellant has ordered exorbitant money in earning. He is earning only 43,000, and the salary certificate is also produced, Your Lordship. Without considering anything, instead of remanding back the he's enhanced the amount from 6,000 to 16,000. Your Lordship. The petitioner here, the respondent has concealed that she's earning, she's working, and also she's having a whole house, and also getting rent out of it. Everything I've produced the documents, Your Lordship.
Are you on the main merit now? Make submission.
No, I didn't have an opportunity to examine the respondent. Instead of remanding back the learn session as head, enhancing the
why did you move the matter and get it listed today, Mr. Counsel for respondent?
Yes, my lord. Yes, I moved the matter because, my lord, the earlier, my lord, the matter was before this honorable court. Then, my lord, the petitioner hearing, they made a submission before this honorable court to go for mediation. We went for the mediation. Mediation could not, it failed. My lord. That's the reason we moved the matter. Now, my lord, my submission is only this. Revision is not maintained. Yes, because I am relying on the judgment of Honorable Supreme Court, 2014. Against the order under section 29 of Domestic Violence Act. Revision is not maintained.
Without hearing me, without giving an opportunity.
Present and counsel for the respondent is appearing through the conference. That counsel for the respondent submits that reading of the judgment of Honorable Apex Court in Yavadu, which is that judgment you are relying upon?
2014, my lord. AIR.
Yes.
2014 5709, my lord. Had not be, my lord. 5709. If I'm not wrong, my lord, I have also produced the citations before this honorable court. If it is not available, I will furnish one more copy, my lord. I have produced the citation on 7/3/22, my lord. 7/3/22.
Submits that.
Project one humble submission. One humble submission. Even I am relying on this.
Is this?
Criminal division number 521 before the Madhya Pradesh. Abhishek Pandey versus Ramji Pandey and others. State of
Which year?
2021 year.
Has it mentioned anything about the Supreme Court
Yes.
judgment of 2014? Submits that. Of the judgment of Honorable Apex Court reported in AIR 2014 SC 5709. The revision petition is not maintainable against the included order passed under section 29 of the PB Act, expanded version. However, the registry has failed to notice the same in the scrutiny. The learned counsel for the petitioner submits that she too have got a case law in her support regarding the maintainability of the matter. In view of the above, learned counsel from both sides are at liberty to make their submission. In view of the above, the registry to re-scrutiny the petition regarding its maintainability and make its submission. Learned counsel from both sides are at liberty to make their submission, if any, regarding the maintainability before the learned registrar judicial. On 14/6/2022 at 2:30 p.m. Yes.
Please, ma'am.
Still number 37, Rajalakshmi Ankalagi, Dhanlakshmi Kere.
The petitioner in this case, madam. In this case, the petitioner has been arraigned as accused. Offense is 138. The amount involved is 3,60,000, 3,90,000, and he has been sentenced to pay 5,90,000.
For the submission of the counsel for the petitioner who is physically present. After filing of his petition, it appears that the petitioner has taken a several months to comply the office objection. It is only now. Yes. Move the matter and got it listed. Yes, he had no urgency in the matter. No, hence issue emergent notice to the.
My lord, may I please, my lord, because the previous council did not comply, I have filed NOC wakalat, my lord.
Issue emergent notice. Petition as well as on a year 2 of 2021. Record number by 21/6. The process and copies, if you need, to be furnished in the registry by the petitioner during the course of the day. Yes.
Still number 38, Ahmedullah Kotwal.
Yes, please.
My lord, I filed this petition seeking to set aside the interim order passed by the Honorable Lower Appellate Court. My lord, the check amount involved is 1,98,000, and the order has been passed to pay 1,98,000 along with 2,03,000 as fine and compensation, and it has also been directed to pay 5,000, which shall be remitted to the state. My lord, I have my only ground in this case is that I have not issued the check to the complainant, and he is a pygmy collector and he has no capacity to pay such a huge amount to the complainant. And he have told in his contention that
of the fine amount to be deposited in the trial court within 2 weeks from today. 50,000 rupees personal bond with 2 sureties. Emergent notice, process to be paid during the course of the day. DCR, SCR. Yes.
39, Vikas M.
Appellant, my lord. Appellant is the accused, my lord. The check amount is 1,95,000 and have been sentenced to pay 1,25,000, my lord.
Less than this amount.
Yes, my lord. The case of the complainant, my lord, was he had given a hand loan of rupees 1 lakh in the year 2012 and a hand loan of rupees 95,000 in the year 2017. And when the second installment was given, he had received this check, my lord, and subsequently has produced it and it has been dishonored, my lord. Case of the accused, my lord, is that he has received a hand loan of 60,000 rupees and he has returned 70,000 rupees, all by way of account transfer, my lord. And the complainant in his cross-examination admits that yes, 70,000 have received from him, my lord. What the learned court has, trial court has done, my lord, is it has partly accepted the complainant's case, saying that yes, he has given 1,95,000. At the same time, it has also accepted the accused case, saying that yes, you have returned 65,000. So 1,95,000 minus 60, you pay 1,25,000, my lord. That is the order, my lord. Partly complainant's case is accepted, my lord, stating 1,95,000 has been given. At the same time, even accused version is also accepted, that yes, you have paid 70,000 rupees.
Same order. 50% of fine amount in trial court in 2 weeks. 40,000 rupees personal bond with a single surety.
20,000 already deposited.
After deducting.
Still number 40, Madhvacharya M.
the dispute between the two partners. Check was issued towards security of the account. 10 lakh is checked, 5 lakhs each, two checks. The amount what are invested by the complainant towards investment of the capital in the partnership firm, not for the expenses. By condition, not when the amount is towards investment of the capital, section 138 will not apply. And also, unless the rendition of the account is completed, the complainant cannot invoke section 138 of the NI Act. Because he said that much towards the expenses, the check issued towards repayment of the amount, expenses. It was issued apart from capital amount. Section 11 and 13 of the Partnership Act is very clear. We'll have deposited on the development code, trail code on 18/10/21.
% of the fine amount in the trial court within 2 weeks from today. 2 lakh rupee personal bond with 2 sureties, emergent notice, process during the course of the day, TCR, ACR.
Number 41, Murthy Mohan.
Yes, I'm for the petitioner, my lord. Offense is 138 NI Act. Alleged check amount is 5,80,000. After conviction, the award is check the amount is 5,85,000, my lord. My grounds are, my lord, the respondent has failed to prove the financial capacity. And the second ground is that she admits that the alleged check was taken for the security purpose, which she has lent 1 lakh rupees as a hand loan to the petitioner. And the petitioner has rebutted the presumption created by the respondent in her defense evidence that the amount was repaid the amount to the respondent's second son. In spite of that, the trial court's concurrent findings is that at page number 21, that a presumption is given to the asset unless the contrary is proved to the holder of the check received by the check for discharge of debt or other liability. These are findings given by the both appellate and as well as the trial court, my lord. Even there is a disturbance in the notice also that there is a delay, but that we need to look into the exhibit.
50% of the fine amount in 2 weeks in trial court. 50,000 rupees personal bond with 2 sureties. Emergent notice process during the course of the day, TCR, ACR.
Still number 42, Prakash Shetty.
For the petitioner in this matter. My lord, one matter pertaining to 138 is the, my lord, concurrent findings of the trial court as well as the first appellate court. My lord, the amount involved in the second matter is, my lord, 2,50,000. And trial court has, my lord, convicted the accused and directed him to pay the fine of rupees 2,60,000. My lord, the accused examined himself as DW1 and examined one more witness. The defense that was taken by the accused is that, my lord, yes, in respect of Aracanate plantation, my lord, wherein, my lord, after seeing the crop, they pay some advance, and if there is any variation in future, my lord, for that, in order to refund that, they take a security check. For that, my lord, for 2014 Aracanate crop, my lord, he has given security check, and he has taken 50,000 rupees, and later on, my lord, he has given the Aracanate. And that check, my lord, he has not returned back. And during the next year, my lord, he has given that Aracanate plantation to one Annappa. For that reason, my lord, he has misused that blank check and he has filled up the amount and he has presented. Both the courts, my lord, only on the one ground that, my lord, that I have not made any efforts to take back the check. Based on that, my lord.
50% of the fine amount in trial court in 2 weeks from today. 40,000 rupees personal bond with a single surety, emergent notice. Process during the course of the day, TCR, ACR.
My lord, including the amount which is deposited. Very grateful.
Number 43, J.S. Venkata Subbarao.
Matter yesterday which had come up, my lord, with same matter between the same parties. So another appeal, connected appeal is challenged. We tagged along with criminal revision petition 829 of 2022. What is my lord? Not for start for any state.
The subject matter of yesterday's petition was this very same impugned.
Very same, very same. The CMS was filed by the respondent. A certain amount, my lord, 5,000 and 3,000 was ordered. But for enhancement, my lord, she had preferred one appeal. But questioning the, my lord, grant of the amount, my lord, I had preferred the appeal. So that's how, my lord, the two appeals.
Yesterday's matter was for?
Was, my lord, the enhancement was
by husband or wife?
The appeal was by the husband. The challenge there too was the appeal preferred by, my lord, the respondent seeking enhancement. So this appeal, my lord, was preferred by me, questioning, my lord, very grant of maintenance. That's the two appeals, 5,008 and 5,009.
Challenging the grant of the maintenance, did you prefer any appeal under section 29 or 25 in the district court?
Yes.
You had.
Yes. That's the appeal now impugned.
Any date is given in the other matter?
My lords have not fixed any.
Counsel for the petition is physically present. Third submission, there is the memorandum of petition, the impugned author. Issue notice to the respondent. Petitioner to pay the necessary process and furnish copies in the registry within a week from today. As submitted to this court with the counsel for the petitioner, registry list. Which is that other matter?
Criminal RP 829 of 2022.
RP 829 of 2022, which is said to be between same parties. This is registry to list this matter along with so and so criminal revision petition, so and so, which is said to be filed between the same parties. Yes.
Great.
Also, matter, bill number 24. Corresponding to this.
2 days delay.
So and so has filed. As well, but files vocal for respondent. Magistrate scrutiny with the vocal. 10 days time to file objection if you need to. Heading IA is granted to the respondent. Yes.
For reporting settlement, still number 44, Ravichandra TC, Kemparaja for respondent.
Appointed, my lord. One 38 proceeding, my lord.
Yes, please. What is your submission?
My lord, this concurrent finding, my lord. Because only difference is that, my lord, it is a theft check, but no legal action is initiated against the respondent. And moreover, it denies, my lord.
No settlement could be arrived at between the parties. Register to proceed further. Yes. Yes.
File hearing matter, serial number 45, M. Partha, SPP for respondent.
Respondent.
Everyone.
I am representing petitioner in this case, my lord.
Proceed, please.
The petitioner is convicted for the offence punishable under section 354. (324) and 448 and 323 of IPC, my lord. Crime number is 47 of 2008. Eluvala Police Station, Mysore, my lord.
Yes.
My lord, initially the case was registered for offences punishable under section 143, 147, 448, 354, 323, 506, 114, read with 149 of the IPC, my lord. On the complaint of one Girija. Girija is PW1. Against accused number 1, this petitioner, Devraj, son of Rajay Gowda, and other 5 members, my lord. All are Belgola village, Srirangpatna Taluk.
Yes.
My lord, according to the case of the prosecution, on the complaint of Girija, the offences are 143. I already submitted before this honorable court that 506 read with 149 against 6 accused persons, my lord. After the investigation is over, the respondent police herein have filed a charge sheet against the petitioner alone for offences punishable under section 448, 354, 323, 506 IPC, my lord. There is no 149 and unlawful assembly is not there, my lord. In the charge sheet, the investigation officer has not stated about anything about accused number 2 to 6, my lord. Whether they were called or the statement was recorded, whether they were present at the time of incident, they were there or not, my lord.
What are your main points of arguments?
My main points of the argument before this honorable court.
You can elaborate those points, but you first jot down the main points. Yes. What are the main points?
Main point, my lord, the 324, the court below, both the court have convicted for offence under section 324, my lord. 324, there is no charge, there is no charge sheet, there is no FIR, my lord.
Just the There is charge.
Yes, my lord.
There is charge. Additional charge is framed.
But charge.
Additional charge is framed for 324 also.
Yes, my lord. My lord.
Your point that no charge for 324 won't sustain.
Yes, my lord. My lord, the 324, my lord, can I read, Your Honor?
No, you first tell me the main points of argument. You can elaborate. First, sir, my points of argument would be 1, 2, 3, 4, this.
Yes, my lord.
I give in detail or submit argument detail and all these 4
There
points.
is no charge.
Easy for me to follow.
Yes, there is no charge sheet or FIR for offence under section 324, my lord. Even according to the case of the prosecution, that, my lord, they have charged for 324. I don't have charge.
There is charge for 324.
I don't have additional.
Is it mandatory that the court should confine only to those offences mentioned in the charge sheet?
No, my lord.
Not necessary.
There should be an order in connection with the framing charge for offence under section 324, my lord.
They have framed.
They have framed, my lord. On what grounds they have framed the charge against the accused for offence under section 324 is required, my lord. And even according to the section 324, my lord, it is very clear. Speaking order is not there, my lord. This is the court below, my lord. I am not representing the case before.
You cannot take that plea. Once you accept wakalat, you are supposed to required to go through the entire record.
Yes, my lord.
And make submission.
Yes, my lord. And 324, voluntary causing grievous hurt by weapons, dangerous weapons. My lord, the entire case of the
Grievous hurt with a dangerous weapon.
Dangerous weapon.
1 minute. Let me refurbish my.
Voluntary causing hurt by a dangerous weapons or means.
So you said voluntarily causing grievous hurt with a dangerous weapon.
No. Dangerous weapon or means.
You said voluntarily causing grievous hurt with the dangerous weapons or means.
Grievous hurt means it is 326, my lord. There is.
Sir, you said, one sentence, Swami. Grievous hurt not necessary. Hesitation.
ತಪ್ಪಾಗಿ ಗ್ರೀವಿಯಸ್ ಅನ್ನ ಸೇರಿಸ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ಅಷ್ಟೇ ಮುಗಿದೋಯ್ತು ಕತೆ. ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್.
Voluntary causing hurt by dangerous weapons or means. Here,
1 minute. ಅವ್ರು ಹೇಳಿರ್ತೀನಿ ಅದನ್ನ ಕೇಳಿಸ್ಕೊಂಡು ನೆನಪು ಮಾಡಿ ಕೊಡ್ಬೇಕು. ಕಿವಿ ಸ್ವಲ್ಪ ಸೂಕ್ಷ್ಮ ಇಟ್ಕೊಳ್ಬೇಕು ಇಲ್ಲಿ ನಾನು ಹೇಳ್ಬೇಕಾದ್ರೆ. There is an order or reason for framing the charge under 324 and New. The trial court has in detail considered an application filed by the prosecution under section 216 CRPC, and by a recent order of not less than 4 pages, it has arrived at a conclusion that there are materials to frame charge for 324, allowing the IA it has framed.
Yes, ma'am.
So your second submission is also incorrect. ಕೋರ್ಟ್ ಅನ್ನ ಹಗುರವಾಗಿ ತಗೊಳ್ಬೇಡಿ. 324 ಅಲ್ಲಿ ಚಾರ್ಜ್ ಇಲ್ಲ ಅನ್ನೋದು, ಚಾರ್ಜ್ ಇದೆ ಅಂತ ತೋರಿಸಿದ್ರ ಮೇಲೆ ಅದಕ್ಕೆ ಆರ್ಡರ್ ಇಲ್ಲ ಅನ್ನೋದು
ಅಲ್ಲ ಚಾರ್ಜ್ FIR ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ
ಮತ್ತು ನೀವು ಹೇಳಬಾರ್ದು ಕೋರ್ಟ್ ನಲ್ಲಿ ಯುವರ್ ಪ್ರೊವೋಕಿಂಗ್ ಮೀ ಟು ಟೆಲ್ ಅಡಿಬಿದ್ರು ಮೂಗ್ ಮೇಲೆ ಅಂತ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. FIR ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿ ಅಫೆನ್ಸ್ ಮೆನ್ಷನ್ ಮಾಡ್ಲೇಬೇಕಾ ಚಾರ್ಜ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅಂತ ನಾನು ನಿಮ್ಮನ್ನು ಕೇಳಿದ್ದಕ್ಕೆ
ಸ್ವಾಮಿ ಅವ್ರು 324 ಯಾಕೆ ಚಾರ್ಜ್ ಮಾಡ್ತಿದೀನಿ ಅಂತ ಹೇಳಲಿಲ್ಲ ಕೆಳಗಡೆ ಕೋರ್ಟು ಅಂತ ಹೇಳಿದ್ರಿ. ನಾನು ಆ ಪ್ರಶ್ನೆಗೆ ಈ ಉತ್ತರ ಕೊಟ್ರಿ. ಆ ಉತ್ತರಕ್ಕೆ ನಾನು ಉತ್ತರ ಇದೆ, ಆನ್ಸರ್ ಇದೆ, ದೇರ್ ಇಸ್ ಎ ಡೀಟೇಲ್ಡ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳಿದಾಗ ಮತ್ತೆ ನೀವು ಯು ಆರ್ ಗೋಯಿಂಗ್ ಬ್ಯಾಕ್ ಟು ಸ್ಕ್ವೇರ್ ಒನ್.
Yes, my lord.
FIR ಇಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಲ್ಲ.
Yes, my lord. In the judgment, my lord, they are examined about PW 1 to 9 and exhibit P1 to P4 marked, my lord. And there is no material object seized from the accused or marked in the court. There is no MOS, my lord.
ಈಗ ನೀವು ಫಸ್ಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳಿದ್ರಿ. ನೀವು ಹೇಳಿದ 2 ಪಾಯಿಂಟ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೂಡ ಇಟ್ ವೋಂಟ್ ಸಸ್ಟೈನ್ ಅನ್ನೋದನ್ನ ಪ್ರೈಮಾ ಫೇಸಿನೇ ನೋಡಬಹುದು ಹೇಳಿದ್ರೆ ಅದೆರಡು ಬಿಡಿ. ಅದೆರಡು ಈಗ ಗ್ರೌಂಡ್ ಪಾಯಿಂಟ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮದು ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ವಾಟ್ ಈಸ್ ಯುವರ್ ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್? ಯು ಕ್ಯಾನ್ ಡೀಟೇಲ್ ಇಟ್. ಐ ಆಮ್ ನಾಟ್ ಕರ್ಟೈಲಿಂಗ್ ಯುವರ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ನೀವು ನನಗೆ ಒಂದು ಪಾಯಿಂಟ್ ಹೇಳಿದ್ರೆ ನನಗೆ ಫಾಲೋ ಅಪ್ ಮಾಡ್ಲಿಕ್ಕೆ.
Weapon is not used in the commission of offense, my lord.
Weapons are not used in the commission of
offense.
What was the weapon that was used according to prosecution or according to you?
There is no weapon used according to the case of the prosecution.
Whether to attract section 324 using of any weapon is mandatory.
Dangerous weapons or means.
Means and ide alve. Means andre does it necessarily requires any weapon?
Weapon is not necessary.
Then
object should be there, my lord.
Children. Sorry. ನೀವು ಇಲ್ಲಿ ಕೂತು ಫ್ರೇಮ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗ್ಬೇಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್. ಇಷ್ಟೊತ್ತು ವೆಪನ್ಸ್ ಅಂದ್ರೆ ವೆಪನ್ಸ್ ಇಸ್ ನಾಟ್ ಪ್ರೂವ್ಡ್, ವೆಪನ್ಸ್ ಇಸ್ ನಾಟ್ ಪ್ರೂವ್ಡ್, ವೆಪನ್ಸ್ ಇಸ್ ನಾಟ್ ಪ್ರೂವ್ಡ್. ವೆಪನ್ಸ್ ಯಾವುದು ಅಂತ ಕೇಳಿದ್ರೆ ವೆಪನ್ಸ್ ಇಲ್ಲ ಅಂತ. ಮೀನ್ಸ್ ಅಂತಿದೆ, ಫೈನ್. ಮೀನ್ಸ್ ಅಂತ ಹೇಳಿದ್ರೆ ಮೀನ್ಸ್ಗೆ ಆಬ್ಜೆಕ್ಟ್ ಬೇಕು ಅಂತ ಎಲ್ಲಿಯಾದ್ರೂ ಸೆಕ್ಷನ್ 324 ಅಲ್ಲಿ ಹೇಳಿದ್ಯಾ? ದೇರ್ ಮಸ್ಟ್ ಬಿ an object. Object idre that can be a weapon or some instrument.
Yes, my lord.
Means ಅಂತ ಹೇಳಿದ್ರೆ it may have some instrument, may not
also, man.
Allave?
Yes, my lord. I'm concealing my 324 in support of the judgment of both the courts, my lord. They are convicted for offense under section 324 IPC. There is no weapon used, even though there is a column of means. Means, I am ready to accept it also, my lord. Next, my lord.
Next point, 3 point hoytu.
Next point. My lord, the delay in filing first information report, my lord.
Yes.
Date of incident is on 14/3/2008 between 2:30 to 2:45 PM, my lord.
Yes.
14/3/2008 between 2:30 to 2:45, my lord. My lord, the complaint was information received at police station on 16/3/2008 at about 5:30 PM, my lord.
Yes.
There is a delay of filing charge FIR before the police about 2 days, my lord. Then, my lord, the PW1 in this case, my lord, other than the complaint before the police, PW1,
So one point is there is a delay in FIR.
Yes.
By at least by 2 days.
2 days.
Fine. What is your next point?
Next point is that, my lord, PW1 is turned hostile.
PW1 turned hostile.
After cross examination of the APP, she has supported the prosecution.
ಏನಿದೆ ಅದನ್ನ ತೆಗೆಯೋದು, ಫ್ಲಾಗ್ ಹಾಕೋದು, ಪಿನ್ ಮಾಡೋದು ಫಸ್ಟೇ ಮಾಡ್ಬೇಕು. ಕೇಸ್ ಕರೆದ್ರ ಮೇಲೆ ಅದನ್ನೆಲ್ಲ ಕಟ್ ಮಾಡ್ತಾ ಪಿನ್ ಮಾಡ್ತಾ ಕೂತ್ರೆ ಸರಿ ಹೋಗಲ್ಲ. ಇದಕ್ಕೆ ಹಾಗೆ ಮಾಡಿದ್ರಿ.
Can I read a deposition of PW1?
Please. Slowly.
ಚಾಸ 2 ಸಲಜಾ ನನ್ನ ಅಕ್ಕ, ಚಾಸ 3 ಉಷಾ ನನ್ನ ಅತ್ತಿಗೆ. ಆರೋಪಿ ನನಗೆ ಗೊತ್ತು, ಆತ ನಮ್ಮ ದೂರದ ಸಂಬಂಧಿ. ದಿನಾಂಕ 14/3/2008 ನಾವು ಚಾಸ 2 ಮತ್ತು 3ರವರು ಮನೆಯಲ್ಲಿದ್ದೆವು. ಮಧ್ಯಾಹ್ನ 2:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ ಹಾಗೂ ಇನ್ನೂ 3 ಜನರು ನಮ್ಮ ಮನೆಗೆ ಒಳಗೆ ನುಗ್ಗಿ ಬಂದರು. ಆರೋಪಿ ದೇವರಾಜ್ ಜೊತೆ ಬಂದವರು ಹೆಸರು ಗೊತ್ತಿಲ್ಲ, ಅವರು ಯಾವ ಊರಿನವರು ಎಂದು ಗೊತ್ತಿಲ್ಲ. ಆರೋಪಿ ನನ್ನ ಕೈ ಹಿಡಿದುಕೊಂಡು ನನ್ನನ್ನು ಮದುವೆ ಹಾಗೂ ತಾಳಿ ಕಟ್ಟುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ. ನಾನು ಆತನಿಗೆ ಇಷ್ಟ ಇಲ್ಲ ಎಂದು ಹೇಳಿದೆ. ಆರೋಪಿ ಮತ್ತು ಜೊತೆಲಿದ್ದವರು ನನ್ನ ಕೈ ಹಿಡಿದು ಎಳೆದಾಡಿದರು. ಚಾಸ 2 ಮತ್ತು 3ರವರು ನನ್ನನ್ನು ಬಿಡಿಸಲು ಬಂದಾಗ ಆರೋಪಿ ಮತ್ತು ಜೊತೆಲಿದ್ದವರು ಅವರನ್ನು ಜಾಡಿಸಿ ತಳ್ಳಿದರು. ಆ ಕಾರಣದಿಂದ ನನ್ನ ಅಕ್ಕ ಚಾಸ 2ರವರು ಕೈಗೆ ಗಾಯವಾಗಿತ್ತು. ಯಾವ ಕೈಗೆ ಎಂದು ಜ್ಞಾಪಕವಿಲ್ಲ. ನಾವು ಜೋರಾಗಿ ಕೂಗಿಕೊಂಡೆವು. ಆಗ ಚಾಸ 4 ಕೃಷ್ಣೇಗೌಡ ಹಾಗೂ ಇತರ ಜನರು ಬಂದು ಅವರನ್ನು ಕಂಡು ಆರೋಪಿ ಹಾಗೂ ಜೊತೆಯಲ್ಲಿದ್ದವರು ಓಡಿ ಹೋದರು. ಸದರಿ ದಿನ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಆರೋಪಿ ಬಾಯಿ ಮಾತಿನಲ್ಲೇ ಬೇರೆ ಏನು ಹೇಳಿರುವುದಿಲ್ಲ. ಈ ಘಟನೆಯ ಬಗ್ಗೆ ನಾನು ಪೊಲೀಸರ ಮುಂದೆ ಫಿರ್ಯಾದು ನೀಡಿರುತ್ತೇನೆ. ಈಗ ನನಗೆ ತೋರಿಸಿದ ದಾಖಲೆ ನಾನು ನೀಡಿದ ಫಿರ್ಯಾದು ಹಾಗೂ ಅದನ್ನು ಎಕ್ಸಿಬಿಟ್ ಪಿ ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಕೃತ್ಯ ನಡೆದ ದಿನವೇ ಫಿರ್ಯಾದು ನೀಡಿರುತ್ತೇನೆ. ನಾನು ಫಿರ್ಯಾದು ಕೊಟ್ಟ ನಂತರ ಪೊಲೀಸರು ಘಟನಾ ಸ್ಥಳವನ್ನು ನೋಡಲು ಬಂದಿದ್ದರು. ಆ ಸಮಯದಲ್ಲಿ ಪೊಲೀಸರು ನಮ್ಮದೇನು ಸಹಿ ಪಡೆದಿರುವುದಿಲ್ಲ. ಈಗ ತೋರಿಸಿದ ಸ್ಥಳ ಮಹಜರ್ ನನ್ನ ಸಹಿ ಇದೆ. ಇದರ ಸ್ಥಳ ಮಹಜರನ್ನು ಎಕ್ಸಿಬಿಟ್ P2 ಎಂದು ಸಾಕ್ಷಿ ಸಹಿಯನ್ನು ಎಕ್ಸಿಬಿಟ್ P2A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಸದರಿ ಸಹಿಯನ್ನು ಯಾವಾಗ ಎಲ್ಲಿ ಮಾಡಿದ್ದೇನೆ ಜ್ಞಾಪಕವಿಲ್ಲ. ವೆಂಕಟರಮಣೇಗೌಡ ಎಂದರೆ ನನ್ನ ತಾತ. ನಮ್ಮ ಮನೆಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಾನು ಪೊಲೀಸರಿಗೆ ದಾಖಲೆ ಕೊಟ್ಟ ಬಗ್ಗೆ ನನಗೆ ಜ್ಞಾಪಕವಿಲ್ಲ. ಈ ಹಂತದಲ್ಲಿ ಸಾಕ್ಷಿಯನ್ನು ಪ್ರತಿಕೂಲ ಸಾಕ್ಷಿ ಎಂದು ಪರಿಗಣಿಸಿ ಪಾರ್ಟಿ ಸವಾಲು ಮಾಡಲು ಅನುಮತಿ ಕೋರಿದ್ದು ಅನುಮತಿ ನೀಡಲಾಯಿತು.
Yes.
Lord, even according to the deposition of this PW1, my lord, she turned hostile. And further cross-examination was done by APP, Your Honor.
Yes.
ಜಗಳ ಬಿಡಿಸಲು ಬಂದಾಗ ಆರೋಪಿ ಆಕೆಯನ್ನು ಬಲಗೈ ಹಿಡಿದು ಎಳೆದಿದ್ದರಿಂದ ಆಕೆಯ ಬಲಗೈ ಉಂಗುರದ ಬೆರಳಿಗೆ ಉಗುರು ತಾಕಿ ಗಾಯವಾಗಿತ್ತು ಎಂದರೆ ಹೌದು. ಆರೋಪಿ ಸದರಿ ದಿನ ನೀನು ನನ್ನನ್ನು ಮದುವೆಯಾಗದಿದ್ದರೆ ನಿನ್ನನ್ನು ಮತ್ತು ಕುಟುಂಬದವರನ್ನು ಕೊಲೆ ಮಾಡಿದಾಗಿ ಬೆದರಿಸಿದ್ದ ಎಂದರೆ ಸರಿ. ನಾನು ಘಟನೆಯ ವಿಷಯವನ್ನು ಗ್ರಾಮಸ್ಥರಿಗೆ ತಿಳಿಸಿದ್ದೆ ಅಂದರೆ ಸರಿ. ಅವರು ನ್ಯಾಯ ಮಾಡುವುದಾಗಿ ಹೇಳಿದ್ದರು ಎಂದರೆ ಸರಿ. ಅವರು ಕೂಡ ಅವರು 2 ತಿಂಗಳಾದರೂ ನ್ಯಾಯ ಮಾಡಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಆದ ಕಾರಣ 2 ತಿಂಗಳ ನಂತರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಹೋಗಿ ಎಕ್ಸಿಬಿಟ್ P1 ರಂತೆ ದೂರು ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ. ಫಿರ್ಯಾದಿ ಕೊಟ್ಟ ದಿನ 6:30 ಸಮಯದಲ್ಲಿ ಪೊಲೀಸರು ಮನೆಗೆ ಬಂದು ಸ್ಥಳ ಪಂಚನಾಮೆ ಮಾಡಿದ್ದು ಎಕ್ಸಿಬಿಟ್ P2 ರಂತೆ ಮಾಜರ್ ಕೂಡ ಅದಕ್ಕೆ ನನ್ನ ಸಹಿ HR2 ಮತ್ತು 8/3 ಸಹಿ ಹೊಡೆದಿದ್ದಾರೆ ಎಂದರೆ ಹೌದು.
Yes.
Lord, the chief examination of PW1, it is clearly stated in the chief examination that accused number, this petitioner and 3 others came to the house. They are all belongs to the Belagola village, my lord. It is stated in the complaint also, exhibit P1, that accused number 1 and 5 others, they are all belongs to the Belagola village, but they are is not aware the names of the other 5 accused persons, my lord. And see, in the cross-examination of the public prosecutor, she has stated before the court that there was delay of filing 2 months, my lord. 2 ತಿಂಗಳು ಆದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಲಾಡ್ಜ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ. She has clearly stated, my lord. And in her statement, my lord, in the first sentence itself, she has stated that petitioner happens to be their relative. And in the cross-examination, she has stated that ಆರೋಪಿ ನಮ್ಮ ಮನೆಯಲ್ಲಿದ್ದು ಕೆಲಸ ಮಾಡುತ್ತಾ ಮನೆಯಲ್ಲೇ ಓಡಾಡಿಕೊಂಡು ಇದ್ದ ಎನ್ನುವುದು ನಿಜ. Lord, this petitioner happens to be the relative, and he was there in the house of PW1, and he is looking after ಮನೆಯಲ್ಲಿ ಓಡಾಡಿಕೊಂಡಿದ್ದು ಕೆಲಸ ಮಾಡುತ್ತಾ ಓಡಾಡಿಕೊಂಡು ಇದ್ದನು. ಮನೆ ಕೆಲಸ ಮತ್ತೆ ವ್ಯವಸಾಯ ಎಲ್ಲ ಮಾಡ್ಕೊಂಡಿದ್ದನು. ವ್ಯವಸಾಯ ಅಂತ ಇಲ್ಲ, ಅಲ್ಲಿ ಮನೆ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಇದ್ದನು ಎನ್ನುವುದು ನಿಜ. ಆರೋಪಿ ನಮ್ಮ ಮನೆಗೆ ಏಕಾಏಕಿ ಬಂದಿಲ್ಲ, ಆದರೆ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ನಾನು ಆರೋಪಿ ಜೊತೆ 4 ಜನ ಬಂದಿದ್ದರು ಎಂದು ಫಿರ್ಯಾದಿಯಲ್ಲಿ ನಮೂದನೆ ಮಾಡಿರುತ್ತೇನೆ. ಅವರು ಯಾರು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಪೊಲೀಸರು ಅವರನ್ನು ಕರೆದು ಯಾವ ವಿಚಾರಣೆ ಮಾಡಿಲ್ಲ ಹಾಗೂ ನನ್ನ ಪುನರ್ ಹೇಳಿಕೆ ಪಡೆದಿಲ್ಲ ಎನ್ನುವುದು ನಿಜ. ಆರೋಪಿ ನನ್ನ ಕೈ ಹಿಡಿದು ಎಳೆದು ಮಾನಭಂಗ ಮಾಡಲು ಪ್ರಯತ್ನ ಪಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸುಳ್ಳು. ನಾನು ಮಾನಭಂಗ ಮಾಡಿದ್ದಾರೆ ಎಂದು ಪೊಲೀಸರ ಮುಂದೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ಜೊತೆ ಬಾಲ್ಯದಿಂದಲೂ ಆಟವಾಡಿದುಕೊಂಡು ಸುಳ್ಳು ಫಿರ್ಯಾದಿ ನೀಡಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ನಮ್ಮ ತಂದೆ ತಾಯಿ ಆರೋಪಿ ಜೊತೆ ನನ್ನನ್ನು ಮದುವೆ ಮಾಡಲು ಹೇಳಿದ್ದರು ಅಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಆರೋಪಿಯನ್ನು ಮನೆಯಿಂದ ಓಡಿಸಲು ಈ ರೀತಿ ಸುಳ್ಳು ಫಿರ್ಯಾದಿ ನೀಡಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ನನ್ನ ಕೈ ಹಿಡಿದು ಎಳೆದಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ಜೊತೆ ಮಾತುಕತೆಯಾದ ನಂತರ ಕಿರಿಚಿದ್ದೇನೆ. ಆ ದಿನವೇ ಯಾವುದೇ ದುರ್ಘಟನೆ ನಡೆದಿಲ್ಲ. ಆರೋಪಿಯನ್ನು ದೂರ ಮಾಡಲು ದುರ್ದೇಶದಿಂದ ಸುಳ್ಳು ಫಿರ್ಯಾದಿ ಕೊಟ್ಟು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ ಅದೇ ದಿನ ಪೊಲೀಸರಿಗೆ ಫಿರ್ಯಾದಿ ಕೊಡಲು ತೊಂದರೆ ಇರಲಿಲ್ಲ ಎನ್ನುವುದು ನಿಜ. ಗಾಯಗಳು ನಾನು ಮನೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುವಾಗ ಆಗಿತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. my lord, even according to the evidence of PW1, it is very clear that the number of persons, my lord, number of persons is more than one, my lord. The charge sheet is filed against only one person.
How it is wrong?
Others should be examined by the police or investigation officer, why they let them out and why they are not charge sheeted against them should be mentioned in the charge sheet, my lord.
Where it is stated that it has to be mentioned in the charge sheet.
Otherwise, my lord, there
No,
is.
you show me the provision of law.
My lord,
That for not filing charge sheet against any one or more of the accused about whom a reference is made in the complaint without their identity, the IO has to necessarily mention the reason in the charge sheet for not filing charge sheet against them.
This accused was arrested, and during the time of his voluntary statement, my lord, under the provisions of 169(2), they have to summon the other accused persons, my lord.
ವಕೀಲರೇ, ಈಗ ಎರಡು ಪ್ರಶ್ನೆ.
Yes, sir.
ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿಯೂ ಕೂಡ ಆಕೆ ಉಳಿದವರು ಯಾವ ಊರ್ನವರು, ಅವ್ರು ಯಾರು ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಆದ್ರೆ ಅಕ್ಯೂಸ್ ಜೊತೆ ಬಂದಿದ್ರು ಅಂತ ಹೇಳಿದಾಳೆ. ಅವ್ರ ಐಡೆಂಟಿಟಿ ಬಗ್ಗೆ ಆಕೆ ಏನೂ ಹೇಳಲಿಲ್ಲ. ಎವಿಡೆನ್ಸ್ ನಲ್ಲೂ ಅದನ್ನೇ ಹೇಳಿದಾಳೆ.
ಬಂದಿದ್ರು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಬಂದಿದ್ರು, ಆದ್ರೆ ಅವ್ರು ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಅವ್ರ ಹೆಸರು ಇತ್ಯಾದಿ ವಿವರಗಳು ಗೊತ್ತಿಲ್ಲ.
ಸರಿ.
ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಆ ದಿನ ಹೋದವರು ಒಬ್ರು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಉಳಿದವರ ವಿರುದ್ಧ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕದೇ ಇರುವುದಕ್ಕೆ ಸಕಾರಣಗಳನ್ನು ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿಯೇ ನಮೂದಿಸಬೇಕು, ಇಲ್ಲದೆ ಹೋದ್ರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇನ್ವ್ಯಾಲಿಡ್ ಆಗುತ್ತೆ ಅನ್ನೋದನ್ನ ನೀವು ಯಾವ ಆಧಾರದ ಮೇಲೆ ಹೇಳ್ತಾ ಇದ್ದೀವಿ?
My lord, the contention is that she has stated before the doctor also, my lord, PW6.
ನೀವು ನನ್ನ ಪ್ರಶ್ನೆ ಉತ್ತರ ಕೊಡ್ತಾ ಇಲ್ಲ, ಬೇರೆ ಹೇಳ್ತಾ ಇದ್ದೀವಿ.
Sorry, if there is any suspected accused persons, they have to issue notice to them under the information of.
ಈಗ ಉಳಿದವರಿಗೆ ಮಾಡ್ಲಿ ಬಿಡ್ಲಿ, ಅದು ನಿಮ್ಮ ಅಡ್ವಾಂಟೇಜ್ ಗೆ ಹೇಗೆ ಬರುತ್ತೆ? ಉಳಿದವ್ರು 4 ಜನರಿದ್ರೆ ನಿಮ್ಮ ಅಫೆನ್ಸ್ ಏನಾದ್ರೂ ಕಡಿಮೆ ಆಗುತ್ತಾ?
Others also assaulted and she pulled ಇದೆ sentence. There is a sentence in ಆರೋಪಿ ಮತ್ತು ಜೊತೆಲಿ ಇದ್ದವರು ನನ್ನ ಕೈ ಹಿಡಿದು ಎಳೆದಾಡಿದರು.
ಹೌದು, ಅದು allegation against you, how it would diminish or reduce?
That is common according to the case of the prosecution. It is 149, my lord. 149 unlawful assembly, my lord, and all these accused joined together and entered into the trespass into the house of PW1. There they picked up a quarrel with PW1, and others along with the accused number 1 pulled her a hand and caused her injuries.
Just put it on 17. Yes.
My lord, the petitioner is convicted for the offense under section 448 of the IPC, trespass into the house of PW1. My lord, the petitioner before this honorable court is a close relative of PW1. My lord, it is stated in her chief examination and cross examination also she has stated that ಆರೋಪಿ ನಮ್ಮ ಮನೆಯಲ್ಲೇ ಇದ್ದು ಕೆಲಸ ಮಾಡುತ್ತಾ ಮನೆಯಲ್ಲೇ ಓಡಾಡಿಕೊಂಡ ಇದ್ದ ಎನ್ನುವುದು ನಿಜ. It is in page number 3.
Yes.
Eighth line ಮಾಡಿ.
Yes.
ಆರೋಪಿ ನಮ್ಮ ಮನೆಯಲ್ಲಿದ್ದು ಕೆಲಸ ಮಾಡುತ್ತಾ ಮನೆಯಲ್ಲೇ ಓಡಾಡಿಕೊಂಡು ಇದ್ದ ಎನ್ನುವುದು ನಿಜ. ಆರೋಪಿ ನಮ್ಮ ಮನೆಗೆ ಏಕಾಏಕಿ ಬಂದಿಲ್ಲ ಅಂದರೆ ನಮ್ಮವರು ಮನೆಯಲ್ಲಿದ್ದು ಹೋಗುತ್ತಿದ್ದು ಅಂದರೆ ಸರಿಯಿಲ್ಲ. ನಾನು ಆರೋಪಿಯ ಜೊತೆ 4 ಜನ ಬಂದಿದ್ದರು ಎಂದು ಫಿರ್ಯಾದಿಯಲ್ಲಿ ನಮೂದು ಮಾಡಿರುತ್ತೇನೆ. Lord, not only PW1 and other witnesses also deposed before the court that this petitioner was staying in their house from 2005. The PW2 in a cross examination 2005ರಿಂದ ಅವನು ನಮ್ಮ ಮನೆಗೆ ಬಂದು ಹೋಗು ಮಾಡುತ್ತಿದ್ದನು. Lord, it is clearly stated this PW2 says that, my lord, ಆ ದಿನ ಆರೋಪಿ ನಮ್ಮ ಮನೆಗೆ ಒಬ್ಬನೇ ಬಂದಿದ್ದ. ನನ್ನ ತಂಗಿ ಮತ್ತು ಆರೋಪಿಯ ನಡುವೆ ಮದುವೆ ವಿಚಾರ ನಡೆಯುತ್ತಿತ್ತು ಅಂದರೆ ಸರಿಯಲ್ಲ. Lord, it is proposed by the relatives of the petitioner and PW1 that regarding the marriage of this petitioner and PW1, my lord. Yes. The evidence of PW.
Yes.
The evidence of PW1 is that, my lord, according to our statement before the court, that accused number 1 and 3 others came to their house, and accused number 1 and 3 others joined together. They pulled her hands and caused her injuries, my lord. And it is also clear from our evidence that there was a proposal of marriage between this petitioner was working in their house, and there was a proposal of marriage. And she is not given any further statement before the police. And exhibit P2, she is not aware. The exhibit P2 is the spot measure. She is not aware of the drawing spot measure, my lord. She is not aware where she signed that document, my lord. She has clearly stated in her chief examination, ಪಂಚನಾಮೆ ಮಾಡಿದ್ದು exhibit P2 ರಂತೆ ಮಸರ್ ಮಾಡಿ ಅದಕ್ಕೆ ನನ್ನ ಹಾಗೂ 2 ಮತ್ತು ಸಹಿ ಪಡೆದಿದ್ದಾರೆ ಎಂದರೆ ಹೌದು.
Yes.
The evidence of PW2, my lord, she is none other than the sister of the PW1, one Sailaja, my lord. She is the resident of Palahalli. ಮಲ್ಲೇಗೌಡನ ಕೊಪ್ಪಲು ನನ್ನ ತಂದೆ ಊರು, ಫಿರ್ಯಾದುದಾರರು ನನ್ನ ತಂಗಿ, ಚಾಸ 3 ಉಷಾ ನನ್ನ ಅತ್ತಿಗೆ, ಆರೋಪಿ ನನಗೆ ಗೊತ್ತು. 14/3/2008 ಮಧ್ಯಾಹ್ನ 2:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಾನು, ಚಾಸ 1 ಮತ್ತು 3ರವರು ನನ್ನ ತಂದೆಯ ಮನೆಯಲ್ಲಿರುವಾಗ ಆರೋಪಿ ನಮ್ಮ ಮನೆಯ ಒಳಗೆ ಬಂದು, ಆರೋಪಿ ನನ್ನ ತಂಗಿ ಚಾಸ 1ರವರನ್ನು ಕುರಿತು ನನ್ನನ್ನು ಮದುವೆ ಆಗು, ಇಲ್ಲದಿದ್ದರೆ ನಿನ್ನನ್ನು ಮಾನಭಂಗ ಮಾಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿ ಹಿಡಿದ. ನನ್ನ ತಂಗಿಯನ್ನು ಹಿಡಿದುಕೊಂಡು ಎಳೆದಾಡುತ್ತಾ ಮಾನಭಂಗ ಮಾಡಲು ಪ್ರಯತ್ನಿಸುತ್ತಾ ಇದ್ದ. ನಾನು ಬಿಡಿಸಲು ಹೋದಾಗ ನನ್ನ ಬಲ ಮುಂಗೈನ ಉಂಗುರದ ಬೆರಳು ಹಾಗೂ ಕಿರು ಬೆರಳು ಹಾಗೂ ಮಣಿಕಟ್ಟಿನ ಬಳಿ ಕಚ್ಚಿದನು. ನನ್ನ ಅತ್ತಿಗೆ ಚಾಸ 3 ಜನಗಳು ಬಿಡಿಸಲು ಬಂದಾಗ ನನ್ನ ಅತ್ತಿಗೆಯನ್ನು ಜಾಡಿಸಿದ, ಆದರೆ ಆಕೆಗೆ ಯಾವುದೇ ರೀತಿಯ ಗಾಯವಾಗಿಲ್ಲ. ಗಲಾಟೆ ಶಬ್ದ ಕೇಳಿ ಕೃಷ್ಣೇಗೌಡ ಮತ್ತು ರವಿ ಬಂದು ಜಗಳ ಬಿಡಿಸಿದರು. ಆ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ ಹೋಗುವಾಗ ಕೊಲೆ ಬೆದರಿಕೆ ಹಾಕಿದ. ಅದೇ ದಿನ ಸಾಯಂಕಾಲ ಇಲಿವಾಲದ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನಾನು ನನ್ನ ತಂಗಿ ಹೋಗಿ ಚಿಕಿತ್ಸೆ ಪಡೆದಿದ್ದೇವೆ. ಇನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ my lord, ಫಿರ್ಯಾದಿ ನನ್ನ ತಂಗಿ ನನ್ನನ್ನು ಶ್ರೀರಂಗಪಟ್ಟಣದ ಪಾಲಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ನಾನು ಅಲ್ಲೇ ವಾಸವಾಗಿದ್ದೇನೆ. ಆರೋಪಿ ನನ್ನ ಸಂಬಂಧಿಕ ಅಂದರೆ ನಿಜ. ಆರೋಪಿ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಇದ್ದ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ, ಆದರೆ ಅವಾಗ ಹೋಗಿ ಬಂದು ಮಾಡುತ್ತಿದ್ದ. ಆರೋಪಿ ನನ್ನ ಅತ್ತೆಯ ಮಗ ಎನ್ನುವುದು ನಿಜ. ಆ ದಿನ ಆರೋಪಿ ನಮ್ಮ ಮನೆಗೆ ಒಬ್ಬನೇ ಬಂದಿದ್ದ. ನನ್ನ ತಂಗಿ ಮತ್ತು ಆರೋಪಿಯ ನಡುವೆ ಮದುವೆ ವಿಚಾರ ನಡೆಯುತ್ತಿತ್ತು ಅಂದರೆ ಸರಿಯಲ್ಲ. ಚಿಕ್ಕವನಿಂದಲೂ ಆರೋಪಿ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ಹೋಗಿ ಮಾಡುತ್ತಿದ್ದ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆದರೆ 2005ರಿಂದ ಅವನು ನಮ್ಮ ಮನೆಗೆ ಬಂದು ಹೋಗಿ ಮಾಡುತ್ತಿದ್ದನು. ನಾನು ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿದ್ದೆವು. ಪಕ್ಕದ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ವಿಚಾರ ತಿಳಿಸಲು ತೊಂದರೆ ಇರಲಿಲ್ಲ ಎನ್ನುವುದು ನಿಜ. ವೈದ್ಯಾಧಿಕಾರಿ ಜೊತೆ ಆರೋಪಿ ಜೊತೆ 4-5 ಜನ ಬಂದಿದ್ದರು ಎಂದು ಹೇಳಿಕೆ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನುವುದು ನಿಜ. ಸ್ಥಳ ಮಾಜರಿಗೆ ಪೊಲೀಸ್ ಯಾವಾಗ ಬಂದಿದ್ದರು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಈ ವಿಷಯವನ್ನು ನನ್ನ ತಂಗಿಯನ್ನು ಕೇಳಿಲ್ಲ. ಸ್ಥಳ ಮಾಜರ್ ಬಂದ ವಿಷಯ ನನ್ನ ತಂಗಿಗೆ ಗೊತ್ತಿದೆಯೋ ಇಲ್ಲವೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಪೊಲೀಸರು ನನ್ನ ಹೇಳಿಕೆ ಪಡೆದಿಲ್ಲ. ಆರೋಪಿಯ ಜೊತೆ ನನ್ನ ತಂಗಿಯ ಮದುವೆ ವಿಚಾರ ಇದ್ದು ಅದು ಬೇಡವಾದ ಕಾರಣ ನಾನು ದೂರ ಇಡಲು ಈ ರೀತಿ ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಿಲ್ಲ. ಆರೋಪಿ ಆ ರೀತಿ ಏಕಾಏಕಿ ಬಂದಿಲ್ಲ, ಮನೆಗೆ ನುಗ್ಗಿಲ್ಲ ಅಂದರೆ ಸರಿಯಿಲ್ಲ. ಸಾಕ್ಷಿದಾರರು ನನ್ನ ಸಂಬಂಧಿಕರು ಅಂದರೆ ಸರಿಯಿಲ್ಲ. ನನ್ನ ಬೆರಳಿಗೆ ಆದ ಗಾಯ ನಾನು ನನ್ನ ಉಂಗುರವನ್ನು ತೆಗೆಯುವಾಗ ಆದ ಗಾಯವಾಗಿರುತ್ತದೆ. ಆರೋಪಿ ಯಾವುದೇ ಗಾಯ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ಆ ದಿನ ಯಾವುದೇ ಘಟನೆ ನಡೆದಿಲ್ಲದಿದ್ದರೂ ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. Is the evidence of PW2, who is none other than sister of the PW1, my lord. And she has stated that there is a relationship between PW1 and their family, my lord. He used to come to their house and from 2005 manege bandu hogi ಮಾಡುತ್ತಿದ್ದನು. My lord, this evidence, according to this PW2, my lord, accused alone came to the house. PW1, my lord, she stated before, in her deposition that PW1 and 3 others came, my lord. And before the doctor, they have stated that accused number 1 and 5 to 6 other persons came to the house. There is 2 medical certificate. In the medical certificates, yes, both the PW1 and PW2 have clearly stated that at the time of incident, PW1 earliest document before the given statement before the doctor is that 5 to 6 persons. Both the medical certificate discloses that 5 to 6 persons, my lord. And the evidence of PW1 and PW2 is that there is a disturbancy in the evidence, contradicting each other. C says accused number 1 and others. PW2 says only one accused. Further, my lord, next witness is one Krishnagoda.
Yes.
I already submitted before this court that 448, the relative is the relative, the trespass is not applicable. Known person going to the house of relatives house is not attracts 448.
How do you substantiate that? Whether section 448 makes any such
A trespass, my lord.
proviso.
A trespass, my lord. Anybody trespass into the house, unknown person trespass. Known person goes to the house, it is not a trespass, my lord. My contention of
No, not contention, sir. Mere telling is not sufficient. You should convince me. How do you substantiate that?
whoever commits house trespass shall be punished with imprisonment.
No. You read the definition of trespass.
Otherwise,
You are reading the punitive clause.
oh, sorry. Whoever commits criminal trespass by entering into or remaining in any building, tent or vessel used as a human dwelling or any building used as a place or worship or as a place for the custody of property is said to commit house trespass. The introduction of any, this is the house trespass.
Does it give any exception that any known person or a relative?
There is no distinguish.
Then how are you inferring that?
There is no distinguish in house trespass, my lord, known persons or unknown persons.
Then how are you?
My contention is that, my lord, if no known person goes to the house and stay in the house, whether it may be a criminal offense or any other thing, my lord, he used to go to their house from 2005. According to the evidence of PW1 and PW2, he used to come to my house and he is a relative. When relative goes to the house of component,
ವಕೀಲ್ರೆ ಎಷ್ಟೋ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಅಣ್ಣ ಮುಂದ್ರೆ ಗುದ್ದಾಡಿರ್ತಾರೆ, ಒಬ್ರು ಇನ್ನೊಬ್ರಿಗೆ ಬೈದಿರ್ತಾರೆ. ನಮ್ಮ ಮನೆಯೊಳಗೆ ಕಾಲಿಡು ನಿನ್ ಕಾಲು ಮುಂದೆ ಕೈ ಕೊಡ್ತೀನಿ ಅಂತ ಅಲ್ವೇ? ಬೆಂಗಳೂರು ಸಿಟಿಯಲ್ಲಿ ಬಹುಶಃ ಎಷ್ಟೋ ಫ್ಯಾಮಿಲಿಗಳಲ್ಲಿ ಅಣ್ಣ ತಮ್ಮಂದ್ರು ಪರಸ್ಪರ ಮನೆಗೆ ಹೋಗದೆ ಎಷ್ಟೋ ವರ್ಷಗಳೇ ಕಳೆದಿರ್ತಾರೆ. ಅದರಲ್ಲಿ ಇವನು ಹೋಗಿ ತಮ್ಮ ಕಪಾಳಕ್ಕೆ ಬಾರಿಸಿ ಬಂದ ಅಂದ್ರೆ ಅದು ಕ್ರಿಮಿನಲ್ ಟ್ರೆಸ್ಪಾಸ್ ಆಗಲ್ವೇ?
With the intention, if the ghost means, my lord, to assault.
ಇದ್ರಲ್ಲಿ ಹೋಗಿ ಬರೀ ಹೋದ ಅಷ್ಟೇ ಅಲ್ಲ,
ಮದುವೆ ಮಾಡ್ಕೊಂತೀನಿ ಅಂತ
324, 354 ಅದೆಲ್ಲದೂ ಬಂದಿದೆ ಅಲ್ವೇ? ಮತ್ತೆ on what basis you say that if a relative or a known person goes, it won't amount to trespass? Rather, won't it has come out as a criminal trespass, because apart from going there,
and whereas
at least they have committed certain offense.
Yes, sir. My contention is that
ನಿಮ್ಮ contention ಅಲ್ಲ ವಕೀಲ್ರೆ, you have to substantiate your contention. Mere telling contention is not at all an argument.
Yes, sir.
ನನಗೆ ಅದೇ ಹೇಳಿ 20 ವರ್ಷದಿಂದ ಸಾಕಾಗಿದೆ. ಏನೋ ಹೇಳಿದ ಕೂಡ ಅದಕ್ಕೆ ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗ್ಲಾದಾಗ that is all my submission. I leave it to your lordship. ಅಲ್ಲ, that is all my contention ಅಂತಾರೆ. ಅಲ್ಲ, you are here not to place your contention, you are here to submit your argument. And argument mean any statement you make, unless the court is not ready to accept it on its face value, you have to substantiate it and attempt to convince the court.
Yes, my lord.
ಹಾಗಾಗಿ that is my contention, that is my submission. ಇಲ್ಲ,
no, I am not submitting before that.
ಮೂರನೇ ಸರ್ತಿ that is my contention ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಿ, ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಿದ್ದೇನೆ.
Yes, my lord.
Maybe your contention, but substantiate that, please. Otherwise, the court may say several of the contentions learned counsels took in the matter in the course of argument, but despite the court repeatedly requesting the learned counsel to substantiate the contention, the learned counsel did not put any effort in that regard. ಹಾಗೆ ಬರೆಯುವುದು ಚಂದವೋ ಅಥವಾ ನೀವು ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡುವುದು ಅನುಕೂಲಕರ?
Substantiate ಮಾಡೋದು
ಅಲ್ಲವೇ?
PW3, my lord.
Yes.
Next witness is one Krishna Gowda, my lord.
Yes.
He is completely turned hostile. Who is the chance witness who was passing through their house after hearing.
ಅದನ್ನ ಹೇಗೆ ಹೇಳ್ತೀರಿ he completely turned hostile ಅಂತ? ದಯಮಾಡಿ ಓದಿ ಒಮ್ಮೆ.
ಚಾಸ 1 ಮತ್ತು 3 ಆರೋಪಿ ಗೊತ್ತು. ಸುಮಾರು 1.5-2 ವರ್ಷದ ಹಿಂದೆ ನಾನು ಮತ್ತೊಬ್ಬ ಹುಡುಗ ಸಂಜೆ 4 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಹೊಲದ ಕಡೆಗೆ ಹೋಗುತ್ತಿದ್ದೆವು. ಚಾಸ 1ರವರ ಮನೆಯಲ್ಲಿ ಕೂಗಾಡುವ ಶಬ್ದ ಕೇಳಿಸಿತು.
ಚಾಸ 1ರವರ ಮನೆಯಲ್ಲಿ ಕೂಗಾಡುವ ಶಬ್ದ ಕೇಳಿತು. ಮುಂದೆ
ಅಕ್ಕಪಕ್ಕದವರು ಓಡಿ ಹೋಗಿ
ಎಂದು
ಕೂಗುತ್ತಿದ್ದರು. ಆಗ ಆರೋಪಿ ದೇವರಾಜ ಮತ್ತಿಬ್ಬರು
ಅಲ್ಲಿಂದ ಓಡಿ ಹೋದರು,
ಮನೆಯಿಂದ ಓಡಿ ಹೋದರು. ನಾನು ನೋಡಿದಾಗ ಚಾಸ 2ರವರ ಬಲಗೈ ಕಡಿಯಲಾಗಿತ್ತು. ಜನರ
ಸಾಗಿಸಿದೆ.
ಜನರ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಲು ಹೇಳಿದರು. ನಾವು ಕರೆದುಕೊಂಡು ಹೋದೆವು. ಒಳಗಡೆ ಏನು ನಡೆದಿತ್ತೆಂದು ನನಗೆ
ಒಳಗಡೆ ಏನು ನಡೆದಿತ್ತೆಂದು ಗೊತ್ತಿಲ್ಲ. ಆದ್ರೆ ಅವನು ಕಂಪ್ಲೀಟ್ಲಿ ಹಾಸ್ಟೆಲ್ ಹೇಗಾಗ್ತಾನೆ? ಹೋದಾಗ ಒಳಗಡೆ ಏನೋ ನಡೀತಾ ಇತ್ತು, ಕೂಗಾಡೋದು ಕೇಳಿತು, ನಿಂತ್ವೆ. ಅಕ್ಯೂಸ್ನು ಇನ್ನೊಂದಿಬ್ರು ಒಳಗಡೆಯಿಂದ ಹೊರಗಡೆ ಓಡಿ ಹೋದ್ರು, ನೋಡಿದ್ವಿ. ಆಮೇಲೆ ನೋಡಿದಾಗ CW2 ಕೈ ಕಚ್ಚಿ ಗಾಯ ಆಗಿತ್ತು, ಆಸ್ಪತ್ರೆಗೆ ಶಿಫ್ಟ್ ಮಾಡಿ ಅಂದ್ರು, ನಾವು ಶಿಫ್ಟ್ ಮಾಡಿದ್ವಿ. ಕ್ಯಾನ್ ಯು ಕಾಲ್ ದಟ್ ವಿಟ್ನೆಸ್ ಆಸ್ ಕಂಪ್ಲೀಟ್ಲಿ ಹಾಸ್ಟೈಲ್?
ಸಾಕ್ಷಿಯನ್ನು ಹೇಳಿಕೆಯ ಅಂಶಗಳಿಗೆ ವಿರುದ್ಧವಾಗಿ ನುಡಿದಿದ್ದರಿಂದ ಪ್ರತಿಕೂಲ ಸಾಕ್ಷಿಯಾಗಿ ಪರಿಗಣಿಸಿ ಪಾಟಿ ಸವಾಲು ಮಾಡಲು ಅನುಮತಿ ಕೋರಿರುತ್ತಾರೆ. That is the submission made by the APP, my lord. And even according to the this evidence, my lord, accused number 1, this petitioner, along with 2 others, ran away from the house. It is there, man.
Yes.
Yes. And his evidence is ನೀನು ಮದುವೆ ಆಗದಿದ್ದರೆ ನಿನ್ನನ್ನು ಕೊಲೆ ಮಾಡು. Exhibit P, my lord, it is treated as hostile. Exhibit P3, my lord, and Exhibit P4, my lord. She is none other than the sister-in-law of the PW1. C2 is turned hostile.
PW4 turned hostile.
Turned. Yeah, andre my lord, for the limited purpose it is turned hostile, but prosecution ಹೇಳಿಕೆಯ ಅಂಶಗಳಿಗೆ ವಿರುದ್ಧವಾಗಿ ಅಂದ್ರೆ 161 ಸ್ಟೇಟ್ಮೆಂಟ್ ಗೆ ಎಗೇನೆಸ್ಟ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಅವ್ರ ಕನ್ಫೆಕ್ಷನ್ ಮೇಲೆ. I am not creating new evidence before this honorable court. It is the evidence which is recorded by the learned magistrate on the request made by the assistant public prosecutor.
Yes.
2.5 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಚಾಸ 1 ಮತ್ತು 2 ಮನೆಯಲ್ಲಿ ಇದ್ದವು. ಆಗ ಆರೋಪಿ ಮನೆಗೆ ಒಳಗೆ ಬಂದು ಚಾಸ 1ರನ್ನು ಹಿಡಿದು ಎಳೆದಾಡಿದ್ದು, ನನ್ನನ್ನು ಮದುವೆ ಆಗು ಎಂದು ಹೇಳುತ್ತಿದ್ದ, ನಿನ್ನನ್ನು ಕೊಲೆ ಮಾಡುತ್ತೇನೆ ಎಂದು ಹೇಳುತ್ತಿದ್ದ. ನಾವೆಲ್ಲ ಕಿರಿಚಿಕೊಂಡವು. ನನ್ನನ್ನು ದಬ್ಬಿದ, ಕೆಳಗೆ ಬಿದ್ದೆ. ಆರೋಪಿ ಚಾಸ 1, 2 ಶೈಲಾಜರು ಬಲಗೈಯನ್ನು ಕಚ್ಚಿದ. ಆಗ ಕೃಷ್ಣ ಅಲ್ಲಿಗೆ ಬಂದರು. ಆರೋಪಿ ಮಾನಭಂಗ ಮಾಡಲು ಪ್ರಯತ್ನ ಪಟ್ಟಿದ. ಕೃಷ್ಣ ಸಾಲಿಗೆ ಬಂದು ನಾವು ನೂಕಿದೆವು. ಇದನ್ನು ಬಿಟ್ಟು ಆರೋಪಿ ಮತ್ತೇನು ಗಲಾಟೆ ಮಾಡಿಲ್ಲ. ಚಾಸ 1 ಬೇಡ ಬೇಡ ಎಂದು ತಡೆಯುತ್ತಿದ್ದಳು. My lord, these all the 3 witnesses, PW1, PW2 and PW4, my lord, are residents of different villages. And they are relatives. PW1's sister is PW2, and PW4 is none other than the sister-in-law of PW1. All these witnesses are relative, my lord. There is a real sister and sister-in-law, and there is likelihood of concocting the evidence of PW1, 2 and 3, my lord. 4, my lord. The relative the witness, the evidence of the relative witnesses should be fair and cautiously.
Really? ಹೇಳ್ತಿದ್ರಿ ರಿಲೇಟಿವ್ ವಿಟ್ನೆಸಸ್ ಎವಿಡೆನ್ಸ್ ನೀಡ್ ನಾಟ್ ಬಿ ಬಿಲೀವ್ಡ್ ಆರ್ ಡಿಸ್ಬಿಲೀವ್ಡ್ ಅಂತ. ಆಮೇಲೆ ನನ್ನ ಮುಖ ನೋಡಿ ಫೇರ್ ಅಂಡ್ ಕಾಶಿಯಸ್ಲಿ ಅಂತಿದ್ದೀರಿ ಅಲ್ವೇ? ಹೇಳಿ ಮುಂದೆ.
Should we examine them fair and cautiously, my lord?
Yes.
And these witnesses, there is possibility of concoction of the evidence of PW1, 2 and 4, my lord. This is my submission, man.
Yes.
And it is also clearly stated in our cross examination, I have not given any statement before the police. ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಹೇಳಿಕೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂದರೆ ನಿಜ. ಘಟನೆ ನಡೆದ ದಿನ ಅವರ ಮನೆಯಲ್ಲಿ ಯಾವುದೇ ಫಂಕ್ಷನ್ ಇರಲಿಲ್ಲ ಅನ್ನುವುದು ನಿಜ. ಪೊಲೀಸರು ಮನೆಗೆ ಬಂದಿದ್ದರು, ಆದ್ರೆ ಅವರಿಗೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿಲ್ಲ. ಆರೋಪಿ ಮತ್ತು ಶೈಲಜಾ ಎಲ್ಲಾ ಸಂಬಂಧಿಕರು ಅನ್ನುವುದು ನಿಜ. ಆರೋಪಿ ಮತ್ತು ಶೈಲಜಾರವರಿಗೆ ಮದುವೆ ಮಾತುಕತೆ ನಡೀತಿತ್ತು ಅನ್ನುವುದು ಗೊತ್ತಿಲ್ಲ. ಸಾಕ್ಷಿ ಪುನಃ ನುಡಿಯುತ್ತಾರೆ, ಘಟನೆಗೆ ಮುಂಚೆ ಆರೋಪಿಯವರು ಮನೆಯಲ್ಲಿ ಇದ್ದಾರಂತೆ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಅಂದ್ರೆ ಸ್ವಂತ ಸಿಸ್ಟರ್, ಬ್ರದರ್ ವೈಫ್, she is not aware that he was staying in that house. ಈಗ ಅತ್ತೆ ಮಗ ಇವನು, ಅತ್ತೆ ಮಗ after the death of PW1's parents, he was staying in the house and there is a proposal of marriage. ಅದು ಮದುವೆ ಮಾಡಿ
ಎಲ್ರಿಗೂ ಹೇಳ್ತಾ ಇದ್ದೀರಿ, ಅವ್ರು ಒಪ್ತಾ ಇಲ್ವೇ? ನಿಮ್ ದುರದೃಷ್ಟವೋ ಅವ್ರ ದುರದೃಷ್ಟವೋ ಗೊತ್ತಿಲ್ಲ, ಹೇಳಿ.
ಯಾವುದೇ ರೀತಿಯ ಕೊಲೆ ಬೆದರಿಕೆ ಹಾಕಿಲ್ಲ ಅಂದರೆ ಸರಿ ಇಲ್ಲ. ಆರೋಪಿ ಶೈಲಜಾ ನಡುವೆ ಮಾತುಕತೆಯಾಗಿದ್ದು ಈಗ ಬೇಡವಾಗಿದ್ದರಿಂದ ಆರೋಪಿಯ ಮೇಲೆ ಸುಳ್ಳು ಫಿರ್ಯಾದಿ ನೀಡಿದ್ದೀರಿ. My lord, there was a proposal during the year 2005 and earlier than that, my lord. Subsequently, she has completed her education and she has become she was doing second PUC, my lord. During that time, she refused to marry this agriculturist. He's an agriculturist by profession, my lord. My lord, they are refused to marry. For that, they have the suggestion of the council before the court below is that she is not interested to marry with this accused. For that, they have created a false complaint against him, my lord. And PW5, my lord, is one Rajagowda. He is a village panchayati member, and there is no dispute regarding the ownership of the said house, my lord. And PW6, one Madeva, my lord. And his limited purpose, he was turned hostile. Exhibit 2 ಮತ್ತು ಚಾಸ 2 ಮತ್ತು 3 ನನಗೆ ಗೊತ್ತು. ಈಗ ತೋರಿಸಿದ ಎಕ್ಸಿಬಿಟ್ 2ರಲ್ಲಿ ಸಹಿ ನನ್ನದು. 16/3/2008 ಪೊಲೀಸರು ಸಂಜೆ 4 ರಿಂದ 5 ಗಂಟೆ ಸಮಯ ನಮ್ಮ ಊರಿಗೆ ಬಂದಿದ್ದರು. ಚಂದ್ರೇಗೌಡ ಮನೆ ಬಳಿ ಎಕ್ಸಿಬಿಟ್ P2ಗೆ ನನ್ನ ಸಹಿ ಪಡೆದಿರುತ್ತಾರೆ. ನನಗೆ ಸಮ ಬೇರೆ ಯಾವ್ದಾರು ಸಹಿ ಮಾಡಿರುವುದಿಲ್ಲ. ಫಿರ್ಯಾದುದಾರರು ಚಂದ್ರೇಗೌಡರ ಮಗಳಾಗಿರುತ್ತಾಳೆ. And he was treated hostile. ಚಾಸ 1 ಮತ್ತು 4ರವರು ಎಕ್ಸಿಬಿಟ್ 2ಕ್ಕೆ ಸಹಿ ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಅವರು ಸಹಿ ಮಾಡಿದ್ದು ಗೊತ್ತಿದ್ದು ನಾನು ಸರಿಯಾಗಿ ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿ ಇಲ್ಲ. ಪೊಲೀಸರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪೊಲೀಸರ ಬಂದಿದ್ದರು ಮತ್ತು ಅದರಲ್ಲಿ ಏನು ಒಕ್ಕಡೆ ಬರೆದಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆರೋಪಿ ಫಿರ್ಯಾದಿದಾರ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದ ವಿಷಯ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಪೊಲೀಸರು ನನ್ನ ಬಳಿ ಯಾವುದೇ ಹೇಳಿಕೆ ಪಡೆದಿಲ್ಲ ಎನ್ನುವುದು ನಿಜ. And this is only for the limited purpose of conducting spot measure in the spot. And he has stated that other signature, I am not aware of other signature, and contents of the measure is not aware. And the next important witness is doctor. Doctor evidence, my lord.
Tell me the summary. What do you want to deduce from the evidence?
In that, I am limited for the purpose I will submit before this court, my lord. The PW1 is examined by the doctor. During that time, my lord, the first on 14/3/2008 at about 2:30, the incident was taken and she is rushed to the hospital by 5 o'clock. 5 o'clock, she visited this hospital. There she has taken a treatment by the doctor. And in front of the doctor, she has given deposed before the doctor that Devraj ಮತ್ತು ಇತರೆ 4 ಜನರು ನಮ್ಮ ಮನೆಗೆ ನುಗ್ಗಿ ಗಲಾಟೆ ಮಾಡಿದ್ದರಿಂದ ಆದ ಗಾಯಗಳು ಎಂದು ತಿಳಿಸಿದರು. Lord, it is still further, there is a improvement by the investigation officer in this case is that, my lord, on the same day, police aware of the said galata, my lord. They have not registered the case. There is, can I read?
Please.
ದಿನಾಂಕ 14/3/2008 ಸಂಜೆ 5:05 ಸಮಯದಲ್ಲಿ ಗಿರೀಶ್ ಮತ್ತು ಶೈಲಜಾ ಚಾಸ 2 ಮತ್ತು 1ರವರು ಇಲಿವಾಲ ಪೊಲೀಸ್ ಠಾಣೆಯ ಪೇದೆ 168ರವರು ಚಿಕಿತ್ಸೆಗಾಗಿ ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದರು. Lord, the evidence of this witness, my lord, the doctor witness, my lord, he has deposed before the court that on the particular day, on the date of incident, on 14/3/2008, at about 5:05, he, along with the police constable HC 168, accompanied with the injured person. And he gave a memo and treated this PW1 and PW2, my lord. Both were treated in their evidence. PW6, my lord. In the PW7, Dr. Srikanth, son of Krishnamurthy.
Yes.
The PW1 stated that A1 and 4 others. Then the Sailaja was PW2 was examined, and their statement also.
Yes.
In the cross examination, can I read cross examination? ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದಾರೆ ಅಂದ್ರೆ ನನಗೆ ನೆನಪಿರುವುದಿಲ್ಲ. ಅವರು ಮಹಿಳಾ ಪೇದೆನಾ ಅಥವಾ ಗಂಡು ಪೇದೆ ನನಗೆ ನೆನಪಿರುವುದಿಲ್ಲ. ನಾನು ಕೊಟ್ಟಿರುವ ML ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಪ್ರಿಂಟೆಡ್ ಫಾರಂ ಎಂಬುದು ನಿಜ ಇರುತ್ತದೆ. MLC ಪೊಲೀಸರ ಗಾಯಾಳುವನ್ನು ಕರೆದುಕೊಂಡು ಬಂದಾಗ ನನಗೆ ಮನವಿ ಪತ್ರವನ್ನು ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಈಗ ಅದು ನನ್ನ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಎಕ್ಸಿಬಿಟ್ P5 ಅಲ್ಲಿ ನಮೂದಾಗಿರುವ ಗಾಯವು ಕೆಳಗೆ ಬಿದ್ದರೂ ಕೂಡ ಆಗುತ್ತದೆ ಎಂದರೆ ಸರಿ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಶೈಲಜಾ ಅವರಿಗೆ ಆಗಿದ್ದ ಗಾಯದ ಅಳತೆಯನ್ನು ನಾನು ಮಾಡಿರುವುದಿಲ್ಲ. ಎಕ್ಸಿಬಿಟ್ P6 ರಲ್ಲಿ ಕಚ್ಚಿದ್ದು ಎಂದು ಹೇಳಲು ನಿಖರವಾದ ಮಾಹಿತಿಯನ್ನು ಅದರಲ್ಲಿ ನಮೂದಿಸಿರುವುದಿಲ್ಲ. ಬೆರಳಿನಲ್ಲಿ ಆಗಿರುವ ಗಾಯ ಉಗುರು ಹಾಕಿಕೊಂಡಾಗ ಆಗಬಹುದು, ಉಂಗುರ ಹಾಕಿಕೊಂಡಾಗ ಆಗಬಹುದು ಎಂದರೆ ಅಬ್ರೇಷನ್ ಆಗಬಹುದು. ಗಾಯಾಳುಗಳು ನೋವು ಅಂತ ಹೇಳಿದಾರ, ಅದರ ಹೊರಗೆ ಯಾವುದೇ ಚಿಹ್ನೆಗಳು ಕಾಣುತ್ತಿಲ್ಲ. ನಾನು ಪೊಲೀಸರ ಹೇಳಿಕೆ ಮೇರೆಗೆ ಸುಳ್ಳು ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿ ಇಲ್ಲ. ನಾನು ಗಾಯಾಳುವಿಗೆ ಯಾವುದೇ ಚಿಕಿತ್ಸೆ ಕೊಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸರಿ ಇಲ್ಲ. The evidence of PW7, Doctor, my lord, it is also earliest opportunity, my lord. Earliest opportunity. The number of accused persons is accused number 1 and 4 others. It is there in the medical certificate. Lord, the investigation officer investigated the matter and recorded the statement of witnesses and filed charge sheet, my lord. And then, my lord, the very interesting that, my lord, on 14/3/2008, the incident was taken place. Thereafter, my lord, after 1 month, my lord, this 3/5/2008 incident was taken place on 14/3/2008. On 13/5/2008, my lord, this PW1's uncle and brother-in-law both caught hold of the injured, caused him injuries, after the said injuries, he was got admitted to the hospital, and a case was registered against this PW1's uncle and brother-in-law location. He was admitted as an inpatient. During that time, statement was recorded and case was registered in same police station in crime number KR ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ದೇವರಾಜ್ ಅವರ ಹೇಳಿಕೆಯನ್ನು 11:45 ಗಂಟೆಗೆ ಬರೆದುಕೊಂಡು ಠಾಣೆಗೆ ಬಂದು ಮೊಕದ್ದಮೆ ನಂಬರ್ 82/2008 324, 323, 506 ರೀತಿ ಕೇಸ್ ದಾಖಲಿಸಿದೆ. The case against this petitioner was on the complaint of this petitioner was registered against the uncle and brother-in-law. Thereafterwards, charge sheet was filed. After filing the charge sheet, the elders of the family compromised the matter. After examining this witness, this case will be taken up. There is a compromise. This witness, my lord, is turned hostile in the court. Thereafter, the PW1 and PW2 deposed before the court against this petitioner, my lord. This is the copy of the FIR and judgment copy.
How can I consider that?
There is a and they are in the motive to assault this petitioner. In CC number 721/2008, my lord. After he turns out, the case of the prosecution was closed and acquitted by the court below, my lord.
Any other points?
My lord, entire case, my lord, is of that of evidence of PW1 and PW2 and 3, my lord. These 3 witnesses are relative each other, my lord, and they are not resident of that village. And there is no chance of coming to that house on the particular day because there is no festival or there is no reasoning why they came to that house on that day. This petition number 1 is the resident of Mallegodan Koppal, and PW1 is resident of Mallegodan Koppal, and PW2 is the resident of Palahalli. PW4 is the resident of KRS. There is a possibility of concoction of evidence of PW1, 2, and 4, my lord. And there is no reasoning why they came on that day to that house. They have not stated before this. For the purpose of creating evidence against this petitioner, they have concocted false case. The court below erred in appreciating the evidence of witnesses, hostile witnesses, and other the PW1 spot measure is also concocted, my lord. According to PW1, there is a delay of my lord, and
2 months and 2 days actually.
Yes. My lord, this petitioner is not involved in any cases. Taking into consideration, my lord, and he is assaulted by the brother-in-law and the relationship. ಗಿರಿಜಾಳ ಚಿಕ್ಕಪ್ಪ, KRS ಲೋಕೇಶ್ ಬಿ ವೆಂಕಟರಮಣಪ್ಪ ಮತ್ತು ಗಿರಿಜಾಳ ಭಾವ ಪಾಲಹಳ್ಳಿಯ ನಾಗರಾಜ್ ಅವರ ಮಗ ಸತೀಶ್ ಇಬ್ಬರು ನನ್ನ ಮೇಲೆ ಜಗಳ ಮಾಡಿದ್ದು, ನನ್ನ ಮೇಲೆ ದ್ವೇಷ ಇಟ್ಟುಕೊಂಡಿದ್ದರು. ಹೀಗಿರುವಲ್ಲಿ ದಿನಾಂಕ 1/5/2008 ನಾನು ಶ್ರೀರಂಗಪಟ್ಟಣದಿಂದ ಸ್ವಂತ ಕೆಲಸ ಇದ್ದುದರಿಂದ ನಾನು ಸ್ಕೂಟರ್ ನಲ್ಲಿ ಶ್ರೀರಂಗಪಟ್ಟಣಕ್ಕೆ ಹೋಗಿದ್ದು, ಸಂಜೆಯಲ್ಲಿ ವಾಪಸ್ ಊರಿಗೆ ಬರಲೆಂದು ಸ್ಕೂಟರ್ ನಲ್ಲಿ ಹೊರಟು ಸಂಜೆ 6:30 ಗಂಟೆಯಲ್ಲಿ ಪಂಪ್ ಹೌಸಿನಿಂದ ಮುಂದೆ ಡಾಬಾ ಹೋಟೆಲ್ ಬಳಿ ರಸ್ತೆಯಲ್ಲಿ ಬೆಳಗೋಳದ ಕಡೆಗೆ ಬರುತ್ತಿದ್ದಾಗ
ಅಷ್ಟೊತ್ತು ಹೇಳಿ ಸಮಯ ತೆಗೆದ್ರಿ,
ಅಂದ್ರೆ
ಓದಿ ಮತ್ತೆ ಸಮಯ ಕಳೀತಾ ಇದ್ವಿ.
ಇಲ್ಲ ಸರ್, ಐ ವಾಂಟ್ ಟು they are in to take revenge against him, and they did the assaulted him and caused him injuries, admitted to the hospital, care hospital. Their statement was recorded. It may be no consequences before this court because he is turned hostile to the case of the prosecution. In my view, my lord, he is not in now. The matter is oldest matter. 14 years is over, my lord, and he is not involved in any other cases. Taking into consideration, my lord, in the hands of this honorable court, he may be entitled for acquittal and set aside the court below.
Keep your argument at 2:30 p.m. Yes, all the next matter.
Number 46 on Nagaland Naik.
Yes.
Motion has raised below. Lordship has below. Directed me to below. River below.
ಪ್ರತಿ ಸರ್ತಿ ಮೈಕ್ರೋಫೋನ್ ಸೈಡಿಗೆ ಟೀಚರ್ ಬರ್ತೀವಿ.
Driver of the Milord bus. Responsibility of the Milord. Whenever
ಹೌದು, ಪ್ರಶ್ನೆ ನೆನಪಿದೆ, ಉತ್ತರ ಏನ್ ಹೇಳಿ.
Milord, I have got the Milord principle laid down by the Milord, the full bench of this court, Milord. One case, Milord.
ಫಸ್ಟ್ ಪ್ರಿನ್ಸಿಪಲ್ ಹೇಳಿ, ಆಮೇಲೆ ತಿಳ್ಕೊಳ್ಬೇಕಲ್ವೇ ಪ್ರಿನ್ಸಿಪಲ್. ಯಾವ ಕೇಸಲ್ಲಿ ಏನು ಅದನ್ನೆಲ್ಲ ಪೂರ್ಣ ಹೇಳಿ. ಎದುರುಗಡೆ ವಕೀಲರಿಗೆ ನೀವು ಅದನ್ನ ಏನ್ ರೆಫರ್ ಮಾಡ್ತೀರಿ ಅದು ಪೂರ್ಣವಾಗಿ ಗೊತ್ತಾಗ್ಬೇಕು, ಮಾಹಿತಿ ನೀಡ್ಬೇಕು ನೀವು. ಹೇಳಿ.
Section 123 has been it has been defined in the they have elaborately discussed in the matter saying duty of the driver and the conductor under held that section 123 of the act casts a duty on the driver and conductor of the vehicle to prevent any person from traveling on the running board or on the top of the vehicle. There is an obligation passed on them under the statute to see that all the persons within the body of the vehicle, in spite of this statutory provision, if they permit any person to travel on the running board or on the top of the vehicle, it is breach of duty. That is larger breach of the our High Court Karnataka referred matter.
It's good.
Yes. Similar principles are same principles.
ಫುಲ್ ಬೆಂಚ್ ಇದೆ ಇಲ್ವೇ?
Full bench is. Apologies, my lord. All the witnesses also supported the case of the prosecution. Death of 3 innocent persons, and as many there are almost 20 persons were injured. Most of them injured examined and they have supported the case of prosecution. Therefore, both the court rightly convicted the petitioner hearing. Therefore, my humble submission, the petition may be dismissed. Divide of merits.
ನಿಮಗೆ ಗೊತ್ತಿಲ್ವೇ ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ ಎಷ್ಟು ಸುಲಭದಲ್ಲಿ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗಿಸ್ಲಿಕ್ಕೆ ಬಿಡಲ್ಲ. ರೈಸ್ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲದಕ್ಕೂ ಉತ್ತರ ಕೊಡಬೇಕು ಅಲ್ವೇ? ಅವ್ರು ಎಷ್ಟು ಪಾಯಿಂಟ್ಗಳು ರೈಸ್ ಮಾಡಿದ್ದಾರೆ? ಅದರಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಒಂದು 2 ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್ ಅಂತ ಹೇಳಿ ನೋಡೋಣ. ಒಂದು ಬಸ್ ಸ್ಟಾಪ್ ಪ್ಯಾಸೆಂಜರ್ಸ್ ಬಗ್ಗೆ ಹೇಳಿದ್ರಿ, ಅದು ನೋಡೋಣ. ಮತ್ತೆ ಇನ್ನೊಂದು
complainant have stated, my lord, hostile witness also, my lord, according to my lord, PW1 and PW. ಪಾಯಿಂಟ್ ಮಾಡಿದ್ದೆ.
ರಿಪ್ಲೈಗೂ ರೆಡಿಯಾಗಿ ಬರ್ರಿ.
Lodge permission. Serial number 56. Filed advance wakalat on 31st.
Serial number?
Serial number 56. Filed wakalat on 31st May, Lord. But instead of that, my name is not shown, and earlier the advocate's name only.
Your name not being shown, that you have to ascertain with the registrar. If they refuse to do it, then you have to make that mention in the court. This court can't do that clerical job.
Not to the notice of the court, my name is not shown. That's all. I'll verify.
Pass over matters. Serial number 28. K. Marchana, MK Query, M. Shashidhara.
After petition, 10 minutes password, swearing in.
Called again. MK Square learned. Also for the applicant in year 1/22, learned HCGP present. Apart from checking for a passover in the matter, the learned counsel for the applicant is seeking once again the passover. Just there's no point in keeping the learned MK Square waiting. Hence, imposing a cost of ₹500 payable by the petition, the learned counsel for the applicant, payable by the applicant in year 1/2022. Short accommodation is granted. Is the matter on 16/6.
10 minutes password. Tomorrow maybe.
Payable by the applicant to the learned amicus curiae.
Any password, melody. Here signature is waiting is.
Yes, next.
Serial number 40, final hearing matters. Serial number 45. M. Partha.
For the petitioner.
HCGP.
For the respondent statement.
Yes, please.
Accused has been convicted for the offense punishable under section 4, 354, 323, 324 mallards, and the same was the judgment of conviction that was upheld by the learned session judge.
For the petitioner, right?
Yes, madam.
That the judgment of conviction passed by the learned magistrate that was upheld by the learned session judge mallards. Let's by submission to delay in lodging complaint mallards, whether the complainant has offered sufficient explanation for delay in lodging the complaint, my lords, has to be limited into my lords, for which, my lords, I want to rely upon the complaint lodged by the complainant, my lords, whether she has offered explanation or not, my lords, that has to be read. Since my learned friend has not read the complaint, I want to read the complaint, therefore kindly.
ಪಂಚಾಯತಿ ನಡೆಸಿಕೊಡುವುದಾಗಿ
Yes. And that apart, my lord, that is one aspect. That the delay, my lords, in lodging the complaint, my lords, is explained in the complaint itself. That is one aspect. The second aspect, my lord, the complainant also says, PW1, my lords, on the date of incident, my lords, immediately after the incident, my lords, she went to, my lords, PW7, the doctor who treated the injured and issued exhibit P5. She said immediately after the incident, she went to the clinic in the evening and took treatment. Let's PW7 also says the injured came to his clinic for taking treatment on the same day. Let's that there is a corroboration in the evidence of PW1 as well as PW5. Let's therefore there is no delay in lodging the complaint. Therefore immediately, she has taken it. It is natural, quite natural that immediately after the incident, the victim who sustains the injuries, it is natural that firstly he goes to a hospital, takes the treatment, then it is natural he goes to the police station and lodges the complaint.
Why should she say in her evidence in examination chief that on the very same day of incident she has lodged the complaint? PW1
in the evidence,
first page, last line.
In the evidence, that is in the evidence. ನಾನು ಘಟನೆಯ ವಿಷಯ ಗ್ರಾಮಸ್ಥರಿಗೆ ತಿಳಿಸಿದೆ. ಅಂದರೆ ಸರಿ, ನ್ಯಾಯ ಮಾಡುವುದಾಗಿ ಹೇಳಿದರು ಎಂದರೆ ಸರಿ.
PW1 evidence examination chief first page last line.
First page last line. Sorry. ಸದರಿ ದಿನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಇರುವ ನಡೆದ ದಿನವೇ ನಾನು ಫಿರ್ಯಾದಿ ನೀಡಿರುತ್ತೇನೆ. In this, the incident has taken place on 14/3/2008. The complaint was, the examination chief of the PW1 was taken place on 3/12/2009. There is a time gap between this and that.
Sir, I'm asking you.
Yes, Malad.
What sanctity you attribute to that her statement?
Yes.
How can you isolate it?
No, Malad.
That means if according to you she has stated a wrong thing, that she lodged the complaint on the very same day, why not her other statements in other sentences must be believed? They may also be wrong. Isn't it? Is it not your case that there was only one accused?
Yes, Malad.
Then why did you permit her or why did you allow her to say that apart from accused number 1, 3 more persons entered my house on this Saturday? Third line from the top of the first page.
That's the allegations of the complainant, in the complaint, in the examination chief, is only against specific governments.
ನನ್ನ ಪ್ರಶ್ನೆ ಉತ್ತರ ಕೊಡ್ತಾ ಇಲ್ಲ. ಆಸ್ ಯೂಶುವಲ್ ನೀವು ನಿಖರವಾದ ಉತ್ತರವನ್ನು ಕೊಡೋದು ಬಿಟ್ಟು ಬೇರೆ ಎಲ್ಲೋ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಒಬ್ಬ ವ್ಯಕ್ತಿ ಒಂದು ವಿಷಯಕ್ಕೆ ಒಂದು ಸುಳ್ಳು ಹೇಳಿದ್ದಾನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅವನು ಉಳಿದ ಹೇಳಿಕೆಗಳನ್ನ ಸತ್ಯ ಅಂತ ನಂಬಲಿಕ್ಕೆ ಏನು ಆಧಾರ ಇದೆ? ಒಂದನ್ನು ಮಾತ್ರ ನಾವು ಹೆಕ್ಕಿಟ್ಟಿಲ್ಲ, ಇದ್ರಲ್ಲಿ ಸುಳ್ಳು ಹೇಳಿದ್ದಾರೆ, ಉಳಿದಿದ್ದೆಲ್ಲ ನಿಜ ಹೇಳಿದ್ದಾರೆ, ಹೇಗೆ ಬಿಲೀವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ?
My first submission is that due to time gap between lodging of complaint and examination chief, there must be some variations in making the statement. Therefore,
the prosecutor should have brought that.
That's what
further examining the witness on the very next sentence.
That's what I am coming to, I am coming to that's due to time gap, due to variations, the complaint might have stated by oversight or by slip of time, she might have stated that on the very same day I have lodged a complaint. But whether when the same day complaint is lodged or on the later part of the days, complaint is lodged, that will not go to the root of the matter, that is only a minor discrepancies,
ಹೇಗೆ ಹೇಳ್ತೀರಿ ಪ್ರಾಸಿಕ್ಯೂಟ್ರಿ? ನೀವು ಸೆಟ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಗಳನ್ನ ಯಾವುದೇ ಕೇಸು 323 ಇಂದ ಹಿಡಿದು 302 ವರೆಗೆ ಯಾವುದೇ ಮ್ಯಾಟರ್ಗಳಾದ್ರೂ ಇವಿಷ್ಟೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಗಳನ್ನ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಹೇಳಿದ್ರೆ ಸಾಕು ಅಂತ ಅಂಡರ್ಲೈನ್ ಮಾಡ್ಕೊಂಡು ಒಂದು ಹಾಳೆಯಲ್ಲಿ 8 ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಬರೀಬಹುದು. ಆ 8 ಸೆಂಟೆನ್ಸ್ ಗಳನ್ನೇ ತಿರ್ಗಾ ಮುರ್ಗ ಹೇಳ್ತಾ ಹೋದ್ರೆ ಹೇಗೆ? Minor discrepancy that cannot be ignored due to paucity of time that might have happened. Due to the shock due of the alleged incident, there may be some variation. By the slip of tongue, something might have happened. ಇದೆಲ್ಲ ಒಂದು ಸೆಟ್ ಆಫ್ ಅಸಂಪ್ಷನ್ಸ್. ಅದನ್ನ ನೀವು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು. ಬರೀ ಹೇಳಿದ್ರೆ ಮುಗಿಯಲ್ಲ, ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು. ಮೈನರ್ ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿ ಹೇಗೆ ಮೈನರ್ ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿ ಆಗ್ತದೆ? ನಿಮ್ಮ ಪ್ರಕಾರ in complaint she has stated 1 plus 4 persons came to my house. Charge sheet says only 1 person came. Even after filing of the charge sheet, which is a final report of the investigating officer of due investigation, the very same victim once again says in her evidence also that the persons who had come was 1 plus 3 persons. From complaint 1 plus 4, her evidence 1 plus 3. That means she is not stating that it was accused and accused alone had come. She says that apart from or along with accused, 3 more persons had come in her evidence. 4 more persons had come in complaint. According to investigating officer, she has given a further statement before the investigating officer stating that it was accused and accused number 1 alone had come. Then was it not expected of the prosecution to put more questions to her and elicit? That is it by oversight, mistake, loss of memory, confusion, shock, tension? She is telling something at variance than what her statement is. Then without doing any such exercises, how can you yourself give a judgment that due to paucity of time it has happened? It's only a minor discrepancy. ಒಬ್ಬರು ಬಂದು ಹೊಡೆದ್ರು, 5 ಜನ ಬಂದು ಹೊಡೆದ್ರು, 4 ಜನ ಬಂದು ಹೊಡೆದ್ರು ಅನ್ನೋದು ಹೊಡೆದಿದ್ದಾರೆ ಎಷ್ಟು ಜನ ಅನ್ನೋದೇ ಕ್ರಕ್ಸ್ ಆಫ್ ದಿ ಮ್ಯಾಟರ್. ಅದೇ ಮೇನ್ ಮೆಟೀರಿಯಲ್. ನಿಮಗೆ ಅದನ್ನೇ ಹೇಳಲಿಕ್ಕಾಗಲ್ಲ ಮೈನರ್ ಅಂತ ಹೇಳಿ ನೀವು ಅದನ್ನ ಒಂದು ಸೆಟ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಫಾರ್ ವಿಚ್ ದಿ ಮೆಜಾರಿಟಿ ಆಫ್ ದಿ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಅಂಡ್ HCGPs ಆರ್ ಟ್ಯೂನ್. ಅದನ್ನೇ ಬಂದು ಹೇಳಿದ್ರೆ ಹೇಗಾಗ್ತದೆ?
Rightly submitted, said.
ನನ್ನನ್ನು ಹೊಗಳೋದ್ರಲ್ಲಿ ಅರ್ಥ ಇಲ್ಲ. Lordship is right, Lordship is very meticulous, Lordship goes in depth, absolutely no use. Convince me on the point.
Yes, the learned PP Mallards who appeared, who examined in chief, the P21, would have extracted all these Mallards, but Mallards, that is not done in this case, Mallards, but the summoned substance, Mallards, overall, so summoned substance of the complaint, Mallards, it is extracted. Mallards, now at this stage, Mallards, I cannot improve. Mallards, as I do consider, Mallards, I cannot improve. I can only restrict my arguments to the pleadings, Mallards, what is there on record, Mallards. I cannot go beyond also, Mallards.
You cannot go beyond the evidence.
Yes.
But your skill lies, you are provoking me, you are making me to lose my patience. 8 out of 10 advocates says that, sir, it is a revision, it is an appeal, it is a second appeal. I cannot improve any evidence. Sir, nobody wants, no courts in India wants any improvement in the evidence. What it expects is whether the learned counsels appear before them have read the entire file in toto, and how do they synchronize the evidence of one witness to another witness, and how do they evaluate, how do they convince the court that the alleged discrepancy, mistake, omission or laches is not as grave as the court is probably depicting. There lies the skill. I am expecting that. Yes, you cannot now improve.
Yes.
You cannot now improve the evidence which has already been recorded. But are you not in a position to convince the court to take the evidence of all material witnesses together, evaluate them, and who shall be the more nearest to the truth, whose evidence could be the more nearest to the truth, how they can be believed, whether it is of victim or whether other 2 persons, or importantly 1 person who sustained grievous injury and who could able to witness the other incident. the alleged outraging the modesty of her sister, which is going in her presence. Therefore, in such a situation, who would be a better witness? Whether a victim who is mainly concentrating in defending herself from the physical manhandling by the accused, or other person standing next to her who is witnessing both the act of the accused and the act of the complainant of the victim and assessing the circumstance. Who would be in a better position?
Mainly Malad.
ನನ್ನ ಮೈಗೆ ಬೆಂಕಿ ಹತ್ತಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಬೆಂಕಿಯಿಂದ ಬಿಡಿಸ್ಕೊಳ್ಳಿಕ್ಕೆ ಒದ್ದಾಡ್ತೇನೋ, ಯಾರೋ ನಾನು ಕುತ್ತಿಗೆ ಹಿಡ್ಕೊಂಡು ಬಾರಿಸಿದ್ದಾರೆ ಅಂದ್ರೆ ನಾನು ಅವನಿಂದ ಬಿಡಿಸ್ಕೊಳ್ಳಿಕ್ಕೆ ಒದ್ದಾಡ್ತೇನೋ, ಅಥವಾ ಇವನ್ ಜೊತೆ ಯಾರು ಜನ ಬಂದಿದ್ದಾರೆ, ಎಷ್ಟು ಜನ ಬಂದಿದ್ದಾರೆ, ಇವ್ ನನಗೆ ಒಂದೇ ಹೊಡ್ತಾ ಇಲ್ಲಿ ಹೊಡ್ದ, ಎರಡನೇ ಹೊಡ್ತಾ ಇಲ್ಲಿ ಹೊಡ್ದ ಅಂತ ನಾನು ಎಣಿಸ್ಕೊಳ್ತಾ ಇರ್ತೇನೋ, ಏನ್ ಮಾಡ್ತೇನೆ? Who will be the better position, in a better person?
It is the victim, Malad's PW1 complainant, Malad's who was subjected to Malad's sexual assault. She has to give a specific word tax in this regard. I'm reading of the evidence of PW1. May I request Malats kindly permit me to read the evidence of PW1, Malats?
ಓದೋದ್ ಬೇಡ, ಏನ್ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ ಹೇಳಿ. ಈಗ ನಾನೇ ಹೇಳಿಲ್ವೇ, ನೀವು ಓದೋದಲ್ಲ. ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಎಷ್ಟು ಲೈನ್ ಅಲ್ಲಿ ಏನಿದೆ ಅಂತ ನಾನು ಹೇಳ್ತಿದ್ದೇನೆ. ಹೇಳಿ, ಏನ್ ಹೇಳ್ತೀರಿ?
Malats, in the PW1, Malats, in the examination chief, Malats say, Malats, on the date of incident, Malats, the accused, along with some other persons, Malats, which I, with their address and the names I do not remember because they were strangers to me. The accused, Malats, main accused, sole accused, Malats, he was related to me, Malats, she admits that the relationship is not disputed. Nama atte maga agbeku ante Malats, relationship is not disputed. But taking advantage of the relationship, Malats, unlawfully, Malats, trespassed into the house of the PW1 with an intention to outrage her modesty and committed the offense. Malats, PW1, Malats, speaks about the same, Malats, about this, Malats, and though this witness was cross-examined, Malats, in the cross-examination, Malats, those our
ನೀವು ಪ್ರಶ್ನೆ ಬಿಟ್ಟು ಎರಡನೇ ಟಾಪಿಕ್ ಹೋಗ್ತಾ ಇದ್ದೀರಿ. ಎಷ್ಟು ಜನ ಬಂದಿದ್ರು? ಹೌ ಮೆನಿ ಅಕ್ಯೂಸ್ಡ್ had come? ಆ ಬಗ್ಗೆ ಅಲ್ಲಿಗೆ ಬಿಟ್ರಿ. ಐ ಕೆನಾಟ್ ಇಂಪ್ರೂವ್ ದ ಕೇಸ್ ಅನ್ನೋದ್ರಲ್ಲೇ ಬಿಟ್ರಿ. ನಾನು ಇಂಪ್ರೂವ್ಮೆಂಟ್ ಆಫ್ ದ ಎವಿಡೆನ್ಸ್ ಕೇಳ್ತಾ ಇಲ್ಲ. Presentation of the case by a learned counsel ಕೇಳ್ತಾ ಇದ್ದೇನೆ.
According to the complainant, let's 3 ರಿಂದ 4 ಜನ ಬಂದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ, but their identity or their names, whereabouts, Malats, that is not disclosed in the complaint. But her allegation is only against this accused and not against those persons. They just
PW1 ಕೊಡಿ.
PW1 evidence.
PW1 first page.
Yes, madam.
8th line.
8th line, madam. ನಾನು ಆತನಿಗೆ ಇಷ್ಟ ಇಲ್ಲ ಎಂದು ಹೇಳಿದೆ. Is it that sentence, madam? ನಾನು ಇಷ್ಟ ಇಲ್ಲ ಎಂದು ಹೇಳಿದೆ.
The line beginning, ಅದರಿಂದ ಎರಡನೇ ಲೈನ್.
ಅಲ್ಲಿಂದ ಚಾಸ 2 ಮತ್ತು 3 ನನ್ನನ್ನು ಬಿಡಿಸಲು ಬಂದಾಗ ಆರೋಪಿ ಮತ್ತು ಜೊತೆಯಲ್ಲಿದ್ದವರು ಅವರನ್ನು ಜಾಡಿಸಿ ತಳ್ಳಿದರು.
Whether the accusation or allegation is only against the accused?
Allegations, Malats, is only against this present accused.
ಮತ್ತೆ ಅದರ ಅರ್ಥ ಏನು? ಆರೋಪಿ ಮತ್ತು ಜೊತೆಯಲ್ಲಿದ್ದವರು ಜಾಡಿಸಿ ತಳ್ಳಿದರು.
ಅವರನ್ನು ಜಾಡಿಸಿ ತಳ್ಳಿದರು. ಅವರನ್ನು means, Malats, Malats, the persons who came with the accused, Malats, they tried to pacify and they tried to pull the accused.
ನೀವು ಬಹುಶಃ ಸರ್ಕಾರಿ ಕನ್ನಡ ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆಗೆ ಹೋಗ್ಬೇಕು. ಕನ್ನಡವನ್ನು ಓದುವುದು ಹೇಗೆ, ಅರ್ಥಿಸಿಕೊಳ್ಳುವುದು ಹೇಗೆ, ಅವನು ಬಸವ ಅವಳು ಕಮಲ, ಪಾಠ 1, ಕನ್ನಡ ಪಠ್ಯ ಪುಸ್ತಕ. ಆ ಸೆಂಟೆನ್ಸ್ ಬಿಗಿನಿಂಗ್ ಇಂದ ಓದಿ.
ಚಾಸ 2, 3 ರವರು ನನ್ನನ್ನು ಬಿಡಿಸಲು ಬಂದಾಗ,
ಚಾಸ 2 ಮತ್ತು 3 ರವರು ನನ್ನನ್ನು ಬಿಡಿಸಲು ಬಂದಾಗ ಆರೋಪಿ ಮತ್ತು ಜೊತೆಯಲ್ಲಿದ್ದವರು ಅವರನ್ನು ಜಾಡಿಸಿ ತಳ್ಳಿದರು. ಅಂದ್ರೆ ಕೋ ಅಕ್ಯೂಸ್ ನ ತಳ್ಳಿದ್ರ? ಚಾಸ 2, 3 ಅಲ್ವಾ ತಳ್ಳಿದ್ದು?
Here she refers to
ಅಲ್ವೇ? ಮತ್ತೆ
He refers
ಏನೋ
to
ಒಂದು
PW.
ಕೋರ್ಟಿಗೆ ಏನೋ ಒಂದು ಹೇಳಿಬಿಟ್ರೆ ಸಾಕು.
Refers to PW 2 and 3 my lord. ಅವರನ್ನು ಜಾಡಿಸಿ ತಳ್ಳಿದರು.
ಅಲ್ವೇ?
As a result my lord, they also
ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಯಾಕೆ ಇಲ್ಲದೆ ಇರೋದು ಏನೋ ಇದೆ ಅಂತ ಹೇಳಿ ಒಟ್ಟಿನಲ್ಲಿ ಕೋರ್ಟ್ ನಾವು ಏನೋ ಹೇಳಿದ್ವಿ ಅಂತ ಆಗ್ಬೇಕು, ಕೋರ್ಟ್ ಮುಂದೋಗ್ಬೇಕು, ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗಿಸಿದೆ ಅಂತ ಆದ್ರೆ ಸಾಕು. ಆ ಮನೋಭಾವದಲ್ಲಿ ಯಾಕಿರ್ತೀರಿ? ಅಲ್ವೇ? Allegation is there against the other accused also.
Reference is
When there is an allegation, not only against the charge sheeted accused, even against others also. And this allegation was there at the earliest point of time in the complaint also.
yes.
Why did the investigating officer did not arrange these other accused as accused?
So probably because that my lords, the investigation officer my lord did not get any.
ಅದನ್ನ ಯಾಕೆ ಕೇಳಬೇಕಿತ್ತಲ್ವೇ?
ಹಾ, yes.
ಆಫೀಸರ್ ಕೇಳಬೇಕಿತ್ತಲ್ವೇ? ಅವ್ರು ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ ಕಾಲಂ ನಂಬರ್ 13 ನಲ್ಲಿ
Yes. Lords,
ಚಾರ್ಜ್ ಶೀಟ್ ಮಾಡದೇ ಇರುವ ಆರೋಪಿಗಳ ವಿವರ ಬರ್ದಿದ್ದಾರ ನೋಡಿ.
That is not challenged in the cross examination also my lords. So kindly permit me to read the evidence of the investigation officer my lords PW. They have not challenged that.
ಅದನ್ನ ಕೊಡ್ತೇನೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಲಂ ನಂಬರ್ 13 ನೋಡಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಮಾಡದೇ ಇರುವ ಆರೋಪಿಗಳ ವಿವರ ಏನ್ ಬರ್ದಿದ್ದಾರೆ ಅದರಲ್ಲಿ?
Permit me to take the.
ಇಸ್ಕೊಳ್ಳಿ.
Probably my lords, because the IO did not get any material against the other accused my lords to implicate them in the charge sheet. Therefore my lords,
ಇರಬಹುದು ಅನ್ಕೊಳ್ಳುವ ಫಾರ್ ದ ಮೂಮೆಂಟ್. ಆದರೆ ಅದನ್ನ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಪ್ರಾಬಬಲಿ ಅಂತ ಅವ್ರು ಪ್ರಿಸ್ಯೂಮ್ ಮಾಡ್ಕೊಳ್ಬೇಕು, ಅಥವಾ ಅಸ್ಯೂಮ್ ಮಾಡ್ಕೊಳ್ಬೇಕು, ಅಥವಾ ಯಾವಾಗ ಯಾರು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಅದೇ ವ್ಯಕ್ತಿಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಾಕ್ಷಿ ಅಂತ ಅದೇ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಎದುರು ನಿಂತಾಗ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಆತನ ಕೇಳ್ಬೇಕು. ಅಯ್ಯ ಕಂಪ್ಲೇಂಟ್ ಇದ್ದಿದ್ದು 5 ಜನರು ಇದು, ನೀನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರೋದು ಒಬ್ರು ಇದು. PW1 ಆಕೆಯ ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿಯೂ ಕೂಡ ಮನೆಗೆ ಬಂದು ತನ್ನೆದುರು ಈ ಅಲಿಜಿಡ್ ಕ್ರಿಮಿನಲ್ ಅಫೆನ್ಸ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ವ್ಯಕ್ತಿ ಒಬ್ಬರಾಗಿರ್ಲಿಲ್ಲ, 4 ಜನ ಆಗಿದ್ರು ಅಂತ ಆಕೆ ತನ್ನ ಸಾಕ್ಷ್ಯದಲ್ಲೂ ಹೇಳಿದಾಳೆ. ನೀನು ಚಾರ್ಜ್ ಶೀಟ್ ಒಬ್ಬರೇ ಅಗೇನ್ಸ್ಟ್ ಮಾತ್ರ ಮಾಡಿದ್ದಿ, ಉಳಿದಿರೋ ಆರೋಪಿಗಳ ಹೆಸರು ಅಥವಾ ಅವ್ರ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ನಿನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿಯೂ ತೋರಿಸಿಲ್ಲ. ನಿನ್ನ ತನಿಖೆನ ಎಷ್ಟು ಮಟ್ಟಿಗೆ ನಂಬಬಹುದು? ಹೌ ಡು ಯು ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್? ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಕ್ಯೂಸ್ಡ್ ಅದನ್ನ ಕೇಳಿ ಎಂಬರೇಜ್ ಆಗಿದ್ದಕ್ಕಿಂತ ಮುಂಚೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅದನ್ನ ಕೇಳಿ ಉತ್ತರ ತಂದ್ಬಿಟ್ರೆ
yes, the prosecutor could have clarified in the chief examination itself.
ಅಲ್ವೇ? ಮತ್ತೆ ಪ್ರಾಬಬಲಿ ಹಿ ಮೈಟ್ ನಾಟ್ ಹ್ಯಾವ್ ಫೌಂಡ್ ಎನಿ ಮೆಟೀರಿಯಲ್ ಅಗೇನ್ಸ್ಟ್ ದಮ್ ಅನ್ನೋದನ್ನ ನೀವು ಹೇಗೆ ಈಗ ಪ್ರಿಸ್ಯೂಮ್ ಮಾಡ್ತೀವಿ? ಮೆಟೀರಿಯಲ್ ಸಾಕ್ಷಾತ್ ನೀವೇ ಹೇಳಿದ್ರಿ ಈಗ 1.5 ನಿಮಿಷದ ಹಿಂದೆ. The evidence of the victim has to be given priority. ಆ ವಿಕ್ಟಿಮ್ ಹೇಳಿದಾಳೆ 4 persons had come.
Yes.
How to believe that the investigation has been conducted correctly in this matter?
Both the courts, my lords, my submission, my lords, both the courts, my lords, concurrently held, my lords, the investigation conducted by the investigation officer and the ocular evidence adduced by the prosecution, my lords, also proves the crime connecting to the accused beyond reasonable doubt and rightly convicted the accused. My lord, the appellate court also confirms with the findings and observations of the trial court. My lords, all this, my lords.
ಅವಾಗ ನಾನು ಏನ್ ಹೇಳಿದೆ, ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಬತ್ತಳಿಕೆಯಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು 8 ರೆಡಿಮೇಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಆಸ್ ಎ ಫಾರ್ಮ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ, ಇದು 9ನೇ. ಅಲ್ಲಿ ರಿವಿಷನ್ ಬಂದಿರದೇ ಕೆಳಗಡೆ ಕೋರ್ಟ್ನವ್ರು ಎರಡೂ ಸರಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ನಾವು ಹಾಗೆ ಬರೆಯೋದಾಗಿ ಬಿಟ್ರೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟು ಸೆಷನ್ಸ್ ಕೋರ್ಟು ಎರಡೂ ಕೂಡ ಕನ್ವಿಕ್ಷನ್ ಅಂತಾನೆ ಆಗಿ ಬಿಟ್ಟಿದೆ. ದೇರ್ ಫೋರ್ ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಇಂಟರ್ಫಿಯರ್ ಅಂತ ಬರೆದ್ರೆ ಅವ್ರು ರಿವಿಷನ್ ಬರೋ ನೆಸೆಸಿಟಿ ಎಲ್ಲಿದೆ?
Here, my lords, the evidence of my lord, the witnesses, that's particularly my lords, this PW 1, 2 and 4, 1, 2 and 4, that's corroborates with the evidence of PW 1. That's this evidence, my lords, fully further corroborates with the evidence.
Whose evidence corroborates evidence of PW 1?
With the 2 and 4.
2 and 4. Yes.
My lords, the evidence of these three witnesses. Let's further corroborates with the evidence of the eyewitness PW3. And this evidence also further corroborates with the evidence of investigation officer and the doctor.
See, evidence of PW214 apart from corroborating the evidence of PW1 also corroborates the evidence of PW3. What is the evidence of PW?
PW3, according to the prosecution, that's he is one of the eyewitness to the incident. He says, that's immediately. May I read, Miller? May I read? I'll just submit.
Please.
That's he was the resident of that area, and there was a loud voice there was going on in the house of the complainant. And on hearing the loud voice, the others also got away, and he told me to go to the spot of incident. As a result, he went there. He find the accused came out of the house and ran away.
Exactly. Stop here. This is the crux now. This is the crux now. Even according to you, PW3 is the independent witness.
Yes.
The independent witnesses evidence is corroborated by PW2 and PW4.
Please.
According to PW2 and PW4, how many accused were there? How many accused have committed offense? PW2 and PW4.
Yes, according to PW2 and 4, this accused came along with other persons.
Please.
May I read the evidence? PW2, my lords.
Odi.
14/3/2008 ಮಧ್ಯಾಹ್ನ 2 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಾನು ಚಾಸ 1 ಮತ್ತು 3 ನನ್ನ ತಂದೆಯ ಮನೆಯಲ್ಲಿರುವಾಗ ಆರೋಪಿ ನಮ್ಮ ಮನೆಯ ಒಳಗೆ ಬಂದ. ಆರೋಪಿ ನನ್ನ ತಂಗಿ ಚಾಸ ಅವರನ್ನು ಕುರಿತು ನನ್ನನ್ನ ಮದುವೆ ಆಗ
ಎಷ್ಟು ಜನ ಬಂದ ಅಂತ ಹೇಳಿದ್ದಾರೆ?
ಆರೋಪಿ
ಅಲ್ವೇ? ಒಬ್ಬನೇ. ಆಕೆ ತನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲೂ ಬಂದಿದ್ದು ಒಬ್ಬನೇ ಅಂತ ಹೇಳಿದ್ದಾಳೆ ನೋಡಿ.
ಪೇಜ್ 2 ನಲ್ಲಿ ಆ ದಿನ ಆರೋಪಿ ನಮ್ಮ ಮನೆಗೆ ಒಬ್ಬನೇ ಬಂದ.
ಅಲ್ವೇ? ನೀವು ಕೇಸನ್ನು ಓದಿ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ಬೇಕಾದವರು ನೀವು ಸರಿ ಏನ್ ಎವಿಡೆನ್ಸ್ ನೋಡಲ್ಲ, ಅವರು ಸರಿ ಏನ್ ಎವಿಡೆನ್ಸ್ ಅಂತ ನೋಡಲ್ಲ, ನಾನ್ ನೋಡ್ಬೇಕು. ಈಗ ಆಕೆ ಹೇಳ್ತಿರೋದು ಒಬ್ಬಳೇ ಬಂದ, ಒಬ್ಬನೇ ಬಂದ ಆರೋಪ. PW4 ಎಷ್ಟು ಜನ ಬಂದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ?
According to PW4 also, ಆಗ ಆರೋಪಿ ಮನೆ ಒಳಗೆ ಬಂದು.
ಅಲ್ವೇ? ಅವ್ರ ಪ್ರಕಾರ ಒಬ್ಬನೇ
ಆರೋಪಿ ಮನೆ ಒಳಗಡೆ ಬಂದು ಚಾಸ 1 ಹಿಡಿದು ಹೇಳ, ನನ್ನ ಮದುವೆ ಆಗು ಹೇಳ್ತಿದ್ದ, ನಿನ್ನ ಕೊಲೆ ಮಾಡುತ್ತೇನೆ ಕಿರಿಚಿಕೊಂಡೆವು, ನನ್ನನ್ನು ತಪ್ಪಿದ, ಕೆಳಗೆ ಬಿದ್ದ.
ಎಷ್ಟು ಓದಿದ್ರು ಅಷ್ಟೇ. ಇದು ಆಕೆ ಹೇಳಿರೋದು ಆರೋಪಿ ಒಬ್ಬನೇ, ಆರೋಪಿ ಒಬ್ಬನೇ. ನಿಮ್ಮ ಪ್ರಕಾರ ಎವಿಡೆನ್ಸ್ ಆಫ್ PW2 and PW4 corroborates the evidence of independent witness PW3.
Except this.
ಈಗ ತ್ಯಾಪೆ ಹಾಕಕ್ಕೆ ಹೋಗ್ಬೇಡಿ. ಈಗ ಇಂಡಿಪೆಂಡೆಂಟ್ ವಿಟ್ನೆಸ್ PW3 ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಪೇಜ್ 1 ಲೈನ್ 4 ಓದಿ. ಪೇಜ್ 1 ಲೈನ್ 4.
ಆಗ ಆರೋಪಿ ದೇವರಾಜ ಮತ್ತಿಬ್ಬರು
ಒಳಗಿನಿಂದ ಹೊರಗೆ ಓಡಿ ಹೋದರು.
ಮನೆಯಿಂದ ಓಡಿ ಹೋದರು. ನಾವು ನೋಡಿದಾಗ ಚಾರ್ಜ್
ಅಲ್ವೇ? ಅಂದ್ರೆ ನಿಮ್ಮ ಪ್ರಕಾರ ಬೆಸ್ಟ್ ವಿಟ್ನೆಸ್ ಈಸ್ ದಿ ವಿಕ್ಟಿಮ್ herself. She has said 1+3. The independent witness who claims to have seen the witness evidence, the incident from outside says accused plus 2 more persons ran away. ಓಡಿ ಹೋಗು ಎಂದು ಕೂಗಿದಾಗ 3 ಜನ ಓಡಿ ಹೋಗು. PW2 and PW4 said only 1%. Yes, other point, next point, please.
The fact that the PW1, PW1 and 2, sustained injuries, not in dispute. PW1 and 2 also says, and PW doctor PW7 also says on the very same day they came to my clinic, took treatment, and he noticed the following injuries. Accordingly, he has issued exhibit P5, and he also mentioned the injuries in the wound certificate issued by him. So therefore, the prosecution.
You set of answers. How do you prove 448? He is convicted for 448
Yes,
also.
448.
Yes. He has read the evidence. ಆರೋಪಿ ನನ್ನ ಅತ್ತೆ ಮಗ.
Relationship, I am not disputing.
ಅವನು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಇದ್ದು ಓಡಾಡಿ ನಮ್ಮ ಸಣ್ಣ ಪುಟ್ಟ ಕೆಲಸಗಳನ್ನು ಮಾಡಿಕೊಂಡು ಓಡಾಡಿಕೊಂಡಿದ್ದ.
ಅದನ್ನು ಇಲ್ಲ ಅಂತಾನು ಹೇಳ್ತಾರೆ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಲ್ಲ ಅಂತಾನು ಹೇಳ್ತಾರೆ. ಇಲ್ಲ ನಮ್ಗವ್ರ ಸಂಬಂಧ ಇಲ್ಲ, ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ ಅಂತಾನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಆದ್ರೆ ಅದೇ ವಿಕ್ಟಿಮೆ ಹೇಳಿದಾಳೆ ಒಂದು ಕಡೆ
ಹೇಳ್ತಾರೆ.
ಮತ್ತೆ ಆರೋಪಿ ನಮ್ಮ ಮನೆಯಲ್ಲೇ ಇದ್ದುಕೊಂಡು ಸಣ್ಣ ಪುಟ್ಟ ಕೆಲಸಗಳನ್ನು ಮಾಡಿಕೊಂಡು ಓಡಾಡಿಕೊಂಡಿದ್ದ.
It's because that he is related and he is residing along with the PW1. It does not permit him to take the offense into his hands and commit an offense.
ನಾನು ಕೇಳ್ತಾರೆ 448. ನೀವು ಸುಮ್ಮನೆ ಬರೀ ಜನರಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಗಳನ್ನೇ ಹೇಳ್ಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗಿಸ್ಬೇಡಿ.
I understood.
How do you prove 448 ಅಂತ ಹೇಳಿದ್ರೆ ಆ ಸೆಟ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇರ್ತಾರಲ್ಲ ಅದೇ ರಿಪೀಟ್ ಮಾಡ್ತೀರಿ. ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳ್ತಾ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡ್ತಾ 35 ಜನ ವಕೀಲರು ಹಿಂದೆ ಕೂತಿರ್ತಾರೆ. ನೋಡಪ್ಪ ಕೋರ್ಟ್ ಈ ಪಾರ್ಟಿ ಹೇಳ್ತಾ ಹೋದ್ರೆ ಈ ವಕೀಲರು ಹಾಗೆ ಮಾಡ್ತಾರೆ ಅನ್ನೋ ಭಾವನೆ ಬರಬಾರ್ದು ಯಾರಲ್ಲೂ. 448 ನಾನು ಕೇಳ್ತಾ ಇದ್ದೇನೆ. ಇಟ್ಸ್ ಎ ಕ್ರಿಮಿನಲ್ ಟ್ರೆಸ್ಪಾಸ್.
Yes.
ಅವ್ರ ಮನೆಯಲ್ಲೇ ಇದ್ದುಕೊಂಡು ಸಣ್ಣ ಪುಟ್ಟ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ಓಡಾಡ್ಕೊಂಡಿರೋನು ಟ್ರೆಸ್ಪಾಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಗೆ ಸಾಧ್ಯ?
Cross examination, she also denies, but in the chief, she also admits.
ಹೌದು, ಅದೇ ವಿಕ್ಟಿಮು ಎರಡನೇ ರೀತಿ ಉತ್ತರ ಕೊಟ್ಟಿದ್ದಾಳೆ ಅಂದ್ರೆ ಬೆನಿಫಿಟ್ ಯಾರಿಗೆ ಹೋಗ್ತದೆ? ನ್ಯಾಚುರಲಿ
if two views are possible, naturally
ಅಲ್ವೇ?
one favoring in favor of the.
ಮತ್ತೆ 448 ಏನಾಗುತ್ತೆ?
The evidence of PW1 is inconsistent insofar as the lordship's question is concerned. She also admits, she also denies that is, and for two, as the lordship said, that if two views are possible, then the benefit.
Whether the doctor has sent MLC to police stations. ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ.
Evidence ಅಲ್ಲಿ
ಮತ್ತೇನ್ ನೋಡ್ತಾ ಇದ್ದೀರಿ?
Just examined the injured and issued the wound certificate.
And he was aware that the injured was brought before him with a history of assault.
Yes, he collects the history. But the history that was given before the doctor is that around 2:30 around 2:30 p.m. on 14/3/2008, Malegoda Koppulo at her home, when the Devraj and 4 others came to her house with intention of tying a thali to her sister, where he went, there is a underwent minutes. That's underwent the injuries. That's the history. And the next
So it's a medical legal case. Doctor knew that.
Yes.
Then why did he not inform the police about a medical legal case? Then how do you say that the trial court and first appellate court judgments are sound and does not warrant any interference? You yourself is conceding that there are several variations.
Right of variations, Malats, both the courts, Malats found that there are material to connect the accused, and the prosecution beyond reasonable to prove the crime to connecting to the accused, and therefore Malats, with the existing material, Malats, both the courts, Malats, concurrently and consistently holds that there are material to convict the accused, Malats. Therefore, Malats.
ಅದೇ ಇದು ಹೇಳಿದ್ನಲ್ಲ, ಸುಖವಾದ ಸಾರಾಂಶದ 12 ಸೂತ್ರಗಳು, ಅದರಲ್ಲಿ 9ನೇ ಸೂತ್ರ. ಅದನ್ನೇ ಹೇಳಿದ್ರಾಯ್ತು. ಎಸ್, ಎನಿ ರಿಪ್ಲೈ? ನೋ ರಿಪ್ಲೈ. ಎಸ್, ನಿಮ್ಮ ಕ್ವಶನ್ಗಳು ಸುಮಾರಷ್ಟಿತ್ತು. ಬೆಳಗ್ಗೆ ನಿಮ್ಮ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಯ್ತು, ಈಗ ಇವರದ್ದಾದಷ್ಟೇ. Counsels from both sides present, third arguments from both sides. Order reserved. Yes. Yes.
Serial number 46, R. Nageswara Nayak, respondent SCJP.
Yes, please. That is one of the argument for which you answer this question.
One major argument is that due to the mechanical defect, the accident. So steering got displaced. Because of that reason, he has lost control of the bus, therefore accident. So that aspect, the motor vehicle inspector has been examined, and here and also cross-examined. In that region, by the cross-examination very clearly stated that there is no the cross-examination BW30.
ಹೇಳಿ, ಅದರಲ್ಲಿ ಏನ್ ಹೇಳಲಿಲ್ಲ ಅಥವಾ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಹೇಳಿ.
ಸ್ಟೇರಿಂಗ್ ಕಟ್ ಆಗಿತ್ತು, ಆದ್ರಿಂದ ನಮ್ದು ಆಕ್ಸಿಡೆಂಟ್ ಕಂಟ್ರೋಲ್ ತಪ್ಪಿತ್ತು, ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ. ಅದಕ್ಕೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆ ಕ್ವಶನ್ ಇವ್ರಿಗೆ ಕೇಳಿದ್ದಾರೆ, ಅದು ನಾನು ಆ ಕ್ವಶನ್ ಡಿನೈ ಮಾಡಿದ್ದೆ. ಅಪಘಾತ ಆಗಿದ್ದ ಬಸ್ಸಿನ ಸ್ಟೇರಿಂಗ್ ಪೂರ್ಣ ಕಿತ್ತು ಬಂದಿದ್ದರಿಂದ ಬಸ್ ಅನ್ನು ಹತೋಟಿ ತೆಗೆದುಕೊಳ್ಳಲು ಆಳವಾಗಿದ್ದ ಸಾಮಾನ್ಯ ಹುಡುಗಿಗೆ ಅಪಘಾತ ಇದೆ, ಸರಿಯಲ್ಲ ಅಂತ ಹೇಳಿ. Therefore, the prosecution in that regard also prove the case of
Has the motor vehicle inspector has verified the condition of the steering of the bus and mentioned about its condition in his report? ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ. There is a specific mentioning about the condition of the steering also. Has he answered that question number 6? 837 ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಎಲ್ಲದಕ್ಕಿಂತ ಎಂಡು. ಎಸ್ But has he answered this specific question? K11. ನಿಮ್ಮ ಅಡಿಗೆ ಮನೆ ಸ್ಟೋರ್ ರೂಮ್ಗಳನ್ನ ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ. ಮನೆಗೆ ಬಂದ ಅತಿಥಿಗಳಿಗೆ ನೀವೇ ಕಾಫಿ ಮಾಡಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಅತಿಥಿಗಳು ಬಂದು ಕೂತ್ರ ಮೇಲೆ ಕಿಟಕಿಯಿಂದ ಪಕ್ಕದ ಮನೆಯಿಂದ ಕಾಫಿ ಪುಡಿ ಸಕ್ಕರೆ ಇಸ್ಕೊಳ್ಳೋದನ್ನ ಅಭ್ಯಾಸ ಬಿಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ? ಹೇಳಿ ಹೇಳಿ ಹೇಳಿ. ಎಕ್ಸಿಬಿಟ್ P37 K11 ಸ್ಮಾಲ್ ರೋಮನ್ 11. ಎಸ್ K11. K for king. ಏನಾದ್ರು ಹೇಳಿದ್ದಾರ ಅದಕ್ಕೆ?
Components of the vehicles are in order. In order. ಅದರ ಮೆಕ್ಯಾನಿಸಮ್ ಮೇಲೆ ಅದರ ಮೇಲೆ
ಏನು ಹೇಳಿ? How do you overcome that? Their defense is that the steering was detached. As such, he lost the control.
They have put the cross examination. Whether there are chances of steering cut ಆದರೆ ಚಾನ್ಸ್ ಆಫ್ ಇದೆ
ಅಲ್ರಿ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾಗಿರೋದು ಅಕ್ಯೂಸ್ಡ್ ಗಿಲ್ಟ್ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾಗಿರೋದು ನೀವ, ಅಕ್ಯೂಸ್ಡ್ ಇನ್ನೋಸೆನ್ಸ್ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾಗಿದ್ದವ್ರ. ಮತ್ತೆ ಒಳ್ಳೆ ಕಥೆ ಆಯ್ತಲ್ಲ ಇದು. ಅವ್ರ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಡಾಕ್ಯುಮೆಂಟ್ ನಿಮ್ಗೆ ಕೊಟ್ಟು ನಿಮ್ಮ ಹತ್ರನೇ ಹೇಳಿಸ್ಕೊಳ್ಳೋದು ಅಂದ್ರೆ ಎನಿ ರಿಪ್ಲೈ?
Few citations.
For what?
For attracting 304A, there should be proxima nexus and causa causa.
All that has been canvassed already. No new principles are there.
Yes, my lord. My only humble submission is that criminal negligence
It is
cannot
not
be
the
attributed.
case the way the accident has happened one day and after a couple of months the person died.
Yes, ma'am.
Immediately all the 3 dead bodies were found beneath the bus only.
Yes, my lordship. And one more thing is that ration negligence has not been proved beyond reasonable doubt to attract criminal liability. For that also there's a.
There's only reply now.
Yes, my lordship. I'm just summing up the arguments. The ration is the degree of criminality.
From both sides. Our argument from learned counsel for the respondent for and the reply. Orders reserved. Yes.
Seal number 47. Yes, Javed, amicus curiae.
Here for the petitioner. Offense is under section 457 and 380 millions. Prosecution has cited complainant witnesses 23 millions. Only 11 witnesses have been examined.
ದೇವರ ದೀಪ ದೇವರ ಕಳಸ ಅಂದ್ರೆಲ್ಲ ಗೊತ್ತಾನೆ. Yes.
Trial court has convicted lots for 1 year for the offence punishable under section 457 and 1 year for 318 lots. PW 1, 2, 5 and 10 are the punch witnesses lots.
PW
1, 2, 5 and 10 lots. 1, 2, 5 and 10.
1, 2, 5, 1.
1, 2, 5 and 10 lots.
10. Yes.
To read the PW1 lots. Page number 45 lots. Here, my lord, the witnesses deposes that the incident of the theft, my lords, PW4, who is the police officer, my lord, who was on duty of guest, my lord, on the said day, my lords, he has seen the
Yes.
Permitted to read the cross-examination of PW1 minutes.
Yes.
Dated 2010-2011 minutes.
Yes.
CP 1ರಲ್ಲಿ ಪೊಲೀಸರು ಏನೆಲ್ಲ ಬರೆದಿದ್ದಾರೆ ಎಂದರೆ ಗೊತ್ತಿಲ್ಲ ಎಂದರೆ ಅದು ಸರಿ. ಪೊಲೀಸರು ಬರೆದುಕೊಂಡಿದ್ದು ನನಗೆ ಸಹಿ ಮಾಡಲು ಹೇಳಿದ್ದಾರೆ, ಸಹಿ ಮಾಡಿದ್ದೇನೆ. P1 is the Caesar Mahazar, that's Pancham notes. Exhibit P1 is the spot Mahazar, my lord. He is the signatory to the spot Mahazar, who deposes that I have sent the said spot Mahazar in the police station, my lords, and I have not no knowledge the contents of the exhibit P1, my lords. The same is deposed by the PW2, my lords. Cross-examination of the PW2, my lords. Second line, my lords. CP 1ರಲ್ಲಿ ಪೊಲೀಸರು ಏನೆಲ್ಲ ಬರೆದಿರುತ್ತಾರೆ ಎನ್ನುವುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದರೆ ಅದು ಸರಿ. CP 1ಕ್ಕೆ ಪೊಲೀಸರು ಸಹಿ ಮಾಡಲು ಹೇಳಿದ್ದರಿಂದ ನಾನು ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ. PW3, my lords, who speaks about the ornaments, my lord, and said to be his father has gifted the said ornaments to the goddesses, my lords. And subsequently he has identified the said ornaments, my lord, which is marked as MO1 and 2, my lords. Eyeballs of the goddesses, my lords. PW4, my lords. The police sub-inspector, my lord, who was on duty on the said day on the guest, my lords, he deposes that he has arrested the accused, my lords. He will be permitted to read his depositions, my lord. ದಿನಾಂಕ 24/11/2010 ರಿಂದ so and so ರವರೆಗೆ ನಾನು ಚಳ್ಳಕೆರೆ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ PSI ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುತ್ತೇನೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಸಂಬಂಧದಂತೆ ದಿನಾಂಕ so and so ರಂದು ರಾತ್ರಿ ರಾಣೆ ಜಿಪಿನಲ್ಲಿ ಗಸ್ತು ಕೆಲಸ ಹೋಗಿರುತ್ತೇನೆ. ಚಳ್ಳಕೆರೆ ನಗರದಲ್ಲಿ ಕಡೆ ಗಸ್ತು ಮಾಡುತ್ತಿರುವಾಗ ಸ್ಥಳಕ್ಕೆ ಹಿರಿಯೂರು ಚಿತ್ರದುರ್ಗ ಕಡೆಗೆ ಗಸ್ತು ಮಾಡುತ್ತಿರುವಾಗ ಕೆಇಬಿ ಹತ್ತಿರ ಬೈಕಿನಲ್ಲಿ ಬಂದು ಇಬ್ಬರು ವ್ಯಕ್ತಿಗಳನ್ನು ನೋಡಿದೆ. ವಿಚಾರಿಸಿ ಬಾಕ್ಸ್ ನಲ್ಲಿದ್ದ ಕಟ್ಟುತ್ತೇನೆ ಎಂದು ಹೇಳಿದರು. ನಂತರ ಅಲ್ಲಿಯೇ ಹೋದರು. ನಾನು ಈ ವಿಚಾರವನ್ನು ರಾಣೆಗೆ ತಿಳಿಸಿರುತ್ತೇನೆ. ನಂತರ ರಾಣೆ ಸಿಬ್ಬಂದಿಗಳು ಹಾಗೂ ನನ್ನ ಸಿಬ್ಬಂದಿಗಳು ಸಹ ಸೇರಿ ಒಬ್ಬ ವ್ಯಕ್ತಿಗಳನ್ನು ಹಿಡಿದಿರುತ್ತೇವೆ. ಆತನ ಹೆಸರು ವಿಚಾರಿಸಿ ಕೇಳಿದಾಗ ಯರಿಸ್ವಾಮಿ ಚನ್ನಪ್ಪ ಎಂದು ತಿಳಿಸಿದರು. ಆತನನ್ನ ಕರೆದುಕೊಂಡು ಬಂದು ಸಿಪಿಐ ರವರ ವಶಕ್ಕೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಸಿಪಿಐ ರವರು ಮುಂದಿನ ವಿಚಾರಣೆ ತನಿಖೆ ಪ್ರಕರಣಗಳನ್ನು ಸಂಬಂಧಿಸಿದಂತೆ ರವರಿಗೆ ನನ್ನ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತೇನೆ. ಆ ದಿನ ನಾವು ಹಿಡಿದ ಆರೋಪಿಗಳು ನ್ಯಾಯಾಲಯ ಮುಂದೆ ಇರುವ ಆರೋಪಿಗಳನ್ನು ನೋಡಿ ಗುರುತಿಸಿರುತ್ತೇನೆ. ಪಾರ್ಟಿ ಸವಾಲು ಶ್ರೇಯಾಂಶು. ಸದರಿ ದಿನ ನಾನು ರಾಣೆಗೆ ಜೀಪಿನಲ್ಲಿ ಗಸ್ತು ಎಂದು ನಾನು ಹೋಗು ಇಬ್ಬರು ಸಿಬ್ಬಂದಿಗಳು ಹೋಗಿರುತ್ತೇನೆ. ಆ ಕಾಲಕ್ಕೆ ಜೀಪಿನ ಚಾಲಕನ ಮಹಂತೇಶ್ ಎಂಬುವರು ಇದ್ದಿರುತ್ತಾನೆ. ನಗರದಲ್ಲಿ ಎಲ್ಲ ಕಡೆಗೆ ಸಹ ಗಸ್ತು ಮಾಡಿಕೊಂಡು ನಾವು ಕೆಇಬಿ ಹತ್ತಿರ ಬಂದಿರುತ್ತೇವೆ. ಮಧುಗಿರಿ ನಗರಕ್ಕೆ ಎಷ್ಟು ಗಂಟೆ ಭೇಟಿ ಕೊಟ್ಟಿರುತ್ತೇನೆ ಎಂದು ಸಮಯ ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ನಾನು ನಗರ ಸೇರಿದ ವ್ಯಕ್ತಿ ಬಳ್ಳಾರಿ ರಸ್ತೆ ಹಾಗೂ ಚಿತ್ರದುರ್ಗ ರಸ್ತೆಯಲ್ಲಿ ಕೆಇಬಿ ಹತ್ತಿರ ಗಸ್ತು ಮಾಡಲು ಬಂದಿರುತ್ತೇನೆ. ಮೇಲೆ ಹೇಳಿದ್ದ ಸ್ಥಳಕ್ಕೆ 10 ರಿಂದ 12 ಗಂಟೆಯವರೆಗೆ ನಾನು ಗಸ್ತು ಮಾಡಿರುತ್ತೇನೆ. ಕೆಇಬಿ ಬಳಿ ಇರುವ ಕಾಲಕ್ಕೆ ಸಮಯ 12:30 ಆಗಿರೋದು. ಕೆಇಬಿ ಹತ್ತಿರ ಮುಂಭಾಗದ ರವರಿಗೆ ರಸ್ತೆ ಆರೋಪಿಯನ್ನು ತಡೆದು ನಿಲ್ಲಿಸಿರುತ್ತೇನೆ. ಕೆಇಬಿ ಮುಂಭಾಗದ ರಸ್ತೆಯಲ್ಲಿ ನಿಲ್ಲಿಸಿರುತ್ತೇನೆ. ಆ ಸ್ಥಳದಲ್ಲಿ ಚಕ್ಕುಬಂದಿ ಹಿಡಲು ಬರುವುದಿಲ್ಲ. ಅಲ್ಲಿ ಇಬ್ಬರು ವ್ಯಕ್ತಿಗಳು ಇರುತ್ತಾರೆ. ಯರಿಸ್ವಾಮಿಯನ್ನು ನಾನು ಆ ವಾಹನದ ದಾಖಲಾತಿಗಳನ್ನು ಕೇಳಿರುತ್ತೇನೆ. ಚಾಲಕನನ್ನು ಭೇಟಿ ಕೇಳಿರುತ್ತೇನೆ. ಹಿಂದುಗಡೆ ಕುಳಿತಿರುವ ವ್ಯಕ್ತಿಯಲ್ಲಿ ಕತ್ತಲಲ್ಲಿ ಸುಮಾರು 100 ಮೀಟರ್ ಆರೋಪಿಗಳು ಓಡಿರುತ್ತಾರೆ. ಇಬ್ಬರು ಆರೋಪಿಗಳು ಸಹ ಓಡಿ ಹೋಗಿರುತ್ತಾರೆ. ಬೈಕ್ ನಲ್ಲಿ ನಿಲ್ಲಿಸಿ ಓಡಿ ಹೋಗಿರುತ್ತಾರೆ. ಹೆಲಿಪ್ಯಾಡ್ ಗ್ರೌಂಡ್ ಬಳಿ ಆರೋಪಿತನನ್ನು ಹಿಡಿದಿರುತ್ತೇನೆ. ಆರೋಪಿತನನ್ನು ಕೆಇಬಿ ಬಳಿ ಹಿಡಿಯಲು ಪ್ರಯತ್ನ ಮಾಡಿದ್ದೇನೆ. ಆತ ಓಡಿ ಹೋದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹೆಲಿಪ್ಯಾಡ್ ಗ್ರೌಂಡ್ ಬಳಿ ಆರೋಪಿಯನ್ನು ಹಿಡಿದಿರುತ್ತೇನೆ. ಆರೋಪಿತನನ್ನು ಕೆಇಬಿ ಬಳಿ ಹಿಡಿಯಲು ಪ್ರಯತ್ನ ಮಾಡಿದ್ದೆ. ಆತ ಓಡಿ ಹೋದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹೆಲಿಪ್ಯಾಡ್ ಗ್ರೌಂಡ್ ಬಳಿ ಹಿಡಿದಿರುತ್ತೇನೆ. ರಾಣೆ 4-5 ಜನ ಸಿಬ್ಬಂದಿಗಳು ಬಂದಿರುತ್ತಾರೆ. ಕೆಇಬಿ ಬಳಿ ಬಂದಿರುತ್ತಾರೆ. ಸದರಿ ಸಿಬ್ಬಂದಿಗಳು ಬೈಕಿನಲ್ಲಿ ಬಂದಿರುತ್ತಾರೆ. But he stated that first he tried to catch the accused near the KEB milots. Subsequently, he states that they have ran away and he has caught hold near the ground milots. This is the version of the PW4 milots. PW5 is the punch witness milot. He has the turned hostile milot to Caesar Mahazar milot. PW6 is PSA milot who has registered the FIR on complaint milot. FIR is marked as Exhibit P5 and FIR complaint as Exhibit P5 and FIR as Exhibit P6 milot. And PW7 milot who has examined milot, he is the Archaka of the said temple milots. He deposes to the contradicting of the depositions of PW4 milots. He said, sir, he has given the complaint milots. PW4 states that I have informed the police station and subsequently it has been FIR been registered milots. Even PW7 states that I have given information before the police station and the FIR has been registered milots. We will be permitted to read the PW7 milots.
Who have stated what? PW?
That's PW, as per PW4, my lords. He states that I have informed the jurisdictional police station, my lord, and they have sent 4 persons to catch hold the accused, my lord. This is the first information, my lords. Please, my lord.
How do you say that is first information? What he informed to the station?
Lord, they have ran away 2 persons.
That is all.
Who told?
He did not inform about the alleged theft.
Alleged theft, no, my lords. Only
No.
about the
He said
persons.
I had signaled 2 motorcycle riders to stop. On the pretext of showing documents from the banks, they have run away. That is all he has stated.
And one
They were able to catch one.
Two absconding, even in charge.
That is all he has stated.
Absconding.
How can that be an FIR?
But first information he has informed to the.
So what is first information? You are taking
about
it
the
fundamental. What is the first information?
about the alleged incident.
Exactly. About the alleged incident. Has PW stated anything about the alleged incident?
No, just 2 persons have
Then
run away.
how can that be a first information? It is not. ನೀವು ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ ಇದ್ದೀರಿ. ಪ್ರಶ್ನೆಗಳು ಬರ್ತದೆ. ಸಬ್ಮಿಷನ್ ಸರಿ ಇಲ್ಲದೆ ಹೋದ್ರೆ. Yes.
PW7, my lords.
Yes.
First examination of the PW7 at para 6, my lords.
Yes.
He states that he is the Archaka of the said temple.
Read PW7 fully, please.
Please, my lords.
Slowly.
ಈಗ ನಾನು ನಿವೃತ್ತನಾಗಿರುತ್ತೇನೆ. ವ್ಯವಸಾಯ ಹಾಗೂ ಯಲ್ಲಮ್ಮ ದೇವಸ್ಥಾನದಲ್ಲಿ ಪೂಜಾರಿಯಾಗಿ ಕೆಲಸ ಮಾಡಿರುತ್ತೇನೆ. ದಿನಾಂಕ 16ರಂದು ಶುಕ್ರವಾರವಾಗಿತ್ತು. ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ದೇವಸ್ಥಾನದ ಬಾಗಿಲನ್ನು ತೆಗೆಯಲು ನನ್ನ ಸೊಸೆಯನ್ನು ಕಳುಹಿಸಿರುತ್ತೇನೆ. ಅವರ ಹೆಸರು ಜೋತಮ್ಮನನ್ನ ಕಳುಹಿಸಿರುತ್ತೇನೆ. ಸದರಿ ಚಾಸ 8 ಬಾಗಿಲು ಚಿಲಕ ಮುರಿದಿರುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ್ದಾಗ ನಾನು ಅಲ್ಲಿ ನೋಡಲಾಗಿ ಹಿಂದಿನ ಬಾಗಿಲು ಮತ್ತು ಗರ್ಭಗುಡಿ ಬಾಗಿಲು ತೆಗೆದಿತ್ತು. ಕಳುವಾಗಿರುವ 2 ಮುಖ ಮದ್ದ 2 5 ಬರ್ತಿ 3 ನಾಗರಹಟ್ಟೆ ಕಣ್ಣುಗಳು 2 ಬಂಗಾರದ ಮೂಗುತಿ ಬಂಗಾರದವಾಗಿತ್ತು. ಉಳಿದು ವಸ್ತುಗಳು ಬೆಳ್ಳಿಯ ವಸ್ತುಗಳಾಗಿರುತ್ತು. ಒಟ್ಟು ಬೆಳ್ಳಿ ಮುಖ ಮೂರ್ತಿಗಳು ನಾಗ ಹೆಟ್ಟೆಗಳು ಎಲ್ಲ ಸೇರಿ 3 kg ಬೆಳ್ಳಿಯ ವಸ್ತುಗಳಾಗಿರುತ್ತೇವೆ. ಬಂಗಾರದ ಕಣ್ಣು ಹಾಗೂ ಮೂಗುತಿ ಮುಕ್ಕಾಲ್ ಗ್ರಾಮ್ ಆಗಿರುತ್ತದೆ. ಅಲ್ಲಿ ಹೋಗಿ ನೋಡಿದ ನಂತರ ನಾನು ಪೊಲೀಸರಿಗೆ ದೂರು ನೀಡಿರುತ್ತೇನೆ. ದೂರನ್ನು ಸಾಕ್ಷಿ ಗುರುತಿಸು ಅದರಲ್ಲಿದ್ದ ಸಹಿಯನ್ನು CP 5B ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ನಂತರದಲ್ಲಿ ಪೊಲೀಸರು ಸ್ಥಳಕ್ಕೆ ಬಂದಿರುವುದು ವಿಚಾರಣೆಯಾದ ಮಾಡಿದ್ದು ಅದನ್ನು ನಾನು ಗುರುತಿಸಿ ಅದನ್ನು ಅಂಗಡಿ ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಆ ಸದರಿ ಕಣ್ಣುಗಳಿಂದ ವಿಚಾರಿಸಿ ಪೊಲೀಸರು ನನಗೆ ಹೇಳಿದ ನಂತರದಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಅರ್ಜಿ ಹಾಕಿ ಬಿಡಿಸಿಕೊಂಡಿರುತ್ತೇನೆ. ಆ ಸದರಿ ಕಣ್ಣುಗಳನ್ನು ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನೋಡಿರುತ್ತೇನೆ. ಕಟ್ಟಿಯನ್ನು ಸಹ ನನಗೆ ನೋಡಿಸಿರುತ್ತಾರೆ. ಒಬ್ಬ ವ್ಯಕ್ತಿಯನ್ನು ನೋಡಿಸಿದ್ದು ಅವರನ್ನು ನಾನು ನೋಡಿರುತ್ತೇನೆ. ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಆರೋಪಿಯನ್ನು ನನ್ನನ್ನು ಆ ದಿನ ಪೊಲೀಸರು ನನಗೆ ನೋಡಿಸಿರುತ್ತಾರೆ. 2 ಕಣ್ಣುಗಳನ್ನು ಬಾಕಿ ತನ್ನ ವಶದಿಂದ ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ಈಗಾಗಲೇ ಅವುಗಳನ್ನು MO 1 and 2 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಅವುಗಳನ್ನು ಸಾಕ್ಷಿಗೆ ವಾಪಸ್ಸು ನೀಡಲಾಯಿತು. ಆ ದಿನ ರಾಣಿಯಲ್ಲಿ ನೋಡಿಸಿ ಗಟ್ಟಿಯನ್ನು ಈ ದಿನ ನೋಡಿದ್ದನ್ನು ಗುರುತಿಸಲಾಗಿದೆ. ಹಂತದಲ್ಲಿ MO 1 ಅಡಿಯಲ್ಲಿ ಕಾರಣಕ್ಕೆ ಮುಂದುವರಿಕೆ ಮುಖ್ಯ ವಿಚಾರಣೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಸಾಕ್ಷಿಯನ್ನು ಪ್ಯಾರಾ ನಂಬರ್ 4 ರಾಣಿಯಲ್ಲಿ ನೋಡಿದ ಬೆಳ್ಳಿ ಕಟ್ಟಿಯನ್ನು ನೋಡಿದ್ದೇನೆ ಗುರುತಿಸಲಾಗಿದೆ. ಅದನ್ನು MO 3 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಸದರಿ ದಿನ ರಾಣಿಯಲ್ಲಿ ತೋರಿಸಿದ ವ್ಯಕ್ತಿಯನ್ನು ಗುರುತಿಸಿದ್ದೇನೆ. ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ ವ್ಯಕ್ತಿ ಸದರಿ ವ್ಯಕ್ತಿಯಾಗಿರುತ್ತಾನೆ. ಪಾರ್ಟಿ ಸೊಲ್ಯೂಷನ್. ನಾನು SLC ಯವರೆಗೆ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿರುತ್ತೇನೆ. ನನಗೆ 3 ಜನ ಗಂಡು ಮಕ್ಕಳು, ಒಬ್ಬ ಹೆಣ್ಣು ಮಗು. ನನಗೆ ರಾಮಜೋಗಿಹಳ್ಳಿಯಲ್ಲಿ 5 ಎಕರೆ ಜಮೀನು, ಆದರೆ ಅದರ ಸರ್ವೆ ನಂಬರ್ ಶೋಯ ಅಂಚು. ನಮ್ಮ ಗ್ರಾಮದಲ್ಲಿ ರೇಣುಕಾ ಮತ್ತು ಆಂಜನೇಯ ಸ್ವಾಮಿ ದೇವಸ್ಥಾನ ಒಂದೊಂದು ಇದೆ. ಪ್ರತಿ ದೇವಸ್ಥಾನದಲ್ಲಿ ಪ್ರತ್ಯೇಕ ಕಮಿಟಿ ಇದೆ ಎಂದರೆ ಸರಿ. ರೇಣುಕಾಯಮ್ಮ ದೇವಸ್ಥಾನದಲ್ಲಿ ಪೂರ್ವ ಪಶ್ಚಿಮ ಆದ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ದೇವಸ್ಥಾನದ 90 ಸರ್ವೆ ನಂಬರದಲ್ಲಿ ಬರುತ್ತದೆ. ಫಿರ್ಯಾದಿ ದೇವಸ್ಥಾನದ ಇರುವ ಸರ್ವೆ ನಂಬರ್ ಬರೆಸಿಲ್ಲ. ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗಲು 2 ಬಾಗಿಲು ಮಾಡಿದ್ದೇವೆ. ದೇವಸ್ಥಾನದಲ್ಲಿ ಹೋಗುವಾಗ 2 ಬಾಗಿಲುಗಳನ್ನು ಬೀಗ ಹಾಕಿಕೊಂಡು ಹೋಗುತ್ತೇವೆ. ದೇವಸ್ಥಾನದಲ್ಲಿ ಸುತ್ತಮುತ್ತ ವಾಸಮನೆ ಮತ್ತು ಖಾಲಿ ನಿವೇಶನ ಇದೆ ಎಂದರೆ ಸರಿ. ಬಾಗಿಲು ಪೂರ್ವ ದಿಕ್ಕಕ್ಕೆ ಇದೆ. ಪೂರ್ವ ದಿಕ್ಕಕ್ಕೆ ಇರುವ ರಸ್ತೆಯಲ್ಲಿ ಸಾಕಷ್ಟು ಜನ ತಿರುಗಾಡುತ್ತಾರೆ ಎಂದರೆ ಸರಿ. ದೇವಸ್ಥಾನದಲ್ಲಿ ಯಾವುದೇ ಶಬ್ದವಾಗಿ ಅಕ್ಕಪಕ್ಕದ ದವರಿಗೆ ಸರಿ. ಫಿರ್ಯಾದಿ ಕೊಡುವ ಕಾಲಕ್ಕೆ ನಾನು ಮತ್ತು ಚಾಸ 6-7 ಹೋಗಿದ್ದೇವೆ. CP 5 ಅನ್ನು ಚಾಸ 5 ರವರು ಬರೆದಿರುತ್ತಾರೆ. ಅದನ್ನು ದೇವಸ್ಥಾನದ ಮುಂದೆ ಬರೆದಿರುತ್ತೇವೆ. ನಾನು ಫಿರ್ಯಾದಿನಲ್ಲಿ 5 ಪ್ರತ್ಯೇಕ 3 ನಾಗಹಟ್ಟಿ ಇತ್ತು ಎಂದು ಬರೆದಿಸಿರುತ್ತೇನೆ. ರಾಣಿಯಲ್ಲಿ ನನಗೆ ಬೆಳ್ಳಿ ಕಟ್ಟಿ ಮತ್ತು ಕಣ್ಣುಗಳನ್ನು ಮಾತ್ರ ತೋರಿಸಿ ನೀಡಿರುತ್ತಾರೆ. ರಾಣಿಯಲ್ಲಿ ತೋರಿಸಿರುವ ವ್ಯಕ್ತಿಯನ್ನು ಹೆಸರು, ತಂದೆಯ ಹೆಸರು, ವಿಳಾಸ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ ಎಂದರೆ ಸಾಕ್ಷಿ ಅವನ ಹೆಸರು ಯರಿಸ್ವಾಮಿ ಎಂದು ತಿಳಿಸಿ ನಮ್ಮ ದೇವಸ್ಥಾನದಲ್ಲಿ ಕಳೆದು ಮಾಡಿಕೊಂಡ ವ್ಯಕ್ತಿ ಎಂದು ತೋರಿಸಿರುತ್ತಾರೆ. ಪೊಲೀಸರ ಹೇಳಿಕೆಯನ್ನು ಮೇರೆಗೆ ಮಾತ್ರ ನಾನು ಅವನ ಹೆಸರು ಯರಿಸ್ವಾಮಿ ಎಂದು ಹೇಳಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿ. ಆ ಕಾಲಕ್ಕೆ ಆರೋಪಿ ಜೊತೆಗೆ ಬೇರೆ ಯಾರು ಇದ್ದರು ಎಂದರೆ ನನಗೆ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ಫಿರ್ಯಾದಿ ನೀಡಿದ ನಂತರ ಸಂಜೆ 4 ಪೊಲೀಸರು ಸಿಬ್ಬಂದಿಗಳು ಪೊಲೀಸರಿಗೆ ರೇಣುಕಾ ಯಲ್ಲಮ್ಮ ದೇವಸ್ಥಾನದಲ್ಲಿ ಊರಿನ ಜನ ತೋರಿಸಿದ್ದಾರೆ. ಬರವಣಿಗೆ ಆದ ನಂತರ ಸದರಿ ದಾಖಲೆಗಳು ಸಿದ್ದಪ್ಪ, ರಾಮಚಂದ್ರ ಮತ್ತು ದೇವರಾಜ್ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ. ಪೊಲೀಸರನ್ನು ಸ್ಥಳಕ್ಕೆ ಬಂದಾಗ ಮೇರೆ ಹೇಳಿಗೆ 3 ಜನ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಅಲ್ಲಿ ಬಹಳ ಜನ ಇದ್ದರು, ಯಾರು ಎಂದು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ಸದರಿ ಸ್ಥಳಕ್ಕೆ ಬೇರೆ ಯಾರು ತೆಗೆದುಕೊಂಡು ಬಂದರು ಎಂದರೂ ನನಗೆ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ಫಿರ್ಯಾದು ಕೊಟ್ಟ 1 ತಿಂಗಳ ನಂತರ ಪೊಲೀಸರು ನನಗೆ ಕಳುವಾದ ವಸ್ತುಗಳನ್ನು ಸಿಕ್ಕಿರುವ ಬಗ್ಗೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆ ಬಗ್ಗೆ ನೆನ್ನೆಯಿಂದ ಯಾವುದೇ ಹೇಳಿಕೆ ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. ದಿನಾಂಕ 0 ದೇವಸ್ಥಾನ ಕಳುವಾಗ ಬಗ್ಗೆ ಫಿರ್ಯಾದು ಎಂದು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿರುವುದು ಎಂದರೂ ಸರಿಯಲ್ಲ. ಗರ್ಭಗುಡಿ ಬಾಗಿಲ ಹೊಡೆದಿದ್ದು ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿರುವುದು ಎಂದರೆ ಸರಿಯಲ್ಲ. ರಾಣಿಯ ಆರೋಪಿ ಮತ್ತು MO 123 ತೋರಿಸಿದು ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿರುವುದು ಎಂದರೆ ಸರಿಯಲ್ಲ. He has identified MO 123 Millards, and he speaks that he has seen the accused in police station Millards. Subsequently, he has same identified before the court Millards, before the trial court Millards. W8 Millards, he is a resident Millard of the said locality, and he has a witness Millard, and even he has identified MO1 Millards, the ornaments Millard, and PW9 is the investigation officer Millard. PW9 Millards, he states that along with complainant witness 4 and 5, he has visited the spot Millards. The said the complainant witness 4 and 5 have not been examined Millards. Permitted to read his depositions Millard. PW9 Millards, investigation officer Millards.
Yes.
Para number 2 Millards. ಸದರಿ ಸ್ಥಳೀಯ ಹೇಳಿಕೆಯಲ್ಲಿ ಸ್ವತ್ತುಗಳನ್ನು ಮಾರಾಟ ಮಾಡಿದ ಅಂಗಡಿ ತೋರಿಸಿ ಹಾಜರು ಪಡಿಸಿರುತ್ತೇನೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಹೇಳಿಕೆಯನ್ನು CP7 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. CP7 ಹೇಳಿಕೆ ಆಧಾರದ ಮೇಲೆ ನಾನು ಪಂಚಾರತ 4 and 5 ರಂದು ಬರಮಾಡಿಕೊಂಡು ಸಿಬ್ಬಂದಿಗಳನ್ನು ಚಾಸ 14-15 ಅವರುಗಳು ಕರೆದುಕೊಂಡು ಗಂಜಗ್ರಾಮ ಗಡ ಚಾಸ 9 ಇವರ ಅಂಗಡಿಗೆ ಗಜೇಂದ್ರ ಗಡದ ಚಾಸ 9 ರವರ ಅಂಗಡಿಗೆ ಹೋಗಿರುತ್ತೇನೆ. ಆರೋಪಿ ಸದರಿ ಅವರ ಅಂಗಡಿಯಲ್ಲಿಯೇ ಮಾರಾಟ ಮಾಡಿರುವ ತಿಳಿಸಿರುತ್ತಾನೆ. ಸದರಿ ಅವರು ಅಂಗಡಿಯಲ್ಲಿ ಚಾಸ 4 and 5 ರವರ ಸಮೂಹ 959 ಗ್ರಾಂ ಬೆಳ್ಳಿಯನ್ನು ಹಾಗೂ 2 ಬಂಗಾರದ ಕಣ್ಣುಗಳನ್ನು ಪಂಚರದ 4 ಮತ್ತು 4 ರವರ ಸಮಕ್ಷಮ ಜಪ್ತುಪಡಿಸಿ ಇರುತ್ತವೆ. This is the Caesar Mahazar, my lord, in the shop where the accused has placed the ornaments, my lord. Yes. Investigation officer deposes that in front of 4 and 5, CW 4 and 5, he has seized the said ornaments, my lord. This CW 4 and 5 has not been examined, my lords. ಪಂಚನಾಮೆಯನ್ನು ಬೆಳಿಗ್ಗೆ 7:50 ರಿಂದ 9 ರವರೆಗೆ ಮಾಡಿ ಅದಕ್ಕೆ ಪಂಚ ಹೇಳಿಕೆ ಪಡೆದು ನಾನು ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ. ಸದರಿ ದಾಖಲೆಯನ್ನು CP3 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಸಾಕ್ಷಿಯ ಸಹಿಯನ್ನು CP3 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಜಪ್ತುಪಡಿಸಿರುವ 2 ವಸ್ತುಗಳನ್ನು ಗುರುತಿಸಲಾಗಿದೆ. MO1 and 2 ಎಂದು PW10 is the country witness, my lord. And PW11, my lords.
Read the cross-examination of PW10, please.
PW10, my lords, please, my lords. ನಾನು ಮತ್ತು ಸ್ವಾಮಿ ಸೇರಿದಂತೆ ಸ್ನೇಹಿತರು ಸರಿ. ತಿಪ್ಪೇಸ್ವಾಮಿ ವಿರುದ್ಧ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕೇಸು ಇತ್ತು ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಳೆದಂತೆ ಕೇಸುಗಳು ಇದೆ. ನ್ಯಾಯಾಲಯದ ಇತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಕಳ್ಳತನದ ಕೇಸುಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಬೇರೆ ಕೇಸುಗಳಿಗೆ ಸಾಕ್ಷಿ ಹೇಳುವುದಿಲ್ಲ. ತಿಪ್ಪೇಸ್ವಾಮಿ ಪಿರಿಯ ಆಟೋ ರಿಕ್ಷಾ ಮತ್ತು ಸಂಬಂಧದಿಂದ ಇದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಾಕ್ಷಿ ಹೇಳಿದ್ದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಾಕ್ಷಿ ಹೇಳುವುದನ್ನು ಹವ್ಯಾಸ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆದ ಕಾರಣ ಚಳ್ಳಕೆರೆ ಪೊಲೀಸರು ರಾಣೆಗೆ ನನ್ನ ವಿಳಾಸ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಹಾಜರ್ ಬರೆದು ನನಗೆ ನೋಟಿಸು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಸದರಿ ದಿನ ನಾನು ತಾಲೂಕು ಅಪ್ಪೀಲಿನಲ್ಲಿ ಬಳಿ ಇದ್ದೇನೆ. ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ನ್ಯಾಯಾಲಯದ 5 ಗಂಟೆ ಇತ್ತು. ನನ್ನನ್ನು ಪೊಲೀಸರು ಹೆಸರು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ಗಜೇಂದ್ರ ಕರೆದುಕೊಂಡು ಹೋಗುವ ಸಂದರ್ಭದಲ್ಲಿ ನಾನು ತಿಪ್ಪೇಸ್ವಾಮಿ ಹೋಗಿರುತ್ತೇವೆ. ನಮ್ಮನ್ನು ಕಾರಿನಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. ಸದರಿ ಕಾರ ನಂಬರು ಮತ್ತು ಚಾಲಕ ಯಾರು ಎಂದು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ನಮ್ಮನ್ನು ಜಗದ ಘಟನೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಒಂದು ಹೊಳೆನಲ್ಲಿ ಕೂರಿಸಿಕೊಂಡು ನಮ್ಮ ಸಹಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಅಲ್ಲಿ ನಾನು ಬರೆದುಕೊಂಡು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಪೊಲೀಸರು ಸಹಿ ಮಾಡು ಎಂದು ಮೇರೆಗೆ ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ. ನನ್ನ ಸಮಕ್ಷಮ ಏನೂ ವಸ್ತುಗಳನ್ನು ಜಪ್ತು ಮಾಡಿಕೊಂಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಗಜೇಂದ್ರ ಪೇಟೆಗೆ ಕರೆಗೆ ಕೊಂಡು ಹೋಗಿರುವ ಜ್ಯುವೆಲ್ಲರಿ ಕಡೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದ ಘಟನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಮಾನತು ಪಂಚನಾಮ ರಾಣಿಯಲ್ಲಿ ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಸಮಕ್ಷಮ ಬೆಳ್ಳಿ ಬಂಗಾರ ವಸ್ತುಗಳನ್ನು ಜಪ್ತಿ ಮಾಡಿಸಿಕೊಂಡು ಎಂದರೆ ತೂಕ ಮಾಡುತ್ತಿರುವುದು ಬೆಳ್ಳಿ ಬಂಗಾರದ ವಸ್ತುಗಳನ್ನು ಎಂದು ಹೇಳುತ್ತಾರೆ. ಸದರಿ ದಿನ ಆರೋಪಿಯು ಸಹ ಇದ್ದ ಎಂದು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿರುವುದು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಯಾವ ಯಾವ ವಸ್ತುಗಳನ್ನು ಮತ್ತು ಎಷ್ಟು ತೂಕ ಇದ್ದುವು ಎಂದು ನನ್ನನ್ನು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಈ ಪ್ರಕರಣದ ಮಹಾಜರ್ ನನಗೆ ಓದಿ ಹೇಳಿದಿ ಎಂದು ಸರಿ. ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧದಂತೆ ಏನು ಮಾಹಿತಿ ಇರಲಿಲ್ಲ ಸಹ ಪೊಲೀಸರು ಮಾತು ಕೇಳಿ ನಾನು ಸಾಕ್ಷಿ ಹೇಳುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. PW11 is the shop owner, my lords. He deposes that the accused has approached stating that his mother is not well, so he has placed the ornaments, my lords. He has identified the accused even in the court, my lords. There is no cross-examination of PW11. Cross-examination, my lords.
No
cross-examination. Please, my lords. Sorry, my lords. Subsequently, on 25/7/2012, my lords, yes, cross-examined, my lords. Strictly permitted to his cross-examination. Para number 2, my lords. ನನ್ನ ಅಂಗಡಿಯಾದ ಓಂ ಕಾ ಜ್ಯುವೆಲ್ಲರಿ ಬಳಿ ಪೊಲೀಸರು ಆರೋಪಿ ಬಂದಿದ್ದರು ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆಗ ಬೆಳ್ಳಿ ಕಡ್ಡಿ ಹಾಗೂ ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ಪೊಲೀಸರು ಕೊಟ್ಟನು ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಗಜೇಂದ್ರ ಕಡದ ಸದರಿ ನನ್ನ ಅಂಗಡಿಯೇ ಇಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಅಳಿಯನ್ನು ಹೆಸರು ಗೋಪಿ ಎಂದರೆ ಸರಿ. ಕಳ್ಳತನಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನನ್ನ ಅಳಿಯ ಗೋಪಿಯನ್ನು PR ಪುರಂ ರಾಣೆಯಲ್ಲಿ ಪೊಲೀಸರು ಹಿಡಿದುಕೊಂಡು ಕುಳಿಸಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ಪ್ರಕರಣದ ಪೊಲೀಸರು ತನಿಖೆ ಮಾಡಿದ್ದಾಗ ಎಂದರೆ ಸರಿ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ರಾಣೆಯಲ್ಲಿ ನನ್ನ ತಂದೆಯನ್ನು ಕರೆದು ವಿಚಾರಣೆ ಮಾಡಿದ್ದು ಎಂದರೆ ಸರಿ. ಪರಶುರಾಂಪುರ ರಾಣೆಯಲ್ಲಿ ನನ್ನನ್ನು ಕರೆಸಿದ್ದರು ಎಂದರೆ ಸರಿ. He deposes that even his Aliya, my lords, who is the Gopi, my lords, even he was called for the investigation, my lord, before the said police station for the said incident, my lords. One Gopi, my lords, he has been called, my lords. ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ನನ್ನನ್ನು ನನ್ನ ತಂದೆಯನ್ನು ಹಾಗೂ ಗೋಪಿಯನ್ನು ವಿಚಾರಣೆ ಮಾಡಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿ. ಪರಶುರಾಂಪುರ ರಾಣೆಯಲ್ಲಿ ನನ್ನಿಂದ ಯಾವುದೇ ವಸ್ತುಗಳನ್ನು ಪಡೆದಿಲ್ಲ. ಆದರೆ ಗಜೇಂದ್ರ ಕಡಲಿನಲ್ಲಿ ನನ್ನನ್ನು ಅಂಗಡಿಯಲ್ಲಿ ವಸ್ತುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಬಂದಿರುತ್ತಾರೆ. ಸದರಿ ದಿನ ನನ್ನ ಅಳಿಯ ಗೋಪಿ ಮೇಲಿನ ಪ್ರಕರಣವನ್ನು ಆರೋಪಿ ಮೇಲೆ ಹೇಳಬೇಕು ಎಂದು ತಿಳಿಸಿದ್ದರಿಂದ ನಾನು ಈ ರೀತಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ರಾಣೆಯಲ್ಲಿ ಆರೋಪಿ ವಿರುದ್ಧ ಸಾಕ್ಷಿ ಹೇಳಬೇಕು ಎಂದು ಆ ಪೊಲೀಸರು ತಿಳಿಸಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ದಿನ ರಾಣೆಗೆ ಅನಂತ್ ಮೂರ್ತಿ ಪಾಲ್ಭಾವಿ ಮತ್ತು ವಾಸುದೇವ್ ಪೊಲೀಸರು ಇದ್ದರು ಸರಿ.
Skip that last paragraph.
Please, ma'am.
What are your arguments?
The identification of the accused, my lords. PW4 states that it is midnight around 12:30, my lords. and there were 200 meters, my lord, away, my lords. When he tried to chase, their accused number 2 has ran away from the spot, my lord. Subsequently, he have caught hold only one accused who is present before the court, my lords. And PW 11, my lords, who identifies the same person, my lords. He states that first time I have seen in the police station, my lord. The same person
Whom he has seen first time in the police station?
Yes. PW7, PW11, my lords.
Yes, PW11 is the shop owner.
Shop owner, my lord.
Has he stated that he saw the accused first time in the police station?
Not first time, my lords. He states that I have seen the accused who was bought before the shop, and even the same person is before the court, my lords. The recovery, my lords. The recovery at the instance of the voluntary statement of the accused, my lord. In voluntary statement, he has deposed that what all acts he has done, my lords. He has robbed, he has theft of two-wheeler, which he has not sold and it is laying in his house. And subsequently, what all the acts he has done, he has stated in his voluntary statement, my lords. In the last para, he has stated that this the ornaments, my lord, which has been theft from the temple, has been pledged with the PW11, my lords.
So what are the points of your argument? Please tell me one single head of your argument.
The accused has been firstly
You are
implicated.
just say putting in English what is there in evidence in Kannada.
Falsely,
Tell me your points of argument.
Falsely, the petitioner has been implicated in
This is a general statement.
Please,
We are in revision.
all the witnesses, my lord, are some of the police witnesses and some of the interested witnesses.
How do you say
my lord.
other police witnesses?
Some
Majority of the witnesses are independent witnesses.
independent witnesses, and there is no eyewitness, my lords.
Do you think for these kind of offenses of a theft in a temple in a remote village, there will be eyewitnesses?
No, my lords. But the temple is situated in the residence where in PW7 who has deposed that. Just before the door, there is a lot of residents, my lords.
Yes.
At least there will be some sound, my lord. Nobody has alarmed the same, my lords.
Have you denied or disputed the theft anywhere in the cross-examination of any of the witnesses? You have not denied. You have not denied the alleged theft. Have you denied that MO 1 and 2 does not belong to the goddess? You have not denied. Have you denied that the Archaka has misidentified or wrongly identified MO 1 and 2? You have not. Then, when you have not denied these important stages of investigation and the alleged important facts that you have been placed through charge sheet, how you can dispute the impugned judgment?
This PW11, my lords, shop owner who disputes that when their in-law, one Gopi, was involved and he has been interrogated by the said police, my lord, after the said incident, my lord.
That is only say the police retaining son-in-law of the shop owner, that is Mr. Gopi, for some time in the police station, has been suggested to the witness. What is the nexus between the police retaining said Gopi for few hours with them in another case and this witness coming in this case and giving evidence?
Maybe the person same is involved.
No, maybe cannot be the thing.
Please, no. There
You
is no
cannot say
witnesses.
maybe.
There is no witness.
Yes, no nexus. No nexus. Probably the learned counsel for the accused in the trial court might have gathered some information, maybe through police themselves. ಹಿರಿಯ ಅಂಗಡಿಯವ್ರ ಎಳೆಯನ್ನ ಹೋದ್ಸಲ ನಮ್ಮ ಸಾಹೇಬ್ರು ಕರ್ಕೊಂಡ್ ಬಂದಿದ್ರು ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಕೂರಿಸಿದ್ರು. ಅವಾಗ ಈತ ಇದ್ ಮಾವ ಎಲ್ರು ಬಂದಿದ್ರೆ ಸಾರ್ ಅಂತ ಹೇಳಿರ್ತಾನ ಅವನು. ಸರಿ ಅಷ್ಟೇ ವಕೀಲರು ಕೇಳಿರ್ತಾರೆ, ನೋಡು ನೀನು ಅಳಿಯನ್ ಪೊಲೀಸರು ಕರ್ಕೊಂಡು ಹೋಗಿದ್ರು, ನಿಮ್ಮಪ್ಪನೂ ಹೋಗಿದ್ದ, ನೀನು ಹೋಗಿದ್ದಿ, ಆಮೇಲೆ ಅವ್ರನ್ನ ಪೊಲೀಸರು ಬಿಟ್ರು, ಹೌದೋ ಅಲ್ವೋ? ಹೌದು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಿನಗೆ ಪೊಲೀಸರು ಪೂರ್ವವಾಗಿ ಸುಳ್ಳು ಹೇಳ್ತಾ ಇದ್ದಿ ಅಷ್ಟೇ. What is the error committed by the trial court as well as the first appellate court warranting an interference at the hands of this court?
On the sole voluntary statement, my lords, the last para, my lords, where the accused voluntarily admits that the said ornaments I have placed in the said shop of EPW1, the petitioner have been convicted for the said offences, my lords.
Yes, Mr. SCGP. ಇಲ್ಲಿ ಈಗ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಂದ ನಿಮ್ಗೆ ಏನ್ ಗೊತ್ತಾಯ್ತು?
Recovery also got the component and also that temple puja was examined. So the court he has also support identified and also accused.
The amicus curiae for the petitioner and the learned SCGP for the respondents are physically present. But the argument of learned amicus curiae. Yes, Javed. As requested by learned SCGP for his argument, followed by reply if any. Is this matter on the top of the list of 10/6/2020. Yes, next.
Serial number 48.
For the petition, for the petitioner. Lords, the germane facts of the case, according to the complainant, is that, my lords, the petitioner was driving a tanker lorry from Chalkare towards Bellary, has driven in a rash and negligent manner, and thereby has hit the deceased Jyoti, who was a pedestrian who was walking on the left side of the road, where the deceased has fallen down, succumbed to injuries, and finally succumbed to death also, my lords. Complaint was filed by the father of the deceased, Mr. Ananda, and the accused was charge sheeted under section 279 304A of IPC and section 187 of IM Act. This incident happened on 14/11/2009 at 11:45 AM. Criminal complaint 1210 of 2009 was filed, and the white judgment dated 25/1/2012, my lord. The accused was convicted under section 279 for simple imprisonment for 6 months and ₹1,000 fine. And then under section 304A, simple imprisonment for 1 year and plus ₹2,000. And under section 187. and under section 187 of IMB, rupees 500 fine, which runs consecutively. Agreed by this, he files a criminal appeal number 18 of 2012 by judgment 12/6/2012, confirms the trial court judgment merits. Hence, this petitioner is before this honorable court. My lords, the main points of defense are five-folds, my lords. First and the foremost, I would like to draw your lordship's attention to the appellate court judgment, my lords.
What is the first fold?
First fold, I would like to draw your lordship's attention to the appellate court judgment, which clearly states that out of all the 17 witnesses, not even one witness is an eyewitness to the incident, my lords. The appellate court.
So the first fold of argument is that the entire case of the prosecution in the trial was based upon the circumstantial witnesses.
Circumstantial.
No eyewitness
Here.
has supported the case of prosecution.
Please, my lords. I will just read out the portion of the appellate court judgment, my lords, at para 26, my lords. From the perusal of all these entire evidence which are on record, it goes to show that none of the witnesses produced by the prosecution are eyewitnesses to the said incident. Having said this, my lords, PW1 and PW2 identifying the accused does not even arise. It is not believable, especially when they claim that the lorry driver has run away after the incident. Well, no doubt the tanker lorry was at the place of accident, but that does not necessarily mean, my lords, and confirm that the accused was the driver, is my first contention to your lordships. And moreover, my lords, the evidence of PW1 again, who is the complainant herein, he clearly says that he does not know, and apparently a shopkeeper happened to tell him the incident. Again, we do not know if that person has witnessed the incident at all. He's not on the record, my lords. So having said that, my lords, may I read the relevant portion of PW1, my lords?
PW1 evidence, you read it entirely.
Chief, my lords.
Read it in entirety.
ನನಗೆ ಸರ್ ಅವರ ಪರಿಚಯ ಇರುತ್ತದೆ. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 14/11/2009 ಬೆಳಿಗ್ಗೆ 11:15 ಸಮಯಕ್ಕೆ ಶಾಲೆಯಿಂದ ನನ್ನ ಮಗಳು ಜ್ಯೋತಿ ನಿಜವಾಗಿ ಆಕೆ ಮರಣ ಹೊಂದಿದ್ದಳು. ಯಾವುದೋ ಒಂದು ಉತ್ತರ ಪ್ರದೇಶದ ವಾಹನ ಸೋನ್ಸೋ ಲಾರಿ ಇರುತ್ತದೆ. ನಮ್ಮ ಮನೆಯ ಬಳಿ ಸುಮಾರು 100 ಮೀಟರ್ ಅಂತರದಲ್ಲಿ ಬಳ್ಳಾರಿ ರಸ್ತೆಯಲ್ಲಿ ನಡೆಯುತ್ತದೆ. ಸದರಿ ಅಪಘಾತ ಆರೋಪಿಯ ತಪ್ಪಿನಿಂದ ಆಗಿದ್ದು, ಆತನು ಬಸ್ಸಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆಯುವುದನ್ನು ತಪ್ಪಿಸಲು ಈಕೆಗೆ ಹೊಡೆಯುತ್ತಾನೆ. ನಾನು ಪೊಲೀಸರಿಗೆ ದೂರು ನೀಡಿರುತ್ತೇನೆ. ಮಂಜುಲಾಲ್ ಎಂಬುವವರು ಅಪಘಾತ ಮಾಡಿಸಿರುತ್ತಾರೆ ಎಂದು ಗೊತ್ತಾಯಿತು. ಸದರಿಯನ್ನು ನಾನು ನೋಡಿರುತ್ತೇನೆ. ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ ಆರೋಪಿಯನ್ನು ಗುರುತಿಸುತ್ತಾರೆ. ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆಯನ್ನು ಸಹ ನೀಡುತ್ತೇನೆ. ನಾನು ಅಲ್ಲಿ ಹೋದ ಕಾಲಕ್ಕೆ ಸ್ಥಳವನ್ನು ನನಗೆ ನೋಡಿಸಿರುತ್ತಾರೆ. ಆ ಕಾಲಕ್ಕೆ ಆರೋಪಿ ಓಡಿ ಹೋಗಿದ್ದು, ನಂತರ ಬಂದಿದ್ದು ಆತನು ನನಗೆ ನೋಡಿಸುತ್ತಾರೆ. ಸಾಕ್ಷಿ ನಿಶಾನೆ P1 ದೂರನ್ನು ನೋಡಿಸಿದ್ದು, ಅದನ್ನು ಗುರುತಿಸಿದವರಿಗೆ ದೂರನ್ನು ನಿಶಾನೆ P ಮತ್ತು ಸಾಕ್ಷಿಯ ಸಹಿ ನಿಶಾನೆ PA ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಪಾಟಿ ಸವಾಲು. ನಾನು 10ನೇ ತರಗತಿಯವರೆಗೆ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿರುತ್ತೇನೆ. ಅಲ್ಲಿ ಅಂಗಡಿಯ ಪಕ್ಕದಲ್ಲಿ, ಅಂದರೆ ಘಟನೆ ನಡೆದ ಸ್ಥಳದ ಪಕ್ಕದಲ್ಲಿ ಅಂಗಡಿ ಇದ್ದು ಅವರು ನನಗೆ ಹೇಳುತ್ತಾರೆ. ನಾನು ಖುದ್ದು ಅಪಘಾತ ನೋಡಿಲ್ಲ ಎಂದರೆ ಅದು ಸರಿ. ನನ್ನ ಮಗಳು ಮರಣ ಹೊಂದಿದ ಕಾರಣ ಪರಿಹಾರಕ್ಕೆಂದು ನಾನು ಅರ್ಜಿ ಸಲ್ಲಿಸುತ್ತೇನೆ ಎಂದರೆ ಅದು ಸರಿ. ಸದರಿ ದಿನ ಆರೋಪಿಯನ್ನು ನೋಡಿರುವುದಾಗಿ ಸುಳ್ಳು ಹೇಳುತ್ತೇನೆ ಎಂದರೆ ಅದು ಸರಿಯಲ್ಲ. ನನಗೆ ಪರಿಹಾರ ಸಿಗಬೇಕೆಂದು ಆರೋಪಿತನು ಯಾವುದೇ ರೀತಿಯ ಅಪರಾಧ ಮಾಡಿಲ್ಲವಾದರೂ ಸಹಿತ ಈ ಸುಳ್ಳು ಹೇಳುತ್ತೇನೆ ಎಂದರೆ ಅದು ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಸ್ವತಃ ಹೇಳುತ್ತಾರೆ, ಆ ದಿನ ಬಹಳಷ್ಟು ಜನರಿಗೆ ಅಪಘಾತವಾಗಬೇಕಾಗಿತ್ತು, ನನ್ನ ಮಗಳು ಮಾತ್ರ ತಿರುಗುತ್ತಾರೆ. ಅಲ್ಲಿ ಇದ್ದ ಜನರ ಆರೋಪಿ ಬಹಳ ಜೋರಾಗಿ ಟ್ಯಾಂಕರ್ ಓಡಿಸಿ ಬಂದಾದುದಾಗಿ ಹೇಳಿದರು. ನಾನು ಅಪಘಾತವನ್ನು ಖುದ್ದಾಗಿ ನೋಡಿಲ್ಲ. ಅಲ್ಲಿಯೇ ಜನರು ಆರೋಪಿ ಅಪಘಾತ ನಡೆಸಿದ ಬಗ್ಗೆ ಹೇಳಿರುತ್ತಾರೆ. Now this boils down to my second segment of my argument, my lords. No doubt, the accident has occurred, my lord, and there is death. But it is incumbent upon the prosecution, my lords, to establish the causa causans of the death of the deceased was due to the act of the accused. My lords, this criminality cannot be presumed, my lords. There are two things to it.
You do not dispute accident, right?
No, my lords. I do not dispute the
You
accident.
do not
I do
dispute
not
the
know.
involvement of the tanker.
I do not.
You do not dispute death of Jyoti, which is said to be due to a road traffic accident.
No, my lords.
You only dispute the alleged involvement of the accused.
Accused being the
Driver of the
driver
tanker
of
at the
the
time of accident.
policeman.
Yes.
So criminality is not to be presumed, my lords. See, besides, my lords, the ingredients of proving rash and negligence, rash and negligence or in the driving, the identity of the driver of the vehicle must also be established separately, my lords, by the prosecution. To prove the guilt of the accused is my respectful submission. My lords, there being dearth of evidence that the accused was the driver in the said incident, that has been not proved beyond reasonable doubt, and hence the accused cannot be convicted is my respectful submission. My lords, it has been held by the Supreme Court in Vikas Kumar Rourkewell versus State of Uttarakhand, my lords. It has specifically held that eyewitness plays an important role in the criminal justice system, and every legislative measure in connection of the witnesses contributes to the fundamental principle of fair trial. That being the case, my lords, when there are no eyewitness, an innocent cannot be charged for an offense which he is not committed. My lords, further down, reiterating the same, my lords, my third contention comes down to the petitioner accused, my lords, has not been identified at any point of time by the prosecution witness, nor there was an identification parade which was conducted, my lords. More so, my lords, especially in this case where there are no eyewitnesses, my lords, this will establish the fidelity of the witness in identifying an unknown person related to the content of the offense, my lords, to the context of the committing of an offense. And my next fourth submission to your lordship is PW5, my lords, admits in his cross-examination that he hasn't examined the vehicle on the spot at the time, at the place of accident. Later on, he has declared that there is no material defect, my lords. That he has not rendered his duty properly, so that cannot be considered as my submission, my lords.
PW5.
PW5, my lords.
PW5 is the investigating officer.
My lords. I am an inspector. He's IMI inspector.
Yes.
Well, as my last point of submission to your lordship is, that's PW six.
With respect to PW5, what was your point of argument? IMA
My
report?
lords, he hasn't examined the vehicle on the spot. How it is not of much relevance, but still it's taken as a ground.
There have to be at least 5-fold. That is the reason you added this.
That's my last contention to your lordship is that PW 6 and 7, my lords, they're the police witness. Here, PW 7 is the IO, my lords. And he has stated, he hasn't stated any details of the spot merger or the sketch. But he just marks the document. And this is not sufficient enough to prove the prosecution beyond reasonable doubt, my lords. He doesn't mention anything about it. So on the whole, my case stands where there is no, where there are no eyewitnesses to the incident, no identification parade of the accused. Nobody has seen the accused. So a person cannot be convicted based on a presumption or an assumption is my respectful submission to your lordship.
Then how you were convicted by trial court and confirmed by the first appellate court?
And that is where they have erred is my respectful submission. That is where the trial court and the appellate court have erred in seeing that there are no eyewitnesses, and in spite of it, he's been accused and convicted for the offense which he's not committed. Based on circumstantial evidence, my lords, alone. And
SCGP.
Let amicus curiae submitted that nobody has identified the accused. Which I read the evidence, nobody has identified the accused. That is, it's on the evidence, I have to concede, no other option. PW1 and 2 says that they have identified, but in the cross-examination, they also say that they were not in this part. Only on receipt of the information, they came to this part, and the persons who gathered there says that he was the accused was on wheels of the offending vehicle as on the date of incident. Therefore, on their basis, so they identified the accused, and therefore, he is the accused who committed the offense. And the second submission, nobody speaks about rash and negligent driving of the offending vehicle by the accused, That is also, to some extent, it is also true, Nobody speak about the rash and negligent. My respectful submission to is that death of the deceased is not in dispute. Nextly, accident is also not disputed. Involvement of the offending vehicle in the accident is not disputed by the accused.
Involvement of the
offending vehicle in the accident is also not disputed by the owner of the vehicle or by the driver of the vehicle, that is the accused.
So whether owner of the vehicle was examined
He was not examined.
It was not examined.
Not examined, but the owner of the vehicle got released the offending vehicle when the investigation officer seized the vehicle. The indemnity bond
Cannot rely upon that.
is the circumstances. Otherwise, if he is not the owner of the vehicle, what was the necessity for him to claim the ownership and got the release the vehicle? So these circumstances, your lordship has to appreciate.
ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಬಹಳ ಸ್ನೇಹಿತ ಆಗಿರ್ಬೋದು ಅವನು ಬಾಲಯ್ಯ ನಾನು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತೀನಿ ಗಾಡಿ ಬಿಡಿಸ್ಕೊಂಡು ಹೋಗು ಮಜಾ ಮಾಡು.
The IO will not release the vehicle so lightly. The appellate court. The appellate court makes an observation.
Assuming for a moment that say the police vehicle, this tanker charged by the investigating officer was the vehicle involved. Does it prove the guilt against the accused? Maybe involvement of the vehicle may be stands established. What about the role of the accused?
PW 1 and 2 evidence has to be.
Here say.
Yes, that has to be believed. That is my submission. Only that has to be believed. Circumstances.
There must be some circumstances to believe PW 1 and 2 evidence, right?
PW 1 and 2 says that on receipt of the information, they came to the spot, and the persons who witnessed the incident says that the accused, before my lords, he was on wheels and on the date of incident, they committed the offense, and therefore, my lords, on their statement, my lords, based upon their statements, he identified the accused.
Please be seated.
Please.
Confirmation of conviction of the accused for the offense 279-304A 187. Comment. The summary of the case of the prosecution, the trial court is that on 14/11/2009 at about 11:45 a.m. the accused being the driver of a tanker lorry bearing registration number JJ6PT 8342. Drove the said tanker from Chellakere side towards Ballari on a public road in a rash and negligent manner, and dashed against one Miss Jyoti, daughter of M.R. Ananda Rao, daughter of M.R. Anand, was going by walk on the left side of the road. In front of the house of Sri Ramashetty, near Suji Malleshwara Nagara, on State Highway number 19. As a result of the said road traffic accident, said Jyoti sustained grievous injuries on her head, hands, and other parts of the body and succumbed to the injuries on the spot. It is further the case of the prosecution that after the accident, the accused ran away from the spot and thus has committed the offence punishable under section 279 304A of Indian Penal Code and under section 187 of the Motor Vehicles Act. Appointment of amicus curiae. The amicus curiae in her argument point for consideration. The amicus curiae in the argument submitted that none of the witnesses examined by the prosecution are admittedly the eyewitnesses to the incident as such. The attempt of the prosecution was to prove the alleged guilt against the accused only through the circumstantial evidence. However, the prosecution has failed in the said attempt. Bogandre, ನಿಮ್ಮ ಮ್ಯಾಟ್ರ್ ಇವತ್ತಿದೆಯಾ? 52 ಬಹುಶಃ ರೀಚ್ ಆಗೋದು ಡೌಟ್. ನೀವೇನ್ ಮಧ್ಯಾಹ್ನ ಬಂದಿದ್ದೀರಿ? ಬಿಟ್ರು ಹೋಗಿ ಬನ್ನಿ ಇವತ್ತು ಪೆರೋಲ್ ಮೇಲೆ ಬಿಡ್ತೇವೆ ಅಂತ. ಹಾಗಾದ್ರೆ ಹೋಗಿ ಮನೆಗೆ. ಮುಂದಿನ ವಾರ ತಗೊಳ್ಳುವ. Probably other matters, the amicus curiae Mr. Javed and Mr. Halshekti. Next matter. 3 minutes. ಆಗ ಒಂದು ಚಾನ್ಸ್ ತಗೊಳ್ಳಿ, ನೀವಿರಿ. ಇದರಲ್ಲಿ ಜಾವೇದ್ ಇದ್ದೀರಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 50. ಹೌದಾ? ಈಗ ಅದನ್ನ ಯಾವ್ದಕ್ಕೆ ಹಾಕಿದ್ದೇನೆ ನಾನು? 10th ಗೆ. Serial number 51. Large amicus curiae for the petitioner and the counsel for the respondent are physically present. Serial number 51 ನಾನು ಹೇಳ್ತಿರೋದು 50. 51 ಅಲ್ಲ, 50. That amicus curiae for the petition that CGP are physically present. So the court time is over. List this matter on 10/6 on the top of the list as prayed. ಇದರಲ್ಲಿ counsel for the petitioner ಇದ್ದೀರಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಅಲ್ಲಿ ಶ್ರೀ ಜಿ ಮಂಜುನಾಥ್. ಇಲ್ಲ, ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಇದ್ದದ್ದು? ಜಾವೇದ್ ಪರವಾಗಿ. ಎಸ್, 10/6 ಅಂತ ಹೇಳಿ 51 ಅಲ್ಲೂ ಅವರೇ ಇದ್ದಾರೆ. 51 ಅಲ್ಲಿ ಅರುಣ್ ಕುಮಾರ್ ಯಾರು? ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದೀರಿ. ಏನ್ ಅಫೆನ್ಸ್ ಅದು? ಅವರೇನ ರಾಜಿಗೆ ಬಂದಿದ್ದಾರೆ ನಿಮ್ಮ ಹತ್ರ? ಬಂದಿಲ್ಲ. Amicus curiae for the petitioner and respondent. Counsel for respondent are physically present. Since the court time is over, matter could not be proceeded today. Is this matter on CC ಯಾವ ವರ್ಷದದು? 2013 CC. Fine amount or check amount? 9 lakh. Is this matter on 17/6?
May I make a request that it be placed higher up on the list, my lord? May I make a request that it be placed higher up on the list, my lord? The matter. It is similarly, it has been
On the top of the list. 52 thirdly. The counsel for the revision petitioner. Respondent to my co-author Sri S. Balakrishnan.
Yes,
Append
Balakrishnan.
for the
For
respondent. Append
The
for
counsel
the.
from both sides present. Since the court time is over, let this matter in the next week. Yes, next week. ಆಮೇಲೆ ಉಳಿದಿರೋದು ಆಮೇಲೆ ನೋಡುವ. ಇದು ಕಂಟಿನ್ಯೂ. ಇದು ಯಾವ್ದಿದೆ ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು 48 ಒಂದಿದೆಯಾ ನೆಕ್ಸ್ಟ್ ಈಗ ನಾವು ಇರೋದು ಯಾವ್ದ್ರಲ್ಲಿ ಈಗ ಇರೋದೇ 48 ಎಲ್ಲಿ ನಿಲ್ಸಿದ್ರಿ entirely based upon the circumstantial witness. She further submitted that admittedly the accused was not identified by any of the prosecution witnesses as the driver of the offending vehicle. Though the learned amicus curiae submitted that should not deny or dispute the occurrence of the road traffic accident on the date, time, and place mentioned in the charge sheet, and also the death of Ms. Jyoti in the said accident. However, in the absence of there being any material to show that however ಮುಂಚೆ occurrence of accident and also involvement of the tanker bearing registration number JJ6PT8342 and the death of Jyoti Anil. She submitted that since the alleged involvement of the accused as a driver of the said tanker has not been proved by the prosecution even to a slightest extent, the petition deserves to be allowed by setting aside the impugned judgments of conviction. For contrast, HCJP in his brief argument submitted that there is nothing on record to show that accused was not the driver of the alleged offending vehicle. The mere fact that the offending vehicle got released by its owner itself go to show that the accused was hired by them as a driver, and it was at the rash and negligent driving of the accused only the accident in question has occurred. As such, both the trial court and the session judges court have rightly convicted the accused for the alleged guilt. The petitioner hearing does not dispute the occurrence of a road traffic accident on 14/11/2009 at about 11:45 on State Highway number 9 in front of Sujimaleshwara Nellahari. So. The petitioner has also not denied nor he dispute that in the said road traffic accident, a tanker vehicle bearing registration number JJ6PT8342 dashed against a pedestrian by name Ms. Jyoti, and that due to the injuries sustained by her in the said accident, she succumbed to it on the spot. However, the said occurrence of the road traffic accident as well as involvement of the tanker lorry bearing registration number JJ6PT8342, and also death of one Miss Jyoti aged about 13 years due to these injuries sustained by her in the said road traffic accident have been further corroborated by the evidence of PW1, PW2, PW3, and the investigating officer, PW3, PW5, and the investigating officer who was examined as PW7. The evidence of PW1, who claims himself to be the father of deceased Jyoti, go to show that it is after the accident and hearing about the said accident, which is said to have been taken place at a distance of 100 meters from his house, he rushed to the spot only to see the mutilated body of her deceased daughter Jyoti. No doubt the said witness has stated that in the spot he also saw the tanker vehicle bearing registration number so and so, and came to know that it was the said vehicle which dashed against her daughter and caused her death. But the witness at more than one places himself has specifically stated that he was not an eyewitness to the incident. In fact, even in his complaint itself, he has stated that he is not an eyewitness to the incident, but it is only after coming to know about the accident and going to the spot, he saw the alleged offending vehicle standing there at a shorter distance to the place where the dead body of her daughter was found lying on the ground. He has specifically stated both in his complaint as well in his evidence that he had not seen the accused in the spot of the accident since he had already ran away from the place. However, the said witness proceeded to say further in the very same evidence that after some time of the incident, the police has shown him the accused, stating to him that it was him who had caused the accident. As such, he has believed that it was the accused who caused the said road traffic accident. Therefore, being himself the complainant and also the father of the deceased Jyoti, though this witness could speak about the accident but not about the alleged involvement of the accused in the said accident. Though some attempt was made to shaken his evidence about the accident and the involvement of the offending vehicle, but the witness has withstood to his original stand about the accident, road traffic accident, involvement of the alleged offending vehicle therein, and also the death of his daughter Jyoti due to the injuries sustained by her in the accident. PW2 NI Mallikarjuna has only stated that on the dead body of deceased Jyoti, inquest Panchanama was drawn in his presence as per Exhibit P2. PW3 Mahalinganna, though was projected as an eyewitness to the incident, he has not supported the case of prosecution to the extent of its expectation, but has only stated that it was only after the accident, having seen a large gathering assembled there, he too went to the spot and saw the spot of the accident. Even after treating him as hostile and cross-examining him, the prosecution couldn't elicit any favorable response any favorable statements from him about he witnessing the incident? Para. Though the evidence of PW4 Noorullah that he was a pancha for a panchanama has not been denied from the cross-examination, but it is best known only to the prosecution as to for what purpose and to which the panchanama he was taken as a pancha. ಏನಾದ್ರು ಹೇಳಿದ್ದಾರ ನೋಡಿ ಅವರು ಅದರಲ್ಲಿ ಹೇಳಿದ್ದಾರ ಸ್ಪಾಟ್ ಅಂತ ಘಟನಾ ಸ್ಥಳವನ್ನು ನನ್ನ ಸಮಕ್ಷಮ ಪಂಚನಾಮೆ ಮಾಡಿರುತ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಯಾವ ಆ ಹುಡುಗಿ ಸ್ಥಳದಲ್ಲೇ ಮೃತಪಟ್ಟಿರ್ತಾಳೆ. ಸದರಿ ಅಪಘಾತ PW4 ದಾಖಲೆಯನ್ನು ತೋರಿಸಿದ್ದು ಅದರಲ್ಲಿ ಸಹಿಯನ್ನು ಸಾಕ್ಷಿ ಗುರುತಿಸಿರ್ತಾರೆ. 6-7 ತಿಂಗಳ ಪೂರ್ವದಲ್ಲಿ ಸೂಜಿ ಮಲ್ಲೇಶ್ವರ ನಗರದಲ್ಲಿ ಶೆಟ್ಟಿ ಮಿಲ್ನ ಎದುರು ಅಪಘಾತ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನಾನು ಸಹಿ ಮಾಡಿರ್ತೇನೆ. ಸ್ಥಳದಲ್ಲಿ ಅಪಘಾತ ಮಾಡಿಸಿದ ವಾಹನ ಮೃತದೇಹ ಇತ್ತು. ಸದರಿ ಗಾಡಿ ರಾಜಸ್ಥಾನದ ವಾಹನವಾಗಿರುತ್ತದೆ. ಸಾಕ್ಷಿಯಾಗಿ ನನ್ನ ಸಹಿ ಪೊಲೀಸರು ಪಡೆದಿರುತ್ತಾರೆ. ನನ್ನ ಸಮಕ್ಷಮದಲ್ಲಿ ಮಾಜರ್ ಮಾಡಿ ಪೊಲೀಸರು ಟಿಪ್ಪರ್ ಲಾರಿಯನ್ನು ಅಮಾನತು ಪಡಿಸಿಕೊಂಡರು.
ಸಾಕ್ಷಿಗೊಂದು ದಾಖಲೆಯನ್ನು ತೋರಿಸಿದ್ದು ಏನು ದಾಖಲೆ? ಯಾವ ಪಂಚನಾಮೆ? ವೆಹಿಕಲ್ ಇರೋದು ಹೇಳಿದಾನೆ, ಹೆಣ ಇರೋದು ಹೇಳಿದಾನೆ, ಸೀಸರು ಹೇಳಿದಾನೆ. ಇನ್ಕ್ವೆಸ್ಟ್ ಆಗ್ಬೋದು, ಸ್ಪಾಟ್ ಆಗ್ಬೋದು, ಸೀಸರ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್ ಆಗ್ಬೋದು. ಯಾವುದು? ನಿಮ್ಮ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಇಷ್ಟು ಚೆನ್ನಾಗಿ ಮಾಡ್ತಾರೆ ನೋಡಿ.
ಯಾವ ಮಾಜರ್ ಅಂತ
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ವೇ? ಏನ್ರಿ ಫಾರ್ ನೇಮ್ ಸೇಕ್. Yes. The evidence of PW5 Subbaiya, the motor vehicle inspector, corroborates the evidence of PW1 to the extent that the vehicle involved in the accident as an offending vehicle was a tanker lorry bearing registration number so and so. He said motor vehicle inspector has described the damages that he has noticed on the offending vehicle and given a report as per Exhibit P6, which in the light of the evidence of PW2 and the investigating officer, that is PW7, to go to show that it was the offending vehicle, it was the offending vehicle, but it was the tanker lorry bearing registration number so and so was the offending vehicle which has caused the accident in question. In addition to the above, Sapyara, the inquest panchanama at Exhibit T2, which was corroborated by the evidence of PW2, would go to show that the panchas to the panchanama have opined that death of Jyoti was due to the injuries sustained by her in the road traffic accident, which is the subject matter of the case. However, the undenied postmortem report at Exhibit P5, after giving the detailed description of the injuries sustained by the deceased Jyoti, aged about 13 years, it is Miss Jyoti, aged about 13 years, notices fractures of the bones of the skull, which according to doctor who conducted autopsy had resulted into several pieces and the fractured ribs have resulted in hemorrhage, and it is the said shock and hemorrhage due to traumatic injury to skull and other parts of the body was the cause for the death of the deceased. He has opined that those injuries are outcome of a road traffic accident. Thus, the evidence of PW1, PW2, PW3, PW5, PW7, corroborated by Exhibit P2, P5, P6. Go to show that on the date, time, and place alleged in the charge, a tanker lorry bearing registration number JJ6TT8342 dashed against Miss Jyoti, a girl aged about 13 years, and caused her death. The remaining question, para, for consideration would be whether the prosecution has, beyond reasonable doubt, proved that it was the accused and accused alone who was the driver of the said alleged offending vehicle, and that it was due to his rash and negligent driving the road traffic accident has occurred, resulting in the death of Mrs. Jyoti. As observed above, none of the witnesses examined by the prosecution have spoken about either the involvement of the accused as the driver of the offending vehicle, nor about the rash and negligent driving of the vehicle. So, in order to prove the alleged rash and negligent driving of a vehicle, either the evidence of eyewitnesses, provided if they are available, can be relied upon primarily, or the circumstantial evidence, if any, if they could prove the alleged rash and negligent driving, can be inferred. In the instant case, as observed above, none of the witnesses have spoken that they were the eyewitnesses to the alleged incident. The fond hope placed upon PW3 by the prosecution also was of no use to prosecution, since the witness did not support the case of prosecution in that regard. The evidence of other witnesses, including the police witnesses, that is PW6 and PW7, nowhere whispers that it was the accused who had committed the accident. Though learned CGP in his argument vehemently submitted that the act of the owner of the vehicle getting the vehicle released itself go to show that the accused engaged by him was the driver of the offending vehicle. But it has to be said that it is only an assumption of the learned HCGP, for the simple reason that neither the documents of the release of the vehicle have been marked as exhibits, nor the alleged owner of the vehicle was examined in the case. Nothing had prevented the investigating officer to examine the owner of the vehicle and to elicit from his mouth as to who was the driver of the offending vehicle at the time of accident. However, to cure the curiosity of the learned HCGP, when the affidavit shown to have been executed by the alleged owner of the vehicle in the trial court while getting the interim custody of the vehicle is perused, it can be only noticed that the alleged owner has spoken about the involvement of his vehicle bearing registration number so and so in the alleged road traffic accident and the death of Miss Jyoti due to the said accident, but nowhere he has whispered as to who was the driver of the said vehicle at the time of accident. Though he has mentioned at more than one place in his affidavit about the driver of the vehicle, but for the reasons best known to him, he has not disclosed the name or identity of the driver of the vehicle. Thus, even the documents pertaining to release of the vehicle for the interim custody of the alleged owner of the vehicle also throws no light in identifying as to who was the driver of the alleged offending vehicle. However, both the trial court as well as the session judges court, going by the statement of PW1 and PW3 to the effect that they came to know the PW1, to the effect that he came to know that it was the accused who has stated, the PW1 who has stated in his evidence that as told to him and shown to him by police, it was the accused who was the driver of the offending vehicle, both the courts landed to an erroneous finding, holding that the prosecution has proved beyond reasonable doubt that it was the accused and accused alone who was the driver of the offending vehicle at the time of accident. By jumping to such a hasty conclusion, both the courts have ignored the fact that even according to PW1, his knowledge about the driver of the alleged offending vehicle was only upon hearsay, and more importantly, according to the information, more importantly, based upon an alleged information said to have been given to him by none else than the police themselves. As such, as a father of the deceased in grief, he has accepted the representation of the police that it was the present accused who was the driver of the alleged offending vehicle, and repeated the same in the court, however, without concealing the fact that his information is, his knowledge is based upon an information given to him by none else than the complainant police. Thus, the finding of the trial court holding the accused guilty, holding the accused as the one, holding the accused as the driver of the alleged offending vehicle, and also hastily holding him as guilty for his alleged rash and negligent driving, for the alleged rash and negligent driving and negligently causing the death of deceased Jyoti. The accused has preferred the present revision petition. Since by the analysis made above, it has been now clearly established that the said finding of both the courts being perverse, has established now that the finding of both the courts are perverse. As such, the impugned judgment warrants interference in the hands of this court, and it has to be necessarily held that the prosecution has failed to prove the alleged guilt against the accused. Accordingly, I proceed to pass the following order. The criminal revision petition stands allowed. So set aside, accused so stands acquitted of the offense punishable under section so. Amicus curiae acknowledge ಮಾಡಿ services honorarium 4,000 rupees ಮಾಡಿ register to transmit record. Yes.
Much obliged.
Serial number 49.
ಕಾನ್ಸೆಪ್ಟ್ ಅವರೇ ಬಹುಶಃ ಇವತ್ತಾಗದ ಡೌಟ್ ಅನ್ಸುತ್ತಲ್ಲ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ this petition has become infructuous for this reason that the petition, the respondent wife has filed domestic violence case against the petitioner husband, and the trial court has passed interim order of maintenance of rupees 10,000,
Against that interim order of maintenance, he filed criminal appeal. That criminal appeal also dismissed. Against that order, criminal revision petition is filed. Now the main matter is itself disposed of in the trial court by order dated 16/4/2018.
Learned. Amicus curiae for the petitioner. And learned amicus curiae for the respondent are physically present. The amicus curiae for the petitioner submits that in view of the fact that the original criminal case from which the present revision petition has arisen itself and been disposed of on its merit by the concerned trial court. The present revision petition has become infructuous. Supporting submission on the similar lines is also made by the amicus curiae for the petition. Learned amicus curiae for the respondent also joins the submission of the learned amicus curiae for the petitioner and submits that if the very petition from which the present impugned order has arisen, though through criminal appeal, as an intermediate stage, comma itself has disposed of the present revision petition does not arise. In view of the remove and the supported submission from both sides, the revision petition stands dismissed as having become infructuous. However, recognizing the efforts put forth by learned amicus curiae from both sides to secure the necessary details and collecting the necessary papers and going through them, their services has to be taken on, recognized on record. As such, as an honorarium, the registry is hereby directed to pay an honorarium of sum of not less than rupees 2,000 to each of the learned amicus curiae at the earliest. Registry to transmit copies of. So, yes. ಮ್ಯಾಟರ್ ಒಂದು ವೀಕ್ ಒಳಗೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ ಒಂದು ಡೇಟ್ ಜಾಸ್ತಿ ಹಾಕೊಳ್ಳಬೇಕು.
Court officer. Court officer. Court officer.
Joint.
Court officer. Ready, sir. Sir, 55, sir. Acharya. Sir, 55. Oh, 55. Acharya. SPP and Acharya. 306. Sir, 14-6, sir. Sir, ಒಂದು 15th ಹಾಕೊಳ್ಳಿ ಸರ್, 14th ಇಲ್ಲ ಸರ್ ದಯವಿಟ್ಟು. ಮತ್ತೆ ಸಾಹೇಬ್ರ ಹತ್ರ ಟೈಮ್ ಕೇಳೋದು 15th ಹಾಕೊಳ್ಳಿ ಸರ್.
ಸಾಹೇಬ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸರ್.
ಅದೇ ಒಂದು 15th ಹಾಕೊಳ್ಳಿ ಸರ್ ದಯವಿಟ್ಟು ಸರ್. ಮತ್ತೆ ನಾನು ಟೈಮ್ ಕೇಳಬೇಕಾಗ ಒಂದೇ ದಿವಸ ಸರ್ 15th ಮಾಡ್ತೀರಾ? 15th ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ 15th ಆಗ್ಬೋದಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್. ಹಾಕೊಡ್ತೇನೆ ನೀನ್ ಸ್ವಿಚ್ ಹಾಕ್ಲಿ ಹಾಕೊಂಡ್ರೆ